Well, y'all made it. All right, so Mr. Ramos, how does this work? You have to click on something to become the interpreter, and then we can select your channel?
Yes, you do. You go to settings and then select where interpreter says. I never done it because I've never been host, but you send me something, a button that it tells me you have been assigned as an interpreter. I click that, and then on the bottom, you know, where the other controls, they say English and Spanish. So as I'm interpreting, I'm clicking English or Spanish.
Okay, and I just enabled interpreter.
Right.
So did you get your invitation?
Not yet. Now it says, now I see that it says English and Spanish interpretation available. So whoever wants to hear the English part clicks on English. Whoever wants to hear Spanish, click on Spanish.
All right, and it shows that you're the interpreter.
I don't see my buttons yet, and I didn't receive that the other button that says you have been assigned as the interpreter.
It says that you're not joined. Did you? Any idea what that means?
No, sir.
Let me share my screen and show you what I'm looking at. All right. All right, so apparently Miss Riley doesn't know that she's supposed to be forwarding these things, but they're not working anyway. Okay. So I'm going to try one more time to screen share, only this time. All right, sir. On the language interpretation, do you see my screen share?
I see that says, notice this document contains sensitive data.
All right, and does it have a little pop-up button on top of it? A pop-up screen that has language interpretation at the top? No.
I see, it says view options. No.
No, it'd be okay. Here they start coming. All right.
Yeah. Now the interpreting thing is gone.
Judge, I need to get my client on very quickly.
All right, and this is not working in any event.
And you did click on where it says the interpretation button, right?
Yes, and it has interpreter 1, Spanish to English, and it says not joined. Okay, did you sign on here with the same email address that you gave me?
Yes.
At H. Ramos?
The same one, yes, sir. Now I see that they're available, English and Spanish interpretation available, but I haven't seen the button that says you have been assigned the interpreter. Because then when I clicked on that, I get 2 buttons on the bottom of my screen that I'm switching, you know, if I'm speaking in English or in Spanish.
Okay, did you
Ah,
get
there
something
it
now?
is. There it is. Yes.
Apparently, because I can't hear you. You go back to English. Go ahead. Okay, but. Right. I cannot hear you now. Okay, I'll be back in about 5 minutes. Let me make Miss Riley the host in case she needs to admit people or something.
Lori, you are efficient. Just wanted you to know.
That
Wow.
what?
You are efficient.
Oh.
Wanted you to know. I would have been going, yeah.
I was
job.
doing that a little bit. I'm still trying to find some people I haven't sent the email,
gotcha.
the invite to that I didn't have there.
Well,
Have
great
it up, yeah.
job. Great job.
Thank you. I appreciate it.
Sí, lo escucho.
Yes, and my client is here. Yes. Uh-huh. Sí, sí lo escucho. Está bien.
Okay, I'm back. Is everybody present who needs to be here?
I believe so, Your Honor.
All right.
Mr.
Yes, Your Honor.
Renee and his client are here. We just don't see Mr. Flores. There he
Thank you.
is.
There he is. All right, and let me ask, are there pleadings I need to look at?
Just a motion for, to modify, Your Honor. It's just a short.
There,
paragraph.
there are initial pleadings, Your Honor, alleging drug use in this case, and that was filed in the original petition.
Okay. All right, and Mr. Ramos was sworn in previously, and I have to say that I've never actually used the interpreter feature because typically it's just easier not to, because if we're doing a plea or something where the judge is talking to the interpreter, we don't need that. So I see that Mr. Ramos is speaking. I can't hear him because I have selected the English channel. Do both of your clients have the Spanish channel selected?
My client does, Your Honor.
Yes, Your Honor.
Okay. All right, so let me go ahead and swear in the parties. Let me ask the two parties to raise their right hands. Right. Do each of you swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Sí.
Sí.
All right. Thank you. And
Your Honor, I think there may be the respondent might have a second witness. I don't know if she was sworn in. I don't see her. But I know it's kind of weird doing it through Zoom. At this point, I would invoke the rule as much as possible.
okay.
There are no witnesses in this Zoom at this time, Your Honor.
Okay, all right, so. All right, so Mr. Flores, it's your motion.
Good. Okay, Your Honor.
All right, go ahead.
Your Honor, basically, this is, and I apologize, we erroneously put matter of the marriage. It's not a marriage on the motion to modify. It's a SAPSER. My client is the father of the child, was living with the child for about 9 years, and 9.5 years. And the mother left, moved from where he lives in Kennedy, Texas, to San Antonio. We have initiated this proceeding in order to basically exercise, get his rights as the father. There were some allegations made, quite frankly, about this case, about my client, about drug use. So we had agreed that he would have supervised visitation until he could test clean. He did test clean back in December. So they did agree to allow him some unsupervised visitation on Christmas, but since then he has not been allowed. And so we are basically moving to be allowed unsupervised visitation, and specifically standard visitation. And that's basically what we're here for, Your Honor.
Yes,
Your
ma'am.
Honor, just very quickly, this case had already been filed last year, and it was filed on July 9th, 2020. In our counter petition, we were alleging illicit drugs and alcohol use. There was an agreement, it is correct, by the parties where Mr. Flores' client did admit to having drug use, and he would wait to take the drug test, so he agreed to supervise. Now, during Christmas, after Mr. Flores' client finally tested for drugs, it was clean. There was no change in order. Mr. Flores never came back to change anything. That was the agreement that we would come back and change it. Mr. Flores did not. Subsequently, my client, still wanting to maintain relationship with his child and the father, allowed the father to do that for one overnight. It was on the 25th and I believe on the 26th. Unfortunately, Your Honor, we have a witness that will testify that the father was drinking with his friends, took the child to a restaurant, continued to drink in front of the child, was in a vehicle with the child drinking a beer as he was driving. Another incident occurred on December 31st, the same issue. Father was intoxicated, went to Alice, Texas to look for the mother and child and demanded possession when he knew, in fact, there was an existing order that required him to only have supervised. So, Your Honor, at this time, we're asking that we move forward to final hearing in March, early March, that Mr. Flores' client not be allowed to have unsupervised at this time because of his continued alcohol use, although his drug test did test clean.
Okay. All right, sir. Mr. Flores, your first witness.
Yes, Your Honor. I would call my client, Juan Aguirre, to stand.
All right.
Go
Go ahead.
He's already sworn in. Mr. Aguirre, please state your name for the record.
Juan Aguirre Lopez.
And you are the father of the child in question. Here.
All right, Mr.
Sí.
Flores, you're breaking up.
Sorry, Your Honor. Okay. And you tell me about your relationship with the child. How long have you lived with the child before?
9 años y medio.
Can you hear me? Hello? Could you repeat that, please?
Mr. Ramos, we
9
can,
años y medio.
Okay. And
Judge, I'm not hearing
so
the
okay.
answer.
All right. Did you hear Mr.
Um,
Ramos's interpretation or the answer from Mr. Aguirre?
No, sir.
I did not hear the interpretation. I think because I had it off. Your
Okay. Have everyone needs to, I
and-
believe everyone needs to go to interpretation and select the English or Spanish channel. So make sure you've done that.
Yep.
All
So
right. I mean, hold on. Hold
well,
on.
how would you describe your relationship?
Mr. Flores, hold on.
Yes.
All right, Mr. Ramos, just say something on the English channel, please, so we can make sure that the interpreter is, I mean, that the reporter's hearing it.
I hear it in English.
Judge, I see it on here.
There's also another button, Judge, under the English Spanish. It says unmute original audio. That,
Okay, mine says mute. Let me try that. I don't know if that would help.
for her, maybe she needs to unmute.
Yes, that makes sense. All right, Miss.
Mine says mute.
Okay. So hit
Original.
it. So hit it. And then see if you can hear Mr. Ramos.
Okay, Mr. Ramos? No.
Okay. All right, I guess let's. Lachey, have you selected a language?
Yes, English.
Hmm.
Unmute original audio. You need me to do that?
Try it both ways.
Okay. Mr. Ramos? Alexa, stop.
Alexa, stop.
I don't hear anything.
All right. All right, that's as good as anything. Ms. Cavazos, if you try to log out and then log back in, if that doesn't work, we'll just not use the interpreter channels.
Okay, so leave.
Yes, I would, that's as good as anything, I think.
Okay, I'll sign off and sign back on.
She signed on twice. She signs on two different computers, and one of them is just the sound. Oh, you know what? I bet you that's the problem. I bet you she's watching on one computer, she's talking on the other one, and she doesn't have the interpretation selected. Talking on. She's got to set that one. All right. Now, why didn't you say that 5 seconds before? She'll log back in. Yeah. Yes. Oh, okay. Makes sense.
Okay.
Okay.
Well. My phone rang. All right, Lachey, I think Mr. Ramos figured out the issue. You have two different electronic devices and you speak on one and look on the other. Do you have the one that you speak on set to interpretation in English?
Okay, let's try that. I can hear.
Okay,
Sorry,
all
Judge.
right. I think Mr. Flores had the floor. Go ahead, sir.
Yes, so can you describe your relationship with your son, Mr. Aguirre?
Sí. La relación entre yo y mi hijo está bien. Él no se invoca como a que no verme o que yo lo trato mal
Is it a
o
close
cualquier cosa.
relationship?
No es
Okay, and
nada de eso.
Mr. Flores, I think you were speaking on Mr. Ramos, overstepping on Mr. Ramos' act. If not, I missed something. Go ahead, sir.
Okay, where are we? Is he done with the interpretation? Okay. Do you have a close relationship with your son, Mr. Aguirre?
Sí,
Okay, he has known you as your father since his birth.
sí.
All right, and let me interrupt for a moment because this is temporary orders and not arguing on the merits.
Mhm.
And then Ms. Rossmore, let me ask you, if there was no drug and alcohol component at all in Mr. Aguirre's behavior, would you be in agreement that he'd be entitled to standard visitation?
Definitely, Your Honor, definitely.
All right. So Mr. Flores, I'm not doubting that the concern I have right now would be the drug and alcohol component. So go ahead, sir.
So, you have had an issue, you have taken illicit drugs in the past, correct, Mr. Aguirre?
Sí.
When was the last time you used, what's your illicit drug of choice? What illicit drug do you use? Have you used?
Coca.
And when's the last time?
Flores,
When's the last time you used coke? When was the last time you used coke?
En junio.
Okay. And have you used cocaine since then?
No.
In fact, you took a drug test back in December to
Sí.
and in that drug test, you came out negative. Is that correct?
Sí.
And Your Honor, I'm not very good at this, but I'm going to try to share this on the screen.
Go ahead.
Your Honor, I would object to him sharing anything unless he's letting us know what it is he's sharing so that I know whether or not I have an objection.
All right, Mr. Flores?
Your Honor, it's the test results that I've already forwarded to opposing counsel, and she has indicated to me she did not have an objection to it.
That is correct. No objection to that item.
All right, go ahead, sir.
Let me just see, share screen. You have to bear with me. Like I said, Your Honor, first time I've ever done this. Okay, these are the results of your test, Mr. Aguirre.
We're not seeing
Sí.
it.
All we see is your directory for Juan Aguirre.
Okay, my computer says you are screen sharing. I don't know.
You're screen sharing, but what we see is your directory for your privately retained client, Juan Aguirre.
Okay.
Voice,
Let me-
letter, motion, to modify.
Click it twice,
Okay.
Mr. Flores.
Sorry, Your Honor, like I said. Pardon me?
Click it twice.
Again, Mr. Flores, I think the other side is stipulating that your client was clean on this drug test.
Okay, Your Honor. I don't know if the court wanted to see it. And I'm trying to get back to Zoom now. I do apologize, Your Honor. Like I said, it's the first time I've done this.
Oh, that's fine.
What the sharing.
And your audio is breaking up, sir.
All right, I'm back. Okay. Okay. All right. So, all right. So anyway, so you tested negative on that, correct? On the drug test?
Sí,
And that was a 10-panel test that tested you for 10 different drugs. Is that correct?
sí,
And that included cocaine. Is that correct?
sí,
Okay. Can y'all see me sharing the document now or no?
Yes.
Okay, good. And so I offer that as Exhibit 1, Your Honor.
No objection.
Without objection, movements exhibit 1 is admitted into evidence.
Stop sharing. Okay, I'm back. All right. You have exercised, when have you exercised visitation of your son?
Flores, you're breaking up.
You remember back in August, we came, we had a hearing. Okay.
Mr.
You remember
Flores?
back in August?
All right, Mr. Flores, I've muted you.
Oh.
Okay. Your voice is breaking up. So let me ask you to start over on that question.
Okay. Mr. Aguirre, you recall that back in August, we made an agreement with the opposing side with regard to visitation being supervised.
sí,
And have you exercised, and that basically that agreement was to visit your son 2 hours a day on Saturday.
sí,
And have you been exercising that visitation?
sí, unas veces no pude ir.
Okay. And I know that
Breaking up, sir.
that me or the interpreter?
No, sir, you disappeared. We did not hear your question and your video went away for a while too.
Okay. Okay, you did not exercise visitation in January nor in so far in February. Is that correct?
No,
Can you hear me? And why is that?
porque yo no me siento a gusto que esté ella ahí, porque un rato lo manda que vaya por un agua, un rato vaya que cargue el teléfono o cualquier cosa, pretexto, para que se pierda como la conversación conmigo y él. Ya eso no, para mí no estoy a gusto, no estoy conforme.
Do you feel she's interfering in your visitation?
Objection, leading the witness.
For temporary orders, I'll overrule that objection.
Do you feel she's interfering with the visitation?
Sí,
Okay, now there's an allegation that back on Christmas, that they agreed to allow you overnight visitation for the first time. Is that correct?
sí,
Okay. And there's an allegation that you were drinking when you picked up the child.
cuando,
Were you drinking?
okay.
Were you drinking when you picked up the child?
No,
Were you intoxicated in any manner when you picked up the child on Christmas?
No,
You picked him up on the you picked him up on the, okay. You picked him up on the 24th or 25th?
el 24 en la tarde.
And you brought him back the next day?
Sí, el 25 a las 12.
And there's also an allegation that you tried to pick up the child on the 31st in Alice. Is that true?
¿En Dallas? ¿En Dallas?
Excuse me, in Alice.
Yo fui simplemente como a hacer un reporte de policía porque ella me estaba diciendo que el niño se había enfermado por mi culpa y ella lo traía en el aire. Yo nomás simplemente quise hacer un reporte como de policía para tener como una excusa de que ella lo tenía ya.
Did you try to pick up the child in Alice?
No. Yo fui nomás a hacer el reporte. Yo al niño ni lo miré.
There's also an indication that you are behind on child support. Is that correct?
Sí, le debo de enero y febrero.
And why have you not paid the child support for those months?
Porque yo a ella le había dicho, en vez si me atrasaba 2, 3 días, una semana, y yo le decía que se lo podía enviar por correo y ella me dijo que no quería que le enviara las cosas por correo, que cuando yo fuera se lo diera a ella.
And had you, before January, had you been paying your child support?
Sí,
If the court grants you standard visitation, do you understand you must remain sober during that visitation period?
sí,
Will you abstain from any illegal drug use from here on out?
sí,
And are you willing to not drink during the time period that you have the child?
sí.
I pass the witness, Your Honor.
Go ahead, ma'am.
Mr. Aguirre, first of all, you owe the mother $2,990 in child support. Is that correct?
2,900, son 2 meses nomás.
Okay, so you only owe her 2 months. Is that what you're saying?
Sí, sí,
Okay. Now, in the child support order, isn't it true that it says you make payments directly to the mother?
sí, yo se los he pagado a ella.
But in the order, it says directly to the mother, does it not?
Sí,
Okay. Now, where do you live, Mr. Aguirre?
en Ronge, en Kennedy,
And how far is Kennedy from Alice, Texas?
como hora y media.
So you're telling this court that you drove all the way to Alice, Texas to file a police report because your son was sick?
Porque ella me echó la culpa a mí, que en Navidad se puso enfermo por mi culpa. Y yo cuando lo llevé al niño estaba bien. Yo nomás quería hacer como un reporte para saber que ella también lo trae afuera. Para que a mí no como me esté culpando a mí.
Mr. Aguirre, you understand you can pick up the telephone and make a police report from your residence. Do you understand that?
No sabía.
No, sir, you understand that we have witnesses that put you in Alice, Texas, at the location where their mother and the child were. Do you understand that?
Jack, I'm gonna object, Your Honor, that she's presenting witnesses that are not even here to testify.
Your Honor, this is very relevant to his allegation that he never approached mother at the residence with the child.
I'll overrule the objection.
You can answer the question, Mr. Aguirre. Do you understand that there are witnesses that see you at the location with the mother and the child in Alice?
Sí. La mamá sí la miré, el hijo nunca lo miré.
So now you did go to the mother where the mother was, correct?
Fui ahí y ella llegó a la casa de los, son compadres, ahí llegó la mamá.
So you didn't just go to Alice to go file a police report, did you?
Nomás eso fui.
Now, Mr. Aguirre, you say that you've missed several visits with your son since temporary orders. Do you remember how many?
4, 5.
Would you be surprised to know that it was about 15 visits that you've missed since we entered into an agreement on August 6, 2020?
¿Sí? 15.
That is correct, sir. Would that surprise you?
Sí, porque ¿cuáles 15 veces?
Well, let's talk about that very quickly. In August, do you know that you missed one visit in August of 2020?
Okay.
And one visit in September and 2 in October.
Okay.
2 in November, 3 in December.
En diciembre.
3 in December. Are you aware of that?
No, 3 veces.
Okay, and 5 in January, 1 in February. Are you aware of that?
Sí, de diciembre para acá no es cuando no ha ido.
Okay, so when you tell the court that you've only missed a few, it's more than just a few, isn't it true, Mr. Aguirre?
Sí,
But the times that you have visited your son, supervised for 2 hours, you've had no issues with mother, have you?
sí, de que lo manda a hacer cualquier cosa para distraerlo, o me manda a otro lugar para más lejos, porque las visitas quedamos que eran en su casa.
But did you
Me
ever
cambia
bring
la
those
dirección distinta,
allegations to your
que
attorney?
tengo que ir a dejarlo en un parque, o ir a
Objection.
levantarlo fuera de otro
Non-responsive.
lugar.
Overrule the objection. And there was a follow-up question that I don't believe that the interpreter had a chance to.
Okay. May I continue, Your Honor?
Yes,
Okay, Mr. Aguirre, you understand that the supervision was to be with mother or her brother, is that correct?
Sí, sí,
And supervision was with mother or her brother, is that correct?
sí,
And you agreed to that, is that correct?
sí.
Now, Mr. Aguirre, let's talk about your alcohol use. When you picked up your son on December, I believe it was December 24th, when your attorney, after your test and you picked up your son, do you recall that?
Okay, now, stop.
Sí.
I'm going to order that, well, I'll allow that question to be answered.
Okay.
All right, Mr. Aguirre, I believe that the other attorney is going to ask you questions that might tend to show you have committed a crime. It is a felony in Texas to operate a motor vehicle while you're intoxicated with a child younger than 14 years of age or in your vehicle. And intoxicated does not mean drunk. By that I mean to be intoxicated for driving while intoxicated, you have to have consumed enough alcohol that you do not have the normal use of your mental faculties or your physical faculties. Now, you have the right under the Constitution to not answer any questions that might tend to show you've committed a felony or a crime, rather. A couple of things I need to add to that. In a criminal case, the defendant does not have to answer questions, and the judge or the jury cannot hold that against the defendant. They cannot consider it for any reason. This is a civil case. In a civil case, if a person says they will not answer a question because it may tend to show they committed a crime, the judge or the jury, there's no jury, can consider that. And they can decide that the witness did not answer the question because they did commit that crime. The last thing I need to tell you is you have to either refuse to answer questions that might tend to show you committed a crime, or you have to answer them. You can't answer a few questions that might tend to show you committed a crime and then say, I don't want to answer anymore. So have you had a chance to discuss this issue with your attorney, Mr. Flores?
Sí.
Okay. All right. And counsel, have you had sufficient opportunity to discuss this with your client?
Your Honor, I don't feel like it's an issue. We have discussed what happened. If I felt like he was going to incriminate himself, I certainly
all I wanted, I just want to make sure that he understands he has rights, and so you're saying he wants to waive any right against self-incrimination and answer the questions.
I mean, if it pleases the court, I guess I can have a brief conference with him, but I don't believe it's an issue in this case. I know he's already told me he wasn't intoxicated, and I know it's a standard that's kind of fuzzy, because it's for a jury to decide really. But I don't believe he was drinking at the time. But
okay, and that's fine. Okay, I'm going to send both of you to breakout room number 5. And I'll ask you to meet with Mr. Aguirre there.
Okay, thank you, Your Honor.
And Mr. Aguirre, you should have received a little blue box. Oh, you've got it? Okay, at the bottom, please click on that.
I haven't gotten it. I haven't gotten the invitation, Your Honor.
Okay, for some reason, it had already set this up
I got the invitation.
Well, nobody else needs to take one. It automatically assigned. The breakout rooms had already been assigned. I opened a new one and sent those to there.
Sí.
Judge, Mr. Renee says that he's done in the breakout room. I don't know why they can't get back into the main room.
All right, I'm closing them down.
Okay.
Okay, we're back on the record. Mr. Flores, did you have an
Excuse me,
opportunity?
Your Honor, I don't see my client.
He's
Oh,
here.
sorry, I didn't mean to interrupt. Oh, here, okay.
Okay. Did you have an opportunity to discuss this matter with your client?
Yes, Your Honor.
Okay, and is he going to answer questions? He's going to stand on his rights against self-incrimination.
He's gonna answer questions. Your Honor.
All right, go ahead, ma'am.
All right, Mr. Aguirre, you understand how important it is not to do drugs or drink alcohol in the presence of children. Do you understand the importance, Mr. Aguirre?
He's muted. Let me go and mute him, or, sorry.
Okay, I'm asking him to unmute. Go ahead if you need to.
Okay, he's ready.
May I proceed, Your Honor?
No. Okay, Mr. Flores, I just heard an echo. Did you change something? Because a moment ago, earlier this morning, when Mr. Aguirre was speaking, I did not hear any echo. And when you spoke just now, I heard this sort of echo that shows that your speakers on the two computers are too close to each other.
We're in separate rooms, Your Honor. There's a wall. The doors are closed. Let me try to move a little bit.
All right, and I'm not hearing it right now. I don't know if somebody had the door open or what, but it sounds fine now. Because I can tell you that if one computer can hear the other one, nobody else can hear anything. You just get feedback. All right, go ahead, ma'am.
Now, Mr. Aguirre, do you understand the importance of not doing cocaine and drinking alcohol in the presence of your son?
No se escucha.
Says he can't hear. Let me make sure it's on the right language, Your Honor. I'm sorry.
All right, Mr. Flores, you may need to reselect the interpretation feature. I don't know.
Yes, Your Honor. Let me go check.
Sí.
Okay, he's ready.
Go ahead, ma'am.
Mr. Aguirre, can you hear me now?
Sí.
Okay. do you understand the importance of not taking or doing cocaine and drinking alcohol in front of your son?
Sí,
Do you understand the importance of not driving while you're drinking alcohol? Do you understand that?
sí,
Now, during the relationship with Ms. Magana, you've had problems with drug use and alcohol, haven't you?
no.
So you think it's
No,
normal for
sorry.
people to smoke cocaine or to do cocaine?
Sí,
Okay, so I want to make it very clear to this court. You think it's normal for people to do cocaine?
no, sé que no es normal.
Okay, so you told this court in a previous hearing and when we came to an agreement that you were doing cocaine. Do you think that's normal?
Antes. Y nomás la he probado 1 o 2 veces. Yo nunca, no soy adicto, no soy.
So tell me, sir, why is it that your wife found all the paraphernalia for crack cocaine in your home and that's why you separated?
No, si no nos separamos por eso.
Okay. All right, sir. So let me just make sure that I understand. You picked up your son on unsupervised visits. Since August, it was supervised. December, you took a test, and then you had unsupervised. Is that correct?
Sí.
When you picked up your son, did you happen to go to the Agave restaurant for dinner with friends and your son?
No, el 24 de la tarde cerramos todos los restaurantes. Estaban cerrados el 24 en la tarde.
Did you go to a restaurant on the 24th or the 25th called Agave with your son and friends?
No. Lo llevé, de pasada llegamos a comer a
Did you not
McDonald's.
go with your friends, Miss? Okay. You never went to Agave restaurant?
You know, I'm gonna object. She keeps,
Sí,
it's been asked
llegué ahí
and
porque
answered.
yo trabajo ahí.
Overruled.
Okay. You work at Agave restaurant, correct?
Sí,
Did you take your son to Agave restaurant when you had him either on the 24th or the 25th? Yes or no?
no,
Okay. Sir, isn't it true that you went to the Agave restaurant and you were drinking with your friends and your son was there with you?
no,
Isn't it true, sir, that you got in the vehicle to take your son home and you were drinking a beer and your son was in the vehicle? Is that not true?
no. Ni el 24 ni el 25 tomé.
Now, sir, can you tell this court, when is it that you allege you drink? Do you drink at all?
Cerveza,
Alcohol, sir.
alcohol, sí.
Okay, so you drink hard liquor and beer? What's your choice?
You know, I'm gonna
No.
object to the relevance. I mean, this is not illegal. They're drinking beer, drinking liquor. I mean, he's already testified that he didn't drink at the time that he had the child. What's the relevance of this?
I'll overrule the objection.
So what's your alcohol of choice, Mr. Aguirre?
Cerveza,
Okay. Have you drank any, well, okay, and Your Honor, I'll pass a witness.
Go ahead, sir.
Um, I don't have any more questions, Your Honor.
All right, your next witness?
That's all I'll call the respondent, to testify, Your Honor.
Go ahead.
At this point, I'll call Nelly Magana to testify. Nayeli Magana.
Go ahead.
Okay, Ms. Magana. You are the mother of the child in question, Christian Aguirre, correct?
Sí, correcto.
And what is your problem with allowing Mr. Aguirre having visitation, unsupervised visitation?
Yo no tenía ningún problema que él viera y conviviera con su padre, pero si él está en alcohol o drogas, o sea, yo es mi único problema, que él esté en sus 5 sentidos y trate bien a mi hijo.
So, as far as you know, he hasn't used illegal drugs since June, correct?
I would object to speculation, Your Honor, whether she knows unless she has personal knowledge.
As far as she knows.
The question is about her knowledge, so I'll overrule it.
Yo no sé porque ya no vivo con él.
You have no reason to believe that he has been using illegal drugs since June, correct?
No lo sé.
And is it your testimony that he was intoxicated when he picked up the child on the 24th?
El 24, cuando él se llevó a mi hijo, cuando él me lo regresó, a mi hijo me dijo, mamá, mi papi estuvo manejando conmigo, estando
Object
tomado.
is hearsay, Your Honor. It's a hearsay response.
Okay, what was the question?
The question was, are you alleging, it was a yes or no question, are you alleging he was intoxicated when he picked up the child on the 24th?
I'll sustain that objection.
Are you alleging that the child, Mr. Aguirre was intoxicated when he picked up the child on the 24th?
No escucho, perdón.
Didn't hear me or didn't hear her? Didn't hear you. In fact, Mr.
Al
Aguirre,
intérprete.
I'll re-ask it. In fact, you don't know if he was intoxicated on the 24th, do you?
No.
Okay. And you don't know if he was intoxicated when he had the child on the 25th either, do you?
No, yo no lo vi, mi hijo me dijo.
Again, Your Honor, object the response hearsay.
Sustain it.
And is it your testimony that he tried to pick up your son on the 31st?
Sí,
Okay. And where were you at that time?
en Alice, Texas.
Whereabouts in Alice, Texas?
En la casa de mis compadres.
Okay. And somehow he found out you were there?
No sé cómo supo.
And Did he take your son on the 31st?
No, yo días antes le mandé un mensaje que su hijo estuvo en el hospital en Corpus. So me dijo que eran mentiras mías y de mi hijo que estaba enfermo. Yo pedí copias en el hospital del expediente. Yo no tenía mueble para llevar a mi hijo, so me llevaron al hospital. Yo por eso estaba en Alice, Texas. A él no le tocaba visita. Él tuvo a su hijo en Navidad y a mí me tocaba en Año Nuevo. Él no fue a visitar a su hijo al hospital. Yo le mandé textos donde le hice saber que su hijo estaba enfermo y no fue. Y le hice saber todo lo que le habían hecho a su hijo. Yo me estuve en Alice, Texas, hasta que pudieron traerme a San Antonio de vuelta. Quiero agregar algo más. Yo llevo a mi hijo con sus especialistas a Corpus porque no he podido cambiar sus especialistas aquí a San Antonio porque el papá del niño me ha dicho que él no ha estado pagando a Medicaid.
Okay, so Mr. Aguirre, besides your drinking and drug issue,
Objection, Your Honor. I
do you
thought
have
he
a
was
problem with
questioning.
him,
Objection.
him,
Okay, Mr. Flores, hold on. What's the objection?
Well, Your Honor, I thought he was questioning Ms. Magana.
Yes, sir. Are you changing witnesses, sir?
Yes, he is. He's asking Mr. Aguirre a question.
I'm sorry, I'm asking Mr. Magana. Ms. Magana, sorry.
Okay, go ahead.
Okay.
Ms. Magana, besides your drinking and drug issues, you don't think Mr. Aguirre is a bad father, do you?
No.
If the court would order that he not drink or do drugs during the time he has custody of your child, you would be okay with him going with his father overnight. Is that correct?
Sí, claro, con medidas porque mi hijo toma medicamentos y yo siempre lo que le he pedido, que sea responsable y que me lo cuide bien porque me lo entregó enfermo en Navidad.
And you have confidence that if he was violating that order, your son would tell you, correct?
Correcto.
I pass the witness.
Ms. Magana, if I may, Your Honor. Ms. Magana, when Mr. Flores just asked you that if there was a violation of an order that your son would tell you, and when your son was picked up by his father, your son did tell you there was a violation, didn't he?
No, Jack, it calls for hearsay, Your Honor.
Correcto.
Your Honor,
Overruled.
thank you. So your son informed you that father was drinking and driving, didn't he?
Same objection, Your Honor.
Correct.
Overruled.
So Ms. Magana, Mr. Aguirre hasn't followed the court order as to child support or health insurance, has he?
Correcto.
Do you honestly believe that he's going to follow a court order that simply says don't drink, don't do drugs?
No creo, porque siempre ha tomado desde que estamos juntos.
Now, you heard Mr. Aguirre say that he's only done cocaine once. Do you recall that?
I don't object, Your Honor. That's misleading. He didn't say that.
I believe that was his testimony, Judge, that it was one time that he did cocaine.
He said a couple of times.
My recollection was that he said he was not addicted, but that he did not restrict it to one use.
Oh, okay.
Well, sustain the objection.
Ms. Magana, what exactly did you find in the residence before you and Mr. Aguirre separated that regarded drug use?
Encontré cocaína en su pantalón. en su pantalón.
Did this concern you regarding the safety of your son?
Demasiado.
Now, Miss Magana, you understand that there was a court agreement that he would have supervision with your son until he got a drug test, correct?
Correcto.
What concerns you about him waiting about 4 months to get a drug test finally? What concerns you about that behavior?
Me preocupaba que en ese tiempo, o sea, él se iba a limpiar, él iba a tener el tiempo necesario para limpiarse y que su test saliera negativo.
Tell me what happened in Alice. Mr. Aguirre initially told the court that he only went over there to make a police report. Do you recall that?
Sí, claro.
Tell me what happened when he approached you and your son.
Él me llamó por teléfono y me dijo que si le daba permiso de ver a su hijo. Yo le dije que no era día de su visita, pero que yo estaba de acuerdo en que solo lo viera. Él me volvió a llamar, habíamos quedado que yo estaba consciente de que lo iba a dejar verlo. Me volvió a llamar y me dijo que estaba en la casa de mis compadres esperándome porque nos iba a hacer un reporte de policía. Yo le pregunté que si, ¿qué reporte iba a hacer? Claro que sí. En la segunda llamada, él me dijo que estaba en la casa de nuestros compadres esperándome porque iba a llamar a la policía para hacernos un reporte. Yo le pregunté que sí, qué clase de reporte, porque no le tocaba visita con su hijo. Y él me dijo que porque no se lo permitía y que quería tomarme una foto a mí y a mi hijo, no sé para qué la quería, y que nos tenía una sorpresa. Ahí, cuando estábamos ahí, dijo que tenía una sorpresa. Yo me presenté en la casa de mis compadres, llevé a mi hijo iba conmigo, pero mi
Your
hijo...
Honor, I'm gonna object to the responsiveness and to the narrative, the fact that it's a narrative.
I'll sustain the objection.
Now, Ms. Magana, please be just answer my question, okay?
Sí, está bien.
Okay. Now, when Mr. Aguirre arrived at the house, what was his behavior? And was he intoxicated?
Sí, traía alcohol y se mostraba agresivo con nosotros.
What was he holding in his hand, if anything?
Un vaso con alcohol.
And how do you know it was alcohol?
Porque olía y él, o sea, en su vaso era refresco él traía su vaso con tequila, con alcohol, y él había dicho que se lo había servido ahí.
Now, Ms. Magana, did he attempt to take your son at that time in Alice?
Sí, él lo quería ver y después se lo quería llevar.
Did you allow him to see your son?
No, mi hijo no se quiso, mi hijo laqueó la camioneta donde veníamos porque le tuvo miedo porque su papá se estaba mostrando agresivo.
Now, when you talk about this surprise, did you file a police report after Mr. Aguirre told you he had a surprise for you?
Ahí todos escuchamos y yo le comenté a la policía que estaba ahí. Ellos escucharon y ellos anotaron, no sé si en el reporte quedó lo de la sorpresa, pero ellos supieron de eso.
What concerned you when Mr. Aguirre said he had a surprise for you? What concerned you about that?
Pues me preocupó en el sentido de que no fue específico, no sé a qué se refería con tipo de sorpresa, y porque tomó fotos de la casa donde estábamos y de los vehículos.
Did it concern you that he had alcohol in his breath and he was drinking at that location?
Sí, claro.
Now, after he left, did he get in the vehicle and drive, or did somebody drive him away?
Él se fue manejando.
And you heard earlier that he lives an hour and a half away. You heard that, correct?
Sí, eso nos había dicho a nosotros, pero después le dijo a mi niño que él ya no vive ahí. Eso no sabemos.
So you don't know right now where he lives?
No.
Does it concern you, Ms. Aguirre, if this court allows Ms. Magana, if this court allows Mr. Aguirre to have possession of your son, do you believe he'll continue to drink like he showed you in December?
Sí, correcto, porque yo estuve accesible el 24 de que conviviera con su hijo y no hizo las cosas como habíamos acordado.
And he actually drank when he had possession of your son the first time that he was unsupervised. Is that correct?
Turner, I'm gonna object to leading her own
Correcto.
client.
And again, for the purpose of, all right. For the purpose of this being a temporary orders, I will overrule the objection. Go ahead.
That is all I have for this witness, Your Honor.
Okay, Mr. Flores?
Yes, Your Honor. Ms. Magana, your testimony is that when he tried to pick up your child and Alice, he had been served the alcohol there at the function, the get-together you were at, correct?
No teníamos fiesta. Él llegó y él no sé si traía botellas en su... Cuando él se bajó, él traía el vaso con alcohol, pero su aliento nos daba alcohol, nos daba el aliento alcohol.
Okay, so you didn't see him drink in the car.
Ahí en nuestra presencia traía el vaso, estaba tomando ahí. Por eso yo no dejé bajar a mi hijo.
Okay. So, but you didn't see him drinking and driving, correct?
Sí, ahí se fue manejando tomado.
You don't know for sure if he was drunk, correct?
Pues estaba tomando alcohol y olía alcohol. Yo no sé a qué grado, pero estaba alcoholizado.
You don't know how many drinks he had, correct?
No, claro que no.
And Mr. Aguirre, he's a pretty big man, isn't he?
Sí, claro.
What is he, about 6 feet maybe?
Tal vez, no sé exactamente.
What does he weigh? At least a couple, 200 pounds or so?
Tal vez.
After he left that party and Alice, you called the police?
En ese momento llegó la policía porque él se estaba mostrando agresivo con mi compadre.
You said he was being aggressive. Did he forcibly try to take Christian, your son?
¿Sí?
You mean he physically tried to take Christian?
Sí. Él quería,
So he got to Christian and tried to pull him away.
Él quería verlo al principio y después me estaba exigiendo llevárselo y yo le dije que no era su visita y que no se lo iba a permitir y menos en el estado en el que estaba. De hecho, las personas de ahí también le pidieron que se controlara y que no hiciera problemas en su hogar.
So he didn't actually get to see his son at that time, correct?
No,
And on the 24th, when he went to go pick up your son, I'm not clear. What are you saying? He was intoxicated or not intoxicated? I thought you said he wasn't intoxicated.
el 24 él se lo llevó y mi hijo fue el que me dijo que su papá estaba tomando cerveza que traía en su camioneta, lo había llevado a un
So-
restaurante a saludar amigos y él estuvo manejando con cervezas en su camioneta.
So you found out about this after he brought Christian back, correct?
El 25, correcto.
I pass the witness, Your Honor.
Just one question, one or two. How old is Christian, Ms. Magana?
10 años.
And just one more, Judge. Ms. Magana, in your opinion, does it matter how big a man is? Does that give him the right to drink and drive?
Your Honor, I'm gonna object.
No.
Okay, and what's the objection, sir?
Never mind, Your Honor. I'll withdraw it.
Go ahead.
So again, the size of a man, does it still give him the right to drink and drive? Drink and drive?
No.
Are you concerned about your son's safety?
Sí.
I have nothing further, Your Honor.
Anything else, Mr. Flores?
Yeah, I'd like to briefly call my client because there was an issue raised as to where my client was living, and I think it would help the court in making its determination.
Well, do you have any other witnesses or just your client?
No, Your Honor.
Okay, just very briefly, go ahead.
Yeah, yes, Your Honor. Mr. Aguirre, can you tell us where you live?
En Ronge, Texas.
Okay, is that in Karnes County?
Sí.
And do you live in a house? Do you live in an apartment? What kind of place do you live in?
Casa.
Okay. And how many bedrooms does it have?
3.
And who lives in that house?
Yo y mi esposa.
Oh. Okay. When did you get married?
Agosto.
All right. And it's just you and your wife that live in that house then?
Sí.
I pass the witness now.
Just one question.
Go ahead.
Mr. Aguirre, didn't you tell the court earlier that you lived in another place before Ronge, Texas?
No. Vivía en Kennedy y de Kennedy me moví para Ronge y de Ronge yo ahí estaba teniendo diario mi dirección.
Okay, so how long have you been in Ronge?
Sí. 6 meses.
Okay, nothing further, Your Honor.
All right, so do you rest, Mr. Flores?
Yes, Your Honor.
All right. Any other witnesses?
No witnesses for me, Your Honor. I rest as well.
So was there any kind of report made by the police in Alice or the sheriff's office?
There was, Your Honor, and I did send that to Mr. Flores. She did testify about that report and that she made the report. We do have the report, but I believe Mr. Flores was going to object to that being admitted And
Okay, and did Mr. Aguirre have a report made?
he
Yes, Your Honor.
did. He did, but Mr. Flores said he didn't want to send to me. That it was.
All the report said is what he testified to, that it was an issue. There was an issue with him supposedly making the child sick, leaving him out in the cold, and he was denying it. And the report that she presented to me, all it was her saying that my client had been drinking, and when he came over to where she was at in Alice and tried to take the child. So, I mean, everything's been pretty much been testified to, Your Honor.
And in the report as well, Your Honor, there is indication where my client did let the police know that Mr. Aguirre had indicated that he had a surprise for her, and that concerned her. That is also in that report.
All right. Argument?
Your Honor, I can understand the concern if my client was, there's any evidence that he was still doing illegal drugs, particularly in front of the child. There's no evidence of that. He has freely admitted that he was doing it back in June. He's tested since then. I presented that 10-panel test to the court. He's been negative. He's been trying to stay clean, and he has been clean. He denied being drinking. She's saying he did. It's he said, she said. As she indicated, she's willing to abide. She's okay with him having overnight visitation. Even, I would submit standard visitation if he could be ordered. Of course, he can't do illegal drugs, and if it pleases the court, he won't drink at that time either. As there's some assurances he's going to follow that order. Her son has not hesitated to tell on him, and so we believe that a standard visitation at this time, and especially given the fact that we're coming up on a final hearing, would be a good way. And there should be no reason he doesn't have that, Your Honor. He lived with the child for 9 years, and the child is old enough, and so we believe standard visitation would be appropriate and in best interest of the child, Your Honor.
And Your Honor, just very briefly, we have to remember this is not what's best for Mr. Aguirre or Ms. Magaña. This is what's best for the child, what's in the best interest of the child. It is in the best interest of the child to protect this child from drugs and alcohol. Clearly, you heard testimony, Your Honor, that this child already told his mother, and via his mother told this court, that father was drinking alcohol with him in his possession. Yes, the father tested negative for drugs, but Judge, in the pleadings, the initial pleadings, drugs and alcohol are the bigger issues here. Mr. Aguirre, clearly, as you already heard, in Alice, he first told you that he never approached the house. He just went all the way to Alice to go file a police report. And then after I started asking him questions, then he says, oh yes, I went to the house. And then he says, I went to the house, but he never talked about, hey, I was drinking, I had a cup in my hand. That is evidence that my client even put in a police report and said, look, he's drinking, his breath smells bad. He even told me he was gonna give me a surprise. It scared me. This child has already actually been a witness to father drinking and driving. And I would assume, Judge, this child has already seen father do cocaine. I don't think it's in the best interest of this child right now to allow this child to go with father. He's violated previous court orders. He's violated child support, health insurance, even the drinking while he had the child. The very first time he had the child unsupervised one night, he blew it. He had the child in the vehicle drinking alcohol. To him, Judge, and Mr. Aguirre thinks it's okay. Okay, I'm not doing drugs, but alcohol is not a big deal. I'm a big man. I'm almost 6 feet. I can handle the alcohol. Well, Judge, that's not true. There is a young child that's in the possession of this man who thinks he can handle his alcohol. It only takes one accident to kill a child or to maim a child or to hurt a child, Judge. And mother is very protective. She wants to protect, and I think you do too. Thank you, Judge.
And is there any telephone contact between Mr. Aguirre and the child?
I don't believe so, Your Honor, but we'd be happy to entertain that for sure. As much as he wants, specific time would be very helpful.
Okay. I will, on temporary orders, modify the temporary orders to allow Mr. Aguirre to have the child on the standard Friday visitations, plus this Friday from 6 p.m. Friday to 6 p.m. Saturday. I'll order that he not consume any alcoholic beverages while the child's in his possession or for 12 hours before. And is there a concern that there's been a resumption of any illicit drug use?
Your Honor, I would
always a
ask the
concern,
court, yes, I would ask the court to order that no illicit drug use.
Oh, certainly that, but I mean, that goes without saying, but I will allow Ms. Magana to and the parties communicate by text.
I believe so, yes.
Okay. I will allow her one time to send a text between 6 a.m. and 8 a.m. on a weekday that's not a holiday. And say that she's requesting that Mr. Aguirre take a urinalysis test for cocaine. Whatever 5-panel or 10-panel that takes, 8-panel. And that he has to do so by 6 p.m. that day. So not on weekends, not on a holiday. And he will have to pay for that, but we can decide at the final hearing how that'll be taxed. And if it comes out negative, I would expect it would be taxed against Ms. Magana. So I kind of stumbled through that because I wasn't sure where I was going when I started. Was that clear enough? What I'm ordering, it would be one extra Friday, since I'm not asking him to wait for another 10 days before he has the child overnight.
So it'd be this Friday to Saturday, 6 to 6, correct?
Yes,
Okay, and then the standard first, third, and fifth, Friday 6 to Saturday 6, correct?
yes.
Okay. Now, Judge, I know that you said that the mother could request one UA test. You said for cocaine, clearly it covers all. What if, alcohol and marijuana? The what ifs? I mean, I know we have a final in March, but let's just say he tests positive for alcohol or marijuana, then we can
Okay,
set
well-
another,
Alcohol is not illegal, Your Honor. I mean, if she's gonna,
I'm sorry, what?
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 Alcohol is not illegal. If
Yeah,
she's gonna ask-
I'm not.
Alcohol is not illegal.
All right. You're breaking up,
Right.
Mr. Flores. I'm gonna mute, okay. If there is any, if the cocaine, methamphetamine comes back as positive, then we'll suspend any further visitation. Apart from that, the attorneys can set this for hearing.
Gotcha.
I think you're muted, Mr. Flores.
Telephone communication, Your Honor. What would the court like to do about that?
Okay, has that been happening informally? Does it need to?
I don't think so. I mean, I think that they do talk, but there's nothing set in stone. I would prefer that something be set.
Okay.
I would prefer to be limited, Your Honor, so that the custody is not interfered with my client. Maybe one phone call. I mean, it's just overnight. I don't even know if that's
No,
necessary.
Okay,
I'm
I
thinking
meant,
about the father.
Yeah,
I'm
yeah, I
thinking
meant the other way
telephone for the
around.
father,
Okay.
not necessarily the mom.
okay, is that something the attorneys can work out then?
Sure, I think we can.
Okay, so who is going to type this up, Mr. Flores?
Mr. Flores, I believe he's a petitioner.
I guess I would.
And
Yeah, it's my motion, Your Honor. And as far as requesting the drug test, she can just do it randomly, or is that she's got to have grounds, or
between
how's that
6
gonna work?
a.m. and 8 a.m. by text, any weekday that's not a holiday. By that, I mean, you can't send it and it has to be done by 6 p.m. So that she can't send it, on Sunday, or I don't know how long this will go on. I know it's set for next month, but
Yeah.
sometime when there's going to be drug places open, and you might want to get with him and make sure he knows the sort of where he could go. So he has that in advance. I think you can go to Kaiser or somebody affiliated with Kaiser down in Karnes County
Okay, and he's got to do it that day, Your Honor?
by 6 p.m.
And is this a one-time deal, or can she do it
One-time
whenever she
deal.
wants?
It's a one-time deal.
One time, okay. Okay, appreciate it, Your Honor.
Okay, so do you need an entry date for this, or?
Yes.
See, today is the 10th.
I'm available whenever Mr. Flores thinks he can put it together.
All right, Mr. Flores, how long do you need to get this put together?
I would say a week, maybe, at the most, maybe,
Okay,
try to get it. Obviously, if we can get it by Friday, that'd be perfect, but I'll try to get it done by,
all right. Well,
I would say give us at least a week, just to be on the safe side.
Okay, I'll set this for the 17th. And again, that's only for an entry. If you have it worked out beforehand, just e-file it.
And that's at 9 o'clock?
Yes, sir.
Okay, very good.
Okay.
May we be excused, Your Honor?
Yes.
Okay,
Thank you, Your Honor.
thank you.
All right. And Mr. Ramos, you're excused. Appreciate your time.
Have a great day, Your Honor. Thank you.
You too, Mr. Flores. All right, Ms. Vickers, where do we stand? Mr. Wilson?
Your Honor, this is Ms. Vickers' setting, I believe, but her client has no show. So,
Yeah, yes, Your Honor. This was temporary orders on my client's motion to modify her visitation. And I am, she has not shown up, and I'm really concerned about that. I have been trying to reach her. She was emailing me as late as 9 o'clock last night. She had all the Zoom information, and then I've been trying to contact her this morning by email and by phone. And so at this point, we cannot proceed with the temporary orders. I'm just asking to drop the setting, and I will reset it to another date as soon as I find out what has happened to my client.
Okay, Mr. Wilson, I couldn't hear you if you were talking.
I was, I hadn't said anything, Your Honor.
Oh, okay, okay.
Just that we've been here since 9 o'clock this morning. My client has incurred expense to have me be here. And one of the reasons that he has custody of the child right now is because the last time this was, well, not the last time, but on the date of a hearing, she no-showed. We showed up and we were ready. So we will let the court decide what is in the interest of justice on this one.
All right. I mean, I will go with what Ms. Vickers requested at this point. Obviously, especially if this is a second occurrence, your client should have a very good reason for this behavior, or it'll be held against her in any further consideration of modifying the temporary orders. I hope that she is all right, and I'll just put reset on request.
All right, Your Honor. Yeah, her default was in July of 2019 in a prior motion. It has not been in the this pending motion that's pending before the court now. So that was some time ago. So, but I understand what Mr. Wilson is saying, and so we'll just reset it upon request when I find her. I've been representing her for 1.5 years, and she has not ever acted this way in anything that I've been doing since I've been representing her. And we've had prior court proceedings, and she's appeared in an enforcement that we did recently. So that's why I'm saying we'll just let it go for today, and then I'll just have to reset it when I find out what happened.
Okay, and what is your client's name?
My client's name is Megan Monk.
Okay. I'm just making a note of my docket here.
That's fine, Your Honor.
Then y'all are excused.
Thank you, Your Honor.
This is reset on request, and I have a note that Megan Monk, no show.
All right. Thank you, Your Honor.
You're welcome. Have a good day. Okay. All right, let me tell the attorneys, I need to return a couple of calls. We'll restart this at 12:40.
Okay, and I'm gonna step out for lunch, Judge, and come back.
Sounds good.
Thank you.
We'll see. All right, Ms. Cavazos? Okay. All right, are we ready to go?
Your Honor, I don't see the opposing the plaintiff's lawyers.
Yes. All right, I'm not sure.
So the answer is yes, Judge, we're ready to go.
I know I had some trouble getting in just now, so I don't know if they're having similar trouble. I was in the waiting room for a little while.
That's because I hadn't gotten back to my desk.
Oh, okay.
Let's see, is Miss Riley here? If somebody would email them to make sure they got the link to the new meeting. Remember we had to
Yes.
start this over?
Yes, Your Honor.
Thank you.
Not as bad as a trial Mr. Waymeyer and I had a couple of years ago up in, was it Ward County?
Ward County, Texas.
Ward County, sitting in front of a jury panel waiting for voir dire for an hour and a half. Also had the wrong time, showed up an hour and a half late.
Ooh.
That was Chad Davis for those taking notes at home.
Mr. Hyatt was in that case for a little while.
You guys non-suited me, man. I'd have been there on time.
I actually had something like that happen in county court one time. And I lost the case after the other side defense attorney showed up an hour and a half, 2 hours late. And he later got disbarred. So that was not one of my better days.
Can't make the facts.
Did y'all see the filter of the cat that was on Zoom in the
Yes.
Zoom hearing?
Yeah, my wife loved that.
And the judge there had some sort of notice that said you're not allowed to record this. I don't know.
They said the judge sent it out on his Twitter account.
Right. Yeah. Then the judge sent it and posted it himself, but when he said nobody else could record it, but I don't know how you enforce that.
Your Honor, I've emailed opposing counsel.
Thank you.
You know, I wonder if they clicked the 9 o'clock link again.
I sent them the new one. And I'm going to try to call them as well, Your Honor.
Cell phone, Corey, cell phone.
I've been fussed at.
Mr. Truss, what is your picture a picture of two people when there's?
Oh, that's my wife and I playing golf.
Oh, okay.
I
just wanted to
guess
get that tiny image.
I should probably get a more professional photo.
I couldn't make out. I could see it was two individuals. That's all I could see.
One of my favorite photos.
I was able to reach Mr. Kilday, and he said they're going to try to use the correct link.
Okay.
Y'all know the judge on that case yesterday, is that Judge Royal Ferguson's son?
I didn't know Judge Ferguson's son was a judge.
It is.
It is. I
is.
saw the name of the guy was Roy Ferguson, and it was spelled the same strange Ferguson spelling.
It is.
Here we go.
Did he step down as the dean of the North Texas School of Law?
I think so.
Okay.
Yeah, we just mediated with him about 30 days ago, and I thought he had some kind of a capacity with the school still, but I might be wrong.
Emeritus. All right, Ms. Kilday, ready to proceed?
Yeah, let me get Mr. McFarland in here. We were in the
Okay.
meeting room since 12:20 on the link for the 9 a.m. hearing. And when I got the updated link for this other room, it came for a 10:30 to 11:30 slot or 10:30 to 12 slot. And I signed in at 10:30 and was very briefly part of your 10:30 hearing, but popped out. But when the waiting room didn't let me in, I tried this link again at 12:30 and didn't see, I was still in a waiting room for that. So I went back to 9
Okay,
o'clock.
I had come back on about 20 after and said I'd be here at 12:40, and so.
Okay. Well, I wasn't in there at 12:20, so let me make sure we get Mr. McFarland in here. I forwarded that link to him.
Yeah, he's Dean Emeritus now.
Okay, and what motions do we have this afternoon?
Your Honor, I think that we're starting the day. The plaintiffs have a no evidence as to the defenses of fraudulent concealment and discovery rule. And then the defendants have their no evidence motion for summary judgment as to the entirety of the plaintiff's case.
Let me go to plaintiff's pleadings. All right, so that would be plaintiff's no evidence motion for partial summary judgment, FS.
I think that's correct, except the last two initials, I wasn't sure what that was. And Your Honor, just to move it along, what they'd indicated yesterday at the close of the hearing, that the only matters out of that entire motion they intended to go forward on was fraudulent concealment and discovery rule.
That's correct, Your Honor. And I see that Mr. McFarland has just joined us, so we're all here.
All right, let me make sure that I'm on the right document.
And I think that, Your Honor, Mr. McFarland, there was a last minute argument very briefly made by Mr. Grable at the end of the day yesterday. Mr. McFarland wanted to speak to that very briefly.
Okay.
There were actually two things I wanted to speak about, Your Honor. One is that there's one remaining issue that is in our second motion for summary judgment that hasn't been argued yet. And that also deals with the road. One of our issues that we asked the court to rule as a matter of law on was whether the deed from Hancock to Frills conveyed fee title to the road or only conveyed an easement. Some of the defendants in this case had raised that issue in their pleadings. And so we requested a ruling on that issue in our second motion. And the defendant's response to our motion argues that it indeed only conveyed an easement. I don't know whether all of the defendants take that position, but at least some do in that response. And so we'd like to be heard on that. And as Mr. Kilday said, we would like to be heard briefly on a response to what Mr. Grable said at the end of the day yesterday. So with the court's permission, I will begin with that.
Okay, let me make my note here about the road tract and then a response. So, I mean, I think the most I could make any decision on the road is just as between these parties and without any prejudice to the rights of the folks on the either side of the road to claim that, because they're not parties, correct?
That's correct.
All right. Right. Go ahead, sir.
So yes, Mr. Grable and I have known each other for a long time. And I know that he has a reputation for getting to the heart of the matter. And he did that yesterday. And he points out that the plaintiff's case, he points out correctly that the plaintiff's case depends on being able to show that the production from the Snitch Rydell well, from the time that the Frells well stopped producing until 2014, when EOG's production began, was unit production that kept the royalties, that our term royalties in effect during that time period from 1997 to 2014. And that goes to two arguments that you've heard argument on already on this case. One relates to the applicability of the Wagner and Brown decision and whether the royalty interests of our clients remained pooled after the lease was released. And the other relates to the viability of the 1982 pooled unit designation that was filed by Shell, and whether that, whether we have the right, or at least have raised a fact issue as to whether that we can claim that the production from the chalk formation was unit production. Also, I think you've heard in the course of these arguments that I have expressed opinions about the Wagner and Brown case. And so I want to take this opportunity to inform the court about my opinions. And I think, although there's been a lot of argument about the Wagner and Brown case, it hasn't really been discussed in great detail, and particularly the facts of the case. So I think that would be helpful to the court. So let me get my slideshow started.
And just to let the attorneys know, I need to leave at 5. That's still over 4 hours from now, to pick a younger son up from band practice. Go ahead, sir.
Okay. Trying to advance the slide. It doesn't seem, there it is. So you've seen this language before. The 1982 unit designation said that it pooled the leases and all royalties, overriding royalties, production payments, and other interests thereunder. And yesterday there was argument about what that language means. And Mr. Grable said that the interests that are pooled did not include the reversionary interest that was owned by the Frells, because that was retained, that wasn't conveyed or granted by the lease. And he's correct about that law. But remember that the royalty interests that are owned by our clients, the term royalty interests, are not interests that are derived from the lease. Those, as it shows on this slide, our royalty interests are interest in the production of oil and gas and are carved out of the fee mineral estate. As I've argued before, our royalty does not depend on the existence of a lease. And so our position is that the 1982 unit designation did pool our royalties, and that pooling did not stop when the lease was terminated. So let's look at the facts in Wagner and Brown. The plaintiff in the case was Jane Shepard, and she owned a 1/8 mineral interest in 62 acres in Upshur County, which she leased. And her lease, along with leases of the other 7/8 mineral interest in that tract, were included in a gas unit, a Wagner and Brown gas unit. And the gas unit contained 122 acres. So it was about twice as large as her tract. Ms. Shepard's lease provided that if royalties did not commence to be paid within 120 days of the first sale from the wells, the lease would terminate. The 2 wells that Wagner and Brown had drilled were on the 62 acres in which Ms. Shepard had an interest. So Wagner and Brown failed to pay timely, and so the lease automatically terminated by its own terms. Wagner and Brown offered to release her interest, but she refused. Instead, she sued and contended that she was entitled as an unleased interest owner in the drill site tract to 1/8 of the net revenue from the wells after operating costs, which would be a much larger share of the revenue than she would be entitled to under the unit. So Wagner and Brown argued that Ms. Shepard's interest remained pooled in the unit, even though it was unleased, and so that her interest in production would still be diluted by the unit factor. She would only get 1/8 of 62 over 122 of the well's net revenue. And that's where the court discussed whether the lease and the unit designation pooled lands or pooled leases. And the court concluded that her interest remained pooled because her lease authorized the pooling of her interest in the land, and Wagner's unit designation pooled the lands. So there was a second issue in the case that was also contested. Wagner and Brown argued that Ms. Shepard's interest in the well should bear its share not only of the operating costs of the well, but also the drilling costs of the well, so that her interest would be treated as if it were an unleased pooled interest from the beginning, that it had never been leased when the unit was created. The court agreed with that also. And this is the quote from the opinion: Shepard had the option to continue to collect royalties free of any drilling costs, as Wagner and Brown offered, having chosen instead, as was her right, to be a co-tenant with full benefits to the minerals she owned. It would be inequitable to allow her to escape the burdens that come with that choice. I've chosen this language because I want the court to understand that if you read the whole opinion, you understand that the court felt that Mrs. Shepard was overreaching, that she was trying to take advantage of a mistake by Wagner Brown and failing to pay her royalty within 120 days, and that it will not be equitable for her to increase her interest in the well solely because of that error on their part. Go to the next slide. So in my writings about this case, one of the things that I talked about was, what if the situation were reversed and the Shepard tract was not the drill site of the wells that Wagner and Brown drilled? So Shepard's lease terminated. So in that event, Shepard would have argued, or could have argued, that her unleased interest remained pooled, so that she still had an interest in the production, even though her lease had expired. And Wagner, on the other side, could have argued that her interest was no longer pooled because it was not the drill site tract. That situation is more akin to what we have here, because the road obviously is not the drill site tract for the Snitz-Rydell unit. And my criticism of this case related principally to the second holding, where the court burdened Ms. Shepard's interest with the drilling costs of the well, even though her lease was in effect when those wells were drilled. So there are differences between Wagner and Brown in the present case, which I think are important. The first is that Shepard's lease terminated according to its terms, based on language that she included in her lease. The Frells, on the other hand, our clients had no right to negotiate the lease. We were just royalty owners in the tract. And the Frills lease did not terminate in accordance with its terms. It was released inadvertently by Carbon when they settled their dispute with Mr. Gaddy.
Your Honor, I have an objection that this is utterly outside the summary judgment record. And if this is in the record, I'd be very curious for a citation as to where it is.
As to the inadvertence of the release?
I believe there's testimony by Mr. Grant that he was sorry that he didn't realize that there was still production from the lease in the Snitch-Rattle unit when he released the lease. He didn't realize that that was the case. And he didn't recognize it until much later when he finally just stopped paying royalty on the road. I believe that's in the testimony. I don't have it at hand. In any event,
I'll overrule the objection. The record says whatever it says.
right, that our clients, the NPRI owners, didn't have any control over whether the lease remained in effect. They were not offered the opportunity to reinstate the lease like Ms. Shepard was in the Wagner and Brown case. And finally, Shepard's mineral interest was not burdened by an NPRI. So there's no party in the Shepard case who is a comparable situation to ours. Now, it may very well be that as to the Frells' interests, when the lease was released, their reversionary mineral interest reverted to the Frells and was no longer pooled. But that would not mean that the royalty interest in the property that we owned was not pooled in accordance with the terms of the 1982 unit designation and remained pooled after the lease was released. We believe that that's a fair reading of the unit designation. And more importantly, if you look at the equity of the situation, it's much different than the Wagner and Brown case. Obviously, the court in Wagner and Brown did not feel that Wagner and Brown was being treated equitably. Here, equity, we believe, is on the side of the NPRI owners who did nothing to cause the release of that lease. There was one other matter that I want to address that Mr. Grable mentioned. He said that the 1982 unit designation was void. And I think Mr. Grable will agree that there's a difference between an instrument being void and an instrument being voidable. A void act cannot be revived no matter what the parties want to do. It is void as a matter of law. It cannot be revived in any way. A voidable act is something that can be ratified or can be recognized in a court of equity. And clearly, Mr. Grable mentioned that, let's suppose the lease had no pooling clause at all. Well, clearly a unit designation that purported to include a unit that had no pooling clause would not be effective. But it could be ratified. It could be made effective by the conduct of the parties. And that's what we say we have here. We say that equitable considerations require, or at least give us a fact issue on whether the conduct of the parties and the equities in this case entitle us to say that by the long continued acquiescence in the production as unit production from the Snitch-Rattle well entitles us to count that production as unit production that maintained our term royalties beyond 1997. So I'm going to now.
Your Honor, may I be heard in 60 seconds on the brand new stuff?
Okay, I'll let Mr. McFarland finish and I'll let you speak.
I think he's moving to his next motion, but.
Oh, are you going to your next issue?
Yes, I am.
All right, I'm sorry. Go ahead, Ms. Wimmer.
Your Honor, 3 points. the pooled unit designation only purported to pool the leases and interest under the leases. When the lease goes away, there is no pooling in the universe as to the Frales lands, the Frales lease, because the pooling was only from the Frales lease. 2, we have heard, you can look back at these plaintiffs, Exhibit 14, Mr. McFarland's declaration, where he is emailing EOG in the year 2017. And all we have heard from these plaintiffs since the middle of 2017 is this is Wagner and Brown. This is the Wagner and Brown case. It's indistinguishable. Wagner and Brown takes care of this whole thing. Once you actually read the case and they're confronted with Chieftain, now for the very first time since the year 2017, they go, no, this is different than Wagner and Brown. Gosh, that was action. We've had it wrong since 2017. That was a different case. And now they come to you pleading equity. Well, this is a court of equity. Let's have equity. The causes of action that they have pled is declaratory judgment to construe the existence of an MPRI. That is not an action in equity in any way, shape, form, or fashion. They have pled a statutory remedy under TNRC 91.402. That is a statutory remedy. That is not an equitable remedy whatsoever. They have pled an action in breach of contract. That is not a plea of equity in any shape, form, or fashion. And they have pled money had and received, which has nothing whatsoever to do with this court construing a term defeasible MPRI. So the fact that they have now retreated off of Wagner and Brown, which is all we have heard since the year 2017, and now stand with their hand out for equity, proves exactly the point that we have been making in the papers from the very first day.
Your Honor, can I have 30 seconds since Mr. McFarland, who I have known for a long time and who I do respect, nevertheless, I thought he was responding to my brief arguments yesterday on 2 points. And the first one, I think he conceded that the reversionary interests were not pooled. And I heard Mrs. Keenan say that his view was they were pooled and that somehow converted the clear pooling only of leases into a pooling of land, so Wagner and Brown didn't apply. I think they've walked away from that now. And I think I heard Mr. McFarland say at least twice that the pooling, since the pooling only was of leases and that the term royalties are not leasehold interests, that they were never pooled. And I think that's correct. And some of them may have ratified the 64 unit, but there's no evidence in this record whatsoever that any of them ratified the 82 unit, which they didn't even know about. Nobody knew about. So I think they wind up outside of Wagner and Brown. And my argument yesterday is they got 2 steps they got to climb successfully to prevail. And one is they're inside Wagner and Brown, which I think they've now admitted out of. And the second, even if they can get over the first step, that one of these units was valid, and I think they've admitted that they weren't pooled by the 82 unit, so they're done. And the third point was that this is a void act, not a voidable act, and it can't be ratified. Well, it could be expressly ratified and revived, but it can't be unconsciously done like they're trying to say. So with that, I'll quit.
And to clarify, Mr. Gravel's, a expired NPRI cannot be revived under any case authority in the state of Texas or any other authority in the world. I think what he is referring to is giving ratification validity to a designation of unit through knowingly, with knowledge of material facts, making the affirmative act to give validity to that otherwise unenforceable 1982 designation of unit. But all of the case authority in Texas says that you cannot breathe life into an expired NPRI. It cannot rise from the dead. Zombie NPRIs cannot come back once expired.
And I was saying that the void act of pooling, just like in the Montgomery versus Rittenbacher, could be ratified, but none of these plaintiffs ever did or tried to. There's no ratification in evidence. So that's it. And I agree with Mr. Waymire that a zombie NPRI can't come back to life. So that's it. Thank you.
Okay, so plaintiff's motion on the equitable defenses is next.
No, our motion about this is another motion about the road, Your Honor.
Oh, okay, go ahead, sir.
Let me share another screen here. So as I said, one of the summary judgment issues that we raised in our second motion for summary judgment was to declare that the deed from Hancock to Farrell's conveyed fee title to the road. The defendants do not have a summary judgment motion on this issue, but they do argue that, and they did oppose this motion, arguing that the deed from Hancock to Farrell's did not convey fee title to the road. So we think it's important for the court to address that issue. It's a legal question. It's a purely legal question of construction of the deed from Hancock to Farrell's. And to begin with, I might point out, as the court may have already seen, that this is inconsistent with the position that the defendants take on construction of the deeds of the royalty deeds. The defendants have conceded that one of the royalty deeds, the one to Mr. Auld, did convey a royalty interest in the road because it had the actual description in that deed, just incorporating the same description as the deed from Farrell's. So obviously, if the deed from Hancock to Farrell's did not convey fee title to the road, then likewise the deed from Ms. Farrell's to Auld could not convey any interest in the mineral title or the royalty interest in the road. So here we are again on the 1945 deed from Hancock to Farrell's. This is the introductory paragraph. And then this is the part that conveys the road, together with the following described tract of land for roadway and easement. So the defendants argue that that grant language only conveyed an easement and not the tract of land. So here are two cases that construe deeds that have both a grant and a designation of the purpose of the grant. Words in a deed that show the purpose of the grant do not change the effect of the conveyance to limit the grant. A deed in which the granting clause grants, sells, and conveys a tract or strip of land conveys fee title, even though in a subsequent clause or paragraph of the deed, the land conveyed is referred to as a right-of-way. So we believe that that is the proper way to construe this language. It says that they have granted, sold, and conveyed the following described tract of land, and then they describe the purpose of the grant. Are y'all seeing these?
Yes.
Okay, all right. I just want to make sure you're seeing them. One other rule of construction that we rely on is that the deeds are construed to confer upon the grantee the greatest estate that the terms of the instrument allow. So the presumption is that the deed conveyed fee title and not an easement. Another argument made by the defendants is that because the deed only described 488 acres in the introductory paragraph, and then separately referred to the grant of the 4.15 acre road, that must mean that the conveyance wasn't intended to convey fee title to the road, but only an easement. And again, we're pointing to the fact that the least reliable of all calls in the deed is the amount of acreage. And this, the quote below is an additional paragraph, an additional sentence in the deed, which makes clear that they're conveying by the tract and not by the acre. And they're not guaranteeing how many acres are in the tract.
Give me just a moment. The computer.
Okay, I'm sorry.
Good sound. All right. Thank you. All right, go ahead, sir.
The fact that the deed conveyed fee title to the land is evidenced also by the way the title to the minerals in the road have been construed and treated since the Shell lease was granted. The Shell lease includes the road in its description, the lease from Frells to Shell. Shell included the Frells lease in its designations of pooled unit, both for the Frells well and the Snitch Bridle well. Shell and Carbon paid royalties to the Frells and to the term royalty owners on production from the Snitch Bridle well based on their interest in the road. And Carbon, as Mr. Waymire has pointed out, Carbon obtained a lease on the road from the Frells in 2010. He assigned that lease to EOG. EOG leased the Frells interest in the deeper rights in the road in 2014. And those leases then were included by EOG in the new units that they had formed when they started drilling their wells in the Chalk and in the Eagle Ford. So there's a designation of pooled unit in the record for the Josie unit, and there's a designation of pooled unit in the record for the Walter unit. Both of those units include all or a portion of the road. And so EOG has concluded that the deed conveyed fee title to the road. And I believe it's the position of the Frells in this case, although maybe the Frells attorney can confirm that Frells believes that the deed and contends that the deed conveyed fee simple title to the road as a defendant in this lawsuit. So we request a summary judgment from the court that the deed from Hancock to Frells included fee title to the road and that the Frells then owned the mineral title under the road.
Okay, and who's going to speak in response?
Your Honor. I can see that you haven't heard enough from me over 2 days plus previous week. Your Honor, alas, Mr. McFarland has waded into possessory territory. And what he's asking you to do is, I don't even know what procedural vehicle he does it, but he's asking you to adjudicate possessory interest in property in this 4.15 acres. That is their ask of you. And they say that they want the court to make a declaration about fee title to the 4.15 acres. And I was accused of histrionics by Mr. Kilday back at the January 26th hearing when I told the court that they're asking you, this is how late they are. They are asking this court to come in and make declarations about things that happened in 1945, 75 entire years ago. And now the proof is right here. Mr. McFarland's asked you to do that. The problem that these plaintiffs have is that, one, as we know well, under the Texas Property Code Section 22.001, and as we know well under Texas Rule Civil Procedure 783, and as we know well under the holding of Martin versus Ammerman, a Texas Supreme Court case opinion, he has to do that through a trespass to tri-title vehicle. And when you declare ownership of possessory property through a trespass tri-title vehicle, what that requires at a bare minimum would be two things. That is, joinder of all the affected parties, and two, a proper abstract of title. There's a whole procedure for abstract of title back to sovereign that's provided for in the rules of civil procedure. He has not brought you the Schnitz owners. He's not brought you the Rydell owners. He just comes in and says, I want you to say that this deed conveys fee title instead of non-possessory easement title. And we would like a declaration about that. Here's the easy way that the court can deny that motion without even getting into the procedure of it. We pled the defense of limitations, saying that coming in the year 2021 and asking for a declaration about something in the year 1945 is tardy. It's too late. You can't do it. And in response to their traditional motion for summary judgment, we pled limitations and we put on the evidentiary proof of limitations. And so their motion requires being denied on that basis. If they did it as a trespass tri-title action, I imagine there'd be all sorts of folks that would need to be joined and might have something to say about it. And there may be adverse, I don't know in terms of the fee aspect. I don't know if there's stripping gore doctrine issues as to this thing or not. The point is we don't know because the plaintiffs haven't done it right, haven't followed the right procedures. And so that's where it is. I want to pull up just briefly so I guess the easy way is motion denied, limitations have been pled, you're too late. We haven't filed a plea in abatement or anything. It's not our play. I mean, like I said, if he wanted to adjudicate fee possessory interest in that road, he had a whole different statute he needed to do it through. And there's no abstract of title in front of the court. As a practical matter, now in their summary judgment proof, they rely on a title opinion from a non-lawyer, a gentleman by the name of James Starr. And Mr. Starr was asked in his deposition, on this road track that y'all want to declare as fee, did you do any investigation about the road, go back in time and look at the history of the road? And what Mr. Starr testified to under oath is that, no, it was too hard. He didn't really mess with it. Well, now lo and behold, he's clairvoyant. He's got it. Now he has an opinion about the road that shows up in a report that is over an entire year tardy. Now he's looked at the road. So I would say to the extent there's any proof in this summary judgment record, this is specifically identified in our timely filed objections to their summary judgment evidence that under Rule 193.6, Mr. Starr's opinions about this road are one, legally incompetent because you can't have somebody come in and testify about legal title. Two, certainly a non-lawyer can't do it. Three, it violates both the penal provisions and the civil provisions against unauthorized practice of law insofar as taking compensation to render legal interpretation and legal opinions. There is a very narrow landman exemption to the unauthorized practice of law for what Mr. Starr's done. It doesn't apply here, and in his deposition, he's testified it doesn't apply. That would, the landman exemption to unauthorized practice of law only protects one if you're in the process of actually acquiring title or acquiring a lease. If he was out doing an actual,
I hate to interrupt, but I object to this argument because this argument goes to a different issue. This argument goes to the qualification of our expert, which is the subject of a motion, but it's not before the court.
Your Honor, it is before I filed an objection that specifically identifies.
Okay, and we'll take that up later. So
yeah.
Okay. Now I know.
Well, yeah, in terms of any evidence they would use, this would all come from Mr. Starr, and we did file an objection to that evidence before start of the hearing, and we'll take that up later today. But let's just look at the actual language. Let's look at the actual language of the 1945 instrument that all right, if we can just get down to, I've had everything else highlighted, but this isn't. Let me see.
Right, and I'm sorry, give me just a moment.
Yes.
Okay, I'm sorry, I'm back.
Thank you, Your Honor. I had an opportunity to get the language that they're asking you to interpret kind of highlighted. It speaks to the 4.15 acres as, quote, together with the following described tract of land for roadway and easement from the above described tract. What they ask you to do is write out the word easement and say that this makes no fact issue as to whether easement was intended. Ignore the holdings of cases like Luckel versus White and U.S. Shell versus Laborde that says you have to construe and give effect to all words in an instrument rendering none surplusage. We want you to put an X through easement without the correct parties at the table to have a say about that. And we want you to interpret this as a fee possessory 4.15 acres. You can take it down. Your Honor, this is not a hill that any defendant needs to die on to prevail in this case. I don't want to belabor it or spend more time on the thing, but it is. I've spoke to holes the size of freight trains in the plaintiff's case. They will hear about this when the case is on appeal, but I think the motion's appropriately denied for the reason that what they're asking for is barred by limitations. We pled that defense in answer to their traditional motion, and in the alternative, it's not even in the right cause of action, but in the further alternative, it says easement. I think there would certainly be a fact issue on it.
Your Honor, may I be heard for a minute?
Yes, sir.
On the issue of whether we have the appropriate pleadings or cause of action, I think the court understands that we're not claiming title to the road. We're claiming title to a royalty interest in the road. The royalty interest is a non-possessory interest and can't be adjudicated by a trespass to try title claim. Our right to that royalty interest, the chain of title to that royalty interest goes from Hancock. And so in order to have that, our title to that interest adjudicated, you have to look at the Hancock deed. And since the defendants brought up the construction of the deed, our motion simply asks the court to construe the deed. We understand, as the court understands and has said, that has no effect on the right of any non-party to claim that the deed should be construed as an easement. I will point out that both the Schnitzes and the Reidels, whose land were included in the same unit, never claimed, to our knowledge, that any part of the road, that they owned any part of the road. They understood that the road was part of the unit and the Farrells were participating in that unit. But we're not seeking to adjudicate title to the road. We're only seeking to acquire, to confirm our interest as a royalty owner in the road.
Do I have all the necessary parties in front of me?
As to the royalty interest, you do, Your Honor. I think that the defendants we have shown are successors in interest to the interest of the Farrells in the tract, in the 488 acres and the road. And the plaintiffs are successors in interest of the grantees in the royalty deeds. So as to the title to the term royalty interest, all the necessary parties are here.
Your Honor, may I be heard?
Yes, sir.
You might inquire of Mr. McFarland whether there are royalty, under his view of the world, whether there are royalty owners that he would claim are similarly situated to him and whether they're in front of the court.
We have said, and it is true, that there are other owners of non-participating royalty who are successors to the deeds who elected not to join this case. They were offered the opportunity and they elected not to join. So those parties' interests will not be affected by the outcome of this lawsuit.
And would that be an advisory opinion, give an opinion that didn't dispose of all the parties?
So if the plaintiffs were to win the case, then the defendants would not be able, if the other royalty owners who are not in the case came in later and claimed their royalties, the defendants would not be able to re-argue the issues that were adjudicated in the case. But if the plaintiffs lose this case, that would not affect the rights for the other royalty owners to bring their suit to claim their title.
Okay, all right. Go ahead.
So, Your Honor, if we are completed in discussing the issues that came up yesterday and the issues relating to the road, then I can proceed with my very brief motion for partial summary judgment as to 2 of the remaining affirmative defenses pled by the defendants. And I'll let the court tell us if that's where we are in the proceedings.
I think so. And that's fraudulent concealment. And which was the other one?
Discovery rule, Your Honor. 2 very related arguments.
Go ahead.
Okay, thank you. Let me pull that screen up. Okay, so as I indicated, Your Honor, I think this will be very short, very brief. We filed our 3rd motion for summary judgment, actually partial motion for summary judgment. It's a no evidence motion as to a number of affirmative defenses that were raised by the defendants in various pleadings. And you'll see the list here. There were, I believe, 17 different defenses covered by our motion. And these were all, for the most part, pleaded in very cursory fashion, a single sentence, sometimes multiple defenses raised in the same sentence. And it was not clear to us exactly what they were even referring to on many of them. Some of them were pleaded with a little bit more specificity, but we moved for partial summary judgment on 17 defenses. This is not all of the affirmative defenses, but they were the ones that we either believed there could be and would be no evidence of, or where we had no understanding exactly what they related to, and for that reason believed there was no evidence. The defendants in recent weeks, maybe within the last few days, have filed amended pleadings that remove 6 of those defenses. So those are now gone. Promissory estoppel, repose, unclean hands, consent, failure to mitigate, and accord and satisfaction. Those have all been abandoned by the defendants with a notice of non-suit in the last several days. And then that leaves 11. As to 9 of those, the defendants have at least articulated what they are discussing and what they are relying upon. And as I announced yesterday, we've elected not to move forward in light of the evidence that has been presented on those 9 defenses. We still, of course, contest the defendant's assertion of those defenses, but that will be an issue to be decided at trial. So our motion for partial summary judgment on no evidence grounds will now move forward only as to these 2 that are highlighted on the screen: fraudulent concealment and discovery rule. And Your Honor, just for context, this comes up in connection with that claim that we have made relating to the 1982 designation of pooled unit, where we say the designation was recorded in the public records in 1982. The certificate of pooling authority was recorded with the Railroad Commission also in the spring of 1982. A permit application was filed to recomplete the Schnitz-Friedel well back in 1982. That permit was granted by the Railroad Commission back in 1982. All 4 of those documents are in the public record, were available for anyone in the world to see. And we've already gone through the case law in discussing that portion of the summary judgment proceedings about parties being on constructive notice of those kinds of filings, and that triggering an obligation to bring a claim, if any, is to be brought relating to a claim of breach of lease and improper pooling in violation of the lease. We've also talked about paragraph 11 of the lease that required any notice to be given to the lessee in a timely way with a 60-day notice of opportunity to cure. So these 2 defenses are tied into all of those issues that we've already discussed this very week. So fraudulent concealment, the case law makes clear that if you are asserting a claim of fraudulent concealment, that is a defense that is to be asserted based upon some kind of fraudulent conduct to conceal activity by the counterparty in the lawsuit. And that comes from BP, American Production Company versus Marshall, Texas Supreme Court 2011. The defendants have made no allegation of any fraudulent concealment by any of the plaintiffs, nor have they made any allegation of any wrongdoing on the part of the plaintiffs associated with the actions they've discussed with Your Honor this week about Carbon Oil Company, about the recompletion of this well in 1992 in the Austin Chalk Formation, about the production of oil thereafter, and about the various filings by Carbon Oil Company with the Railroad Commission. Those are facts and allegations about alleged misconduct by Carbon, not by the plaintiffs. So we are here in this lawsuit saying on quasi-estoppel, on limitations, on waiver grounds, you can't accept benefits from production when there's a pooled unit designation on file back in the early 1980s and never contest that pooled unit designation for 35 years and then come to court and take an exact contrary position, which the defendants are doing in this lawsuit. And we say those claims are time barred because they needed to bring a suit against Carbon in a timely way, and they had all the records that they needed to bring that claim back in the early 1980s. They now say, wait, you can't assert limitations, plaintiffs, because of your fraudulent concealment. And our point is simply, there is no evidence of any fraudulent concealment by the plaintiffs, and there's no evidence of fraudulent concealment of anything that would change the outcome of the arguments based upon limitations on this issue. And another case we cite for this in our briefing, Vial versus Gas Solutions Limited in 2006. It's in our brief that the elements of fraudulent concealment are the existence of the underlying tort, and then the counterparty's knowledge of the tort, the counterparty's use of deception to conceal the tort, and then the plaintiff's reasonable reliance on the deception. Here it would be the defendant's reasonable reliance on the deception. So, but there's no act of fraudulent concealment. There's no evidence of any act of fraudulent concealment by the counterparty here, which would be the plaintiffs. There's no active suppression of truth or failure to disclose information known to the plaintiffs by the plaintiffs. So that's why we've brought forward this no evidence motion. There's no evidence of any act to conceal anything by any of the plaintiffs, and there's no evidence to show that. The underlying facts were never concealed by anyone about the formation of this pooled unit. And we talked about at length Exhibit 1H, which was the pooled unit designation that was recorded in the real property records of Karnes County in the spring of 1982. It's been on file for anyone to see for more than 35 years. Exhibit 2H is the Notice of Pooling Authority, which was filed at the Railroad Commission. Exhibit 2I is the permit application to recomplete the Schnitz-Riedel well in the Austin Chalk. That was filed at the Railroad Commission in the early 1980s, in 1982. Exhibit 2J is the permit granted by the Railroad Commission to recomplete the Schnitz-Riedel well in the Austin Chalk Formation. That was recorded at the Railroad Commission and publicly available at any time. So similar principles on the discovery rule. This relates to the exact same issue and it's sort of the same exact argument. The discovery rule applies to defer the accrual of a cause of action and delays triggering the statute of limitations when two elements are present. One is that the nature of the injury is inherently undiscoverable, And the second is the evidence of injury is objectively verifiable. That's the BP case in 2011 from the Texas Supreme Court. There's also case law showing that an injury is not inherently undiscoverable when it's the type of injury that could be discovered through the exercise of reasonable diligence. That's also discussed in the BP case. Here we have claims by the defendants that they are entitled to rely on the discovery rule. Why? Well, they claim that they couldn't have discovered that there was production out of the Schnitz-Riedel well in the Austin Chalk Formation because of documents that Carbon filed showing that that production came from the Edwards Formation. But that really misses the point of the claim. The claim is you're time barred to contest the pooled unit designation for the Austin Chalk. You're time barred in contesting that. It's a claim of improper pooling under the Frells lease, and the triggering event was 1982 when that pooled unit designation was recorded, when that pooling was achieved. And the defendants certainly can argue that was a breach of the Frells lease, but the time to make that argument would have been in 1982. And none of the facts they say they didn't know were necessary for them to have made that claim back in the early 1980s. So there's no evidence that those facts were inherently undiscoverable. The summary judgment record conclusively shows the opposite. The underlying facts were in plain view. They were publicly recorded at the Railroad Commission and at the Karnes County Real Property Records, and they were all inherently discoverable, and it would be their burden to show inherently undiscoverable. But they were certainly filed of record, same exhibits we just talked about, the pooled unit designation exhibit 1H, the notice of pooling authority exhibit 2H, the permit application exhibit 2I, the permit itself exhibit 2J. All of those are in the public records. So we would respectfully urge that the plaintiff's no evidence motion for summary judgment should be granted as to these two defenses. There's no evidence to support the defendant's fraudulent concealment claim, and there's no evidence to support the defendant's discovered rule claim. Thank you, Your Honor.
All right, who's going to respond?
I'm Your Honor.
Go ahead, sir.
So with the, I'm true, as you know well, fraudulent concealment and discovery rule operate as kind of a defense to a defense. So once one pleads statute of limitations, then in response to that, you plead fraudulent concealment or discovery rule. And so I think it would be incredibly helpful and narrow today's presentation, because the plaintiffs have pled statute of limitations that we've answered with by fraudulent concealment and discovery rule, to know what the plaintiffs are saying is barred by limitations. And so if I could get that clarity on the record of what is barred by limitations, I think that will greatly narrow the presentation from here. I'm just, and obviously the court tells me no, and I'll shut up, but.
Oh, go ahead.
I'm just asking for the plaintiffs, if the court could ask the plaintiffs to say what exactly is barred by limitations, because the fraudulent concealment and discovery rule are stated in response to the pleadings to their plea of limitations. And so we don't know what they're even saying is barred by limitations. If we could get that clarity, I think it'll move the presentation along.
Mr. Kildane?
Your Honor, we will rely on our pleadings. I think we set that forth in great detail. It's certainly set forth in our pleadings. I'm not here today to abandon or waive anything that we've pleaded, but I think, as I've stated to Your Honor, the defense of limitations is based upon the defendant's failure to take any action to contest the pooling of the Schnitz-Rydell unit for the Austin Chalk in 1982. And we say that they are barred from complaining about any subsequent production out of the Austin Chalk because they didn't take timely action to contest the formation of that pooled unit in 1982. And other than that, I'll rely on our pleadings, which explain that in further detail.
Okay.
Thank
you, Your Honor. So I think what he said is that they are pleading that a counterclaim that the 1982 designation of unit is a breach of contract or is invalid is barred by limitations. There's no counterclaim whatsoever in this case against the plaintiffs. So for them to have a defense of limitations, there has to be a counterclaim pled against them. Mr. Kildane must concede that there is zero counterclaim pled in this case in any way, shape, or form. And that has been, he mentioned a few days ago, with respect to so that the record's perfectly clear, it wasn't a few days ago that any defenses were dropped. More than 7 days before the summary judgment hearing, consistent with Rule 166A, a handful of defenses were let go. But as to the counterclaims, there is zero counterclaim in the world for him to even have a limitations defense too. But he talks about the 1982 designation of units. So I think this goes back to him wanting to say that we are asserting a hypothetical claim against Carbon, and then he gets to hypothetically assert a defense on behalf of Carbon on limitations. As the court knows, as just a pure procedural matter, even if you hypothetically pretended that we sued Carbon and said breach of lease or whatever you want to call it, it would be incumbent on Carbon to plead statute of limitations. We could go to Carbon could make the hypothetical decision to go straight to trial without ever pleading its affirmative defense of limitations. And so I don't want the procedure here, because this is so sloppy, to be missed. What Mr. Kilday is saying is that his clients are pleading a defense to a cause of action that doesn't exist and making a decision for Carbon. There's no statute of repose. No guillotine comes down on a cause of action automatically after so many years. Someone must plead the defense. And what he purports to do here is plead the defense for Carbon. I want to make, so as we talk about this 82 designation of unit, the court will recall that that was only as to the Austin Chalk Formation and only at the depth interval of 10,800 feet below the surface. Mr. Kilday, if we look at the, he told you that the chalk, that you would go find the chalk at 10,800 feet. He told you in his remarks that it is the plaintiff's position that 10,800 feet is the base of the chalk. Let's look at what their experts swore to and what is in the summary judgment record at Exhibit 5. And in paragraph 7, what their expert swears to is that you won't, while we've heard all this fuss about the 82 designation of unit that they discovered at some time after July of 2019 and want to say has been ratified, what their experts swore in this summary judgment record that'll go up on appeal is that 10,495 to 10,596 feet, those depths define the top and the base of the Austin Chalk Formation as the Austin Chalk was encountered in the Schnitzer-Riddell #1 wellbore as measured by the Schlumberger induction electric log. So we've heard all of this fuss about, well, I looked at Webster's dictionary and this is how it defines a formation. And that 10,800 feet, because Mr. Kilday says so, is where the base of the Austin Chalk is. The proof he's put on in the summary judgment record is that his statements are categorically false, and the court can go down the well bore of the Schnitzer-Riddell #1 well, and you at 10,800 feet, which was the only precise foot that was purported to be pulled by the 82 designation, and you're not, according to his own expert and according to his own summary judgment proof, you will find no Austin Chalk at that depth, period. But let's continue on. He's given you no case in the universe that says that the Texas Supreme Court's holding in Sampson from 2017, this is a recent case, that holding should be stood on its head and that this court shouldn't follow it, or that these facts dictate some different legal framework. And what that speaks to is that pooling is valid only if done in accordance with the method and purposes specified in the lease. That is the only way pooling is valid. And a pooled unit that does not comply with the terms of the pooling agreement is invalid and unenforceable absent the lessor's ratification. So what he wants to do, playing this game of a hypothetical claim that doesn't exist, and he stands in the shoes of Carbon and asserts a hypothetical defense that Carbon would not be required to assert and hasn't asserted, and says then that the 1982 designation of unit becomes valid because through some weird statute of repose argument, a guillotine comes down after 4 years and no one can ever challenge it. That's not what the Texas Supreme Court says about a unit designation that is unenforceable and void from its very filing. That thing is not enforceable. It's of no legal effect. There's nothing to be done about it unless and until the operator lessee would prove that the invalid unit has, through knowing, materially and knowingly, been ratified. So I'm going to address the limitations, the fraudulent concealment. I'm going to address discovery rule with evidence, but I do not want to lose sight of the fact that this entire exercise is created only by the sloppy pleadings and the plaintiffs trying to force us into a scenario that the Texas Supreme Court in Sampson said in 2017 you don't use. There's only one way to give effect to an invalid unit, and that's through proving a ratification of it. And he doesn't even have standing to do that. This is the Morris Buick versus Davis. Again, this is Texas Supreme Court case. This says that they are procedurally out of order. Where there's a defense that goes to the substance of what the plaintiffs are fussing over, it is not anything that has limitations applicable to it. Do you know why we're pointing out that since the year 1982 and under the holding of Sampson, the 82 designation of unit is void and unenforceable and was a nullity from day one? We didn't just decide one day that would be really neat to bring to Judge Wilson and tell him about. We're taking that position because the plaintiffs threw the rock decades late and filed this lawsuit. Under the clear holding of Morris Buick versus Davis, they are completely procedurally out of order and no statute of limitations applies categorically. But they want to say that hypothetically a cause of action accrued back in 1982, and that but they haven't showed when the cause of action would accrue, even according to them from a breach of contract standpoint, which again, breach of contract isn't what Sampson says we use. There are numerous cases that hold to this effect, but Archer versus Triegas is a Texas Supreme Court case. And what the Texas Supreme Court case said there is that this is consistent with the well-settled principle that one who already owns the land is not required to search the records every morning in order to ascertain if something has happened that affects his interest or deprives him of his title. Noting that registration of an instrument carries notice of its contents only to those bound to search for it, among whom are subsequent purchasers. And so, there's cases that have colorful language about you don't have to get your head off the pillow every morning and go check the deed records. And so what Mr. Kilday does is try to accrue a cause of action that is not asserted and doesn't exist against all of these defendants, hypothetically against Carbon, saying that in 82, they needed to get their head up off the pillow, run over to the real property records of Karnes County, Texas, and check to see if their title has been disturbed unlawfully over 20 years outside of the lease's terms. There's no such obligation in the world as to any of the defendants or defendants' predecessors in title back in 82 when this thing was recorded to take their head off the pillow and go search the real property records to see if something's been recorded that would have been outside of any kind of permissibility under the oil and gas lease. That's black letter law, and there's piles of cases interpreting this and applying this same principle. With respect to the current defendants that are before you, they talk about, well, they bought, when these defendants bought their interests or acquired their interests, they should have searched the records and seen this 82 designation of unit. Well, to play the hypothetical game that's absolutely inappropriate to play, procedural and legally, to play that hypothetical game, here's what you would have seen. You would have seen a void and unenforceable 82 designation of unit. You would have seen no production ever once established out of the void and unenforceable designation of unit. You would have seen a lawsuit filed by Mr. Gaddy against Carbon in the year 1997, and a complete and utter release of all Frel's oil and gas lease in the year 1997, specifically March of 97. And at that point, you would have been satisfied. There's nothing more that you couldn't have sued Carbon some extra to get some extra release. The 82 designation of unit was void on its face, purported to pool only a lease. And in 1997, the entire world was placed on notice that, and this is in our chain of title, that the Frel's oil and gas lease was released and of zero effect. The presentment requirements, all the different things Mr. Kilday wanted to point to contained in the Frel's lease, that lease evaporated off of the face of the planet in March of 1997 at the absolute latest. Let's talk about the timeline. Again, we're going to be intellectually precise here, not sloppy. Up to April of 1992, the Schnitz-Rydell well was producing out of the Upper Edwards limestone, just as the 1964 designation of unit, the valid one, required. And so the first time that, according to these plaintiffs, there would have been any production in the world outside of the 64 designation of unit comes about in April of 1992. And that's Exhibit O. That is the dialogue where we see that the concrete plug was set on top of 10,790 feet. And we know in February of 1997, the Frells well that was producing from the Frells track stops producing. And so that's when the guillotine comes down. And as to this alleged term defeasible MPRI, there's no longer any production from the Frells track, and they want to start looking around to try to find constructive production substitutes. And the only well in the world that they can point to is the Schnitz-Rydell #1, which isn't on the Frells track. And up until middle of 2019, they were pointing at the 64 designation of unit. Only now do they start pointing to the 82 designation of unit. And so again, so the relevant question is not limitations or fraudulent concealment or discovery rule. It's, was there a ratification during this 4-year, 11-month period, which requires knowledge? But a lot of the elements touch on and are similar to the fraudulent concealment and the discovery rule pieces. And so I want to talk about that. And I'm just going to note, these plaintiffs have been very careful in days of presentation to not say 82 Schnitz et al. Oil unit. They don't like the fact that that thing in the public record was called the Schnitz et al. Oil unit. They don't like the name of the unit because it is the Seinfeld well. It is the well that never was drilled. It was permitted, expired a year later. It was the well about nothing. It was the 82 Schnitz et al. Oil unit about nothing. Let's look at, in terms of fraudulent concealment, I think Mr. Kilday concluded his remarks saying, well, we could, these defendants could have just gone and looked at the commission records, and of course they would have seen that there was an injury here. Let's look at what you would have seen in the commission records. Well, we would have seen that this is called the Schnitz et al. Oil unit, pooled for Austin Chalk at 10,800 feet. Here is the application that was associated with the Schnitz et al. Oil unit. Again, they want to call it the 82 unit. They don't like calling it by its name. What is the API number for the well associated with it? Up in the top left-hand corner, the API associated with this application for the Seinfeld well is 255-00000. And the name of the Seinfeld well is Schnitz et al. Oil unit well. And you can see in the bottom right-hand corner, that's April 28th of 1982. Let's look what else that somebody peeling through the commission records would have found. They would have seen a permit granted associated with the Seinfeld well. And the permit, if you look at the API number up in the top left-hand corner, again, for a well called the Schnitz et al. Oil unit well, that API is 42-255-00000. And it said that the permit was issued back in, it's difficult to read there, but the summary judgment record is going to reflect that permit issued in May of 1982. Let's look what they would find next.
Give me a second, please. Go ahead. That's a deputy. I'll message him.
Thank you, Your Honor.
Didn't have phone back on vibrate.
We're playing Mr. Kilday's hypothetical game of going through the commission records because he just told you unequivocally that it was uncontroverted. You would have discovered that there was production from the Schnitz et al. Oil unit and that there was some validity to this or some need to do something on the Schnitz et al. Oil unit. What you would have next found was that at the bottom left hand on May 20th, 1983, the permit to drill the Seinfeld well expired. And again, it's still being called the Schnitz et al. Oil unit well. Let's keep going through the commission records. Well, in 1992, when Carbon illegally and fraudulently lies to the commission and recompletes into a new shallower zone and field and formation without telling the commission, they lied to the commission. There's no fact issue there. Everyone agrees they lied to the commission and agrees it's a felony. And you can see in box 12 that they told the commission that that was still the Davy Edwards field unchanged. So that's what one would discover in 92 when for purposes of Mr. Kilday's ratification argument, we would start looking because that's the first time that there is no longer oil out of the 1964 Schnitz-Rydell unit. Well, if you look at the commission records, it says that it's still out of the Schnitz-Rydell unit, and it's still under API 4225500198 up at the very top of the page. That is the API not associated with the Seinfeld well. That is the API number associated with the Schnitz-Rydell well that's been producing from the Upper Edwards Limestone Formation since the 60s. And we can see on the bottom left-hand corner, this is a public filing as of 8/24/1992. What did the plaintiffs, what were they telling this court with the duty of candor on them and with the duty of investigation on behalf of their clients? Their Fourth Amendment petition, this is July of 19. Here's what they're telling the court. They're telling the court that in January of 64, Shell and Standard Oil formed a pooled unit containing 80 acres named the Schnitz-Rydell unit. I agree with them on that. A portion of the Frells tract, the road, is included in the Schnitz-Rydell unit as permitted by the Frells lease. The Schnitz-Rydell well was classified as an oil well, and all production from the Schnitz-Rydell well was treated as production from the Schnitz-Rydell unit at all times from 1964 until the Schnitz-Rydell well ceased to produce in paying or commercial quantities in spring of 2014. So as we talk about our relevant period of time being between 1992 and 1997, these plaintiffs are not telling you that this was the Seinfeld well. They're not telling you that this came out of the Schnitz et al. Oil unit. They tell you exactly what they meant and exactly what they intended and exactly what the parties suffered under, being believed that based on the lies and the fraudulent reporting by Carbon, that the production was out of the Schnitz-Rydell unit. If Mr. Kilday wants to come in here and say that the defendants, well, obviously they could have discovered this was coming from the Seinfeld well or from the Schnitz oil unit. He is a licensed attorney with a duty of diligence on behalf of his clients. Why, as of July of 2019, hadn't he exercised the diligence that he now tries to hold us to somehow look at the commission records better or different? Or the point is, there's nothing in the universe in the commission records that would have led anybody to believe that the Schnitz-Rydell well was producing from the Schnitz et al. Oil unit. And that's because it was fraudulently concealed by Carbon. And I assume Mr. Kilday relied on that fraudulent concealment when he brought the court his Fourth Amendment petition in July of 2019. Well, let's see what Carbon says. The P4 operator of the well, if they say that this was the Seinfeld well, if they say that this was in any way under the 82 Schnitz et al. Oil unit, they say no. He's being shown at Exhibit 61, the Schnitz et al. Oil unit paper, and it's asked, with respect to this designation of pooled unit, during the time Carbon was operator, you never purported to pay any royalties pursuant to or giving effect to the designation of unit, did you? He said, I don't believe we did. And so the court asked the question the other day, were royalties ever paid under the Schnitz et al. Oil unit, i.e., is there a fact issue on ratification? And what the oil and gas operator Carbon said here unequivocally is that they never purported to pay royalty under the Schnitz et al. 82 oil unit. So obviously no defendant could have ratified the Schnitz et al. Oil unit or ratified any production because the operator wasn't even pretending to pay or intending to pay or actually paying under the Schnitz et al. Oil unit. The P4 operator of the well was asked, did you ever receive any lawsuits from a mineral owner or MPRI owner during Carbon's period of operatorship alleging unitization or communitization or any validity to the 82 Schnitz et al. Oil unit? No. Are you aware of any party ever during the entire time of Carbon's period of operatorship, any party ever behaving as though or taking the position that Exhibit 61 was a valid designation of pooled unit? No. So to answer the court's question perfectly squarely, the idea of ratification of the Schnitz et al. Oil unit or the Seinfeld well about nothing, straight out of the P4, P5 operator's mouth, it was their testimony that no one, inclusive of them, ever gave any validity, ratification, acceptance, anything in the universe as to the Seinfeld well or the Schnitz et al. Oil unit paper. There was no controversy Mr. Kilday talks about declaratory judgment. What lawsuit would have been served in the year 1982 or at any time thereafter when the P4 operator isn't giving any effect whatsoever to the void and unenforceable paper? With respect to the, we're continuing to look at the public records here. And again, we're just looking for a scrap of evidence that anybody was purporting to operate the Seinfeld well, or that anybody was purporting to operate under the Schnitz et al. Oil unit. This is the form P4 that I just mentioned to you. This is contained at the plaintiff's exhibit 2D. This is your P4 well responsibility. You got to have a P5, which is operational organizational authority to operate wells in the state of Texas. You got to have your bond on file and other requirements. And if there's an API number in the state of Texas, that you're going to have a P4 that assigns to that API a P5 operator who's responsible. This is the form that was filed on May 5th of 1983. There was a change in P5 responsibility associated with the Schnitz-Rydell well. And what did they say in 1983? This is after the 82 Schnitz et al. Oil paper that Mr. Kilday has admitted his entire case now hangs on, that he didn't even know about until July of 19. The new P5 operator with P4 responsibility for the Schnitz-Rydell unit well is Great Western Production Company. And what they say is not that this is a Schnitz et al. Oil unit well. They say it's the Schnitz-Rydell unit well, perfectly consistent with this being covered under the 1964 designation of unit, with the well producing from the upper Edwards limestone. This was filed on May 5th, 1983. Again, this postdates the Schnitz et al. Void and unenforceable paper. Very soon thereafter, P5 status and P4 responsibility transfers to Carbon. That's contained in Exhibit 2A. That's what you're, I'm sorry, 2E for the record. This is, you're looking at the P4 that was filed in June 22nd of 1983. So this postdates Mr. Kilday's vital Schnitz et al. 1982 paper that he says his whole case hangs on now. And what did Carbon now in June of 1983 say? Did it tell the world or tell the commission that it was purporting to operate the Seinfeld well? No. Did it tell the world or tell the commission that it was purporting to operate under the Schnitz et al. Oil unit of 1982, a year and a half before this? No. What up at the top, the legibility is bad, but at the top you can see that they are telling the commission that they are continuing to proceed under the Schnitz-Rydell unit, the 1964 designation of unit that which is where the well was producing from. Let's look at 1992. When they illegally recomplete out of the Upper Edwards Formation. What did Carbon tell the commission, and what did Carbon tell the world? Did they tell them that they were giving any validity, or that someone is ratifying or accepting benefits from the Schnitz et al. 1982 oil unit that Mr. Kilday hangs his case on? No. What Carbon told the world in 1992 was that they were proceeding in the Davy Edwards field, that's up in field name box 1. They told the commission and the world in box 12 they were producing from the Davy Edwards field, that was unchanged. And they told the world that they were proceeding under API number 42-255-00198, and that being the Schnitz-Rydell unit well. There's no way to ratify the Schnitz et al. Oil unit well, because Carbon's already testified, and that's in the record uncontroverted, that they didn't intend, never gave any effect to the 1982 Schnitz et al. Oil paper. And if you look at the public records, the Schnitz in the 92 filing, they are not saying they're giving any effect to the other. What they're telling the world and the commission is that it's the Schnitz-Rydell unit. Well, let's look at the production reports. Maybe the production reports helped the plaintiff's case. Maybe the production reports said that, in fact, here they were proceeding under the Seinfeld well, or proceeding under the void and unenforceable Schnitz et al. 1982 unit that the operator, the P4 operator and P5 operator said they weren't proceeding under. Well, they also told the world, you can see here from 1993 on in Plaintiff's Exhibit 2G, that they were proceeding not on the Seinfeld well or the Schnitz et al. Oil unit well, but they were proceeding on the Schnitz-Rydell unit well. And so that's what you would see every single month. If you went and pulled that, if you go pull the production records every single month, it's going to be reported that it's the Schnitz-Rydell unit, the 64 unit that they're proceeding under, not the 1982 Schnitz et al. You could even go all the way to the field office and get the paper copies. That one's going to be the exact same thing, going to be no different. And that's going to be for the API number associated with the 1964 unit and well. All right. Yesterday I made a fuss and said, ask Mr. Kilday to show you one scrap of paper during the relevant time frame of 1992 to 1997 where any party, I don't care if that party be plaintiff or defendant, received 1 penny of royalty associated with the Schnitz et al. Oil unit, or for that matter, even the Schnitz Rydell well. And he didn't do it. He didn't show the court one single check or payment or anything that would have been received by any party in the universe during that period of time. But I'm going to show you, I went through his evidence. Here's the closest thing that Mr. Kilday can get to as we talk about ratification being the proper inquiry under Sampson. At the bottom left-hand corner, you can see that this was issued on January 15, 1998. So this is after the guillotine has already come down in February of 1997. So this is an entire 11 months later that the guillotine comes down on the alleged MPRI interest. And let's see, it does pertain to 1 month that would be in the relevant period. Let's look at it. So again, the payment would not have been received. No one could have ratified or anything like that. Even if you just scratched out Schnitz-Rydell unit and called it the Schnitz et al. Oil unit, it wasn't during the relevant 4 year and 11 month period to be precise. And after the 4 year and 11 month period, you can't have a zombie MPRI. There's no case that any plaintiffs cited to you that a dead and expired zombie MPRI comes back to life or rises from the dead. But if you'd looked at your check, you were not getting production from the Schnitz et al. Oil unit. You were ratifying no production out of the Schnitz et al. Oil unit. There was a grand total of 1 penny. So we're going to talk about production and paying quantities here in a moment on the defendant's no evidence motion here. But you would have seen that there was a grand total of 1 penny for the month of February 1997 that doesn't show up for an entire year later. And that would have been reported not to the Schnitz et al. Oil unit. That would have been to the Schnitz-Rydell unit instead. And then actually they didn't even get the penny, because if you look down, there were costs of sales. That's another thing we'll hear about. Their expert, their alleged PPQ expert decided that these wells don't have any cost, that these are the only wells in the entire state of Texas that operate cost-free somehow. But you can see they even had 11 cents taken out, so they didn't even get the penny. Mr. Kilday doesn't show you that because there's no records of any ratification or acceptance of royalty. The best he can do is that's just 1 plaintiff. That's all he's got in this whole in the whole case there. Is checks not during relevant period of time for nickels associated with the Schnitz-Rydell unit, not the 82 Schnitz et al. Oil unit that we started this discussion about. He says that there were decades of acceptance of royalties. Well, I've already shown the court that the only relevant time frame, the decades, is theatrics and posturing and sleight of hands. Up until 1992, the Schnitz-Rydell well was appropriately producing out of the Upper Edwards Limestone Formation. There's nothing to fuss about as to the production out of that well. And we know that in March of 1997, the Frells lease is released. There's no more constructive production, even under their view of the world, after March of 1997, because only the Frells lease was pulled and the Frells lease was released in its entirety. And so we're not talking about decades of acceptance of royalty, even though he has zero evidence in the record of a defendant receiving 1 single nickel. The period to talk about is that 4 years and 11 months. And so the whole idea of, well, presentment should have been made. Look, there's a clause in the lease that gives Carbon an opportunity to fix things and do it right. there was nothing to sue over after March of 1997. And in fact, Carbon had already been sued saying, give me the entire lease back. And Mr. McFarland's references earlier that Mr. Frells didn't, or the Frells successors didn't intend to release the road tract. They wanted nothing in the universe to do with Carbon. They wanted all of the leasehold. I don't care if it's located on the moon, back from Carbon, because Carbon was an unscrupulous and inept operator, period. This is the defendant's response. I'm sorry, this is the plaintiff's response to motion for summary judgment. What are the plaintiffs telling you? This is today. I don't have to go back to their petition in the middle of 2019, their Fourth Amendment petition. What are they telling you today? What they're telling you today in their papers filed of February 1st, 2021 is that in 1964, Shell and Standard Oil formed an 80-acre pooled unit, including a 1.85-acre portion of the Frells tract for production from the Edwards Formation, the Schnitz-Rydell unit shown in red above. Okay, they've told you that the unit is called the Schnitz-Rydell unit and that unit is the one back from 64, not the 1982 Schnitz et al. Oil unit that he tells you now is his life preserver. He mentions in the next paragraph there that in 1982, Shell and Standard Oil created a second pooled unit covering the same lands as in the previous designation of pooled unit for production from the Austin Chalk Formation. He doesn't tell you that it's at precisely 10,800 feet. He doesn't tell you that, according to his own expert, there is no Austin Chalk Formation at 10,800 feet. He doesn't tell you the name of that unit because in this case, for the plaintiffs, Schnitz et al. Oil unit is a bad word. They want to keep that thing put away because they know that it's the well about nothing. It's the Seinfeld well. And they know that it's and they know that the Frells lease was released in its entirety. They know that the permit expired. They know that no one in the universe, certainly never in any commission records or on a check record or anything else, gave any vitality, validity whatsoever to the Schnitz et al. Oil unit. Those are two different things. And so every time we look at every reference in all these papers to the Schnitz-Rydell unit, there should be no confusion. What everybody is intending and referring to by Schnitz-Rydell unit is the paper that was filed in 1964 to cover production from the Upper Edwards Limestone Formation, not this silly 1982 Schnitz et al. Oil paper. Carbon was asked, as we talk about decades of production, Mr. Kilday keeps waving his hands over decades of production. He doesn't have one single check in the universe or one single payment in the universe to any defendant in this case, not one. So he points to Bob Brandt's testimony and he tells you, well, there's been decades of production. Bob Brandt says so. Here's what Bob Brandt said. Back in 2011, did you believe that the interest of the term royalty interest had terminated by virtue of the 97 release of Frells lease? Yes. Do you know how long Carbon continued to pay the term royalty interest owners out of production from the Schnitz-Rydell well after 97? I don't know. Do you know how long Carbon continued paying the Frells out of the production from the Schnitz-Rydell well after 1997? I don't know. But now, despite that Mr. Kilday's witness had no clue in the world who was paid, whether they were paid, what they were paid, and despite that he doesn't have one scrap of paper in the universe of any defendant being paid a nickel, he comes in and waves his hand and says, well, there's been decades of production and nobody's complaining. There's no evidence in the record to support what Mr. Kilday wants to do. His White Horse case, this is the only case cited for the proposition. Hay versus Shell Oil Company. His White Horse case comes out of the Corpus Christi Edinburgh Court of Appeals in 1999. What his White Horse case concerned was a designation of unit that was filed in 1977 that pooled 704 acres. And in his White Horse case, the oil and gas operator was 100% legally entitled to make that 704 acre unit under the lease terms. That his White Horse case is not a situation such as addressed in Sampson by the Texas Supreme Court in 2017. His White Horse case is the Corpus Christi Court of Appeals in 1999, talking about a unit that was validly formed in conformity with the lease terms. And then in 1989, the operator shall reform the unit to go down to 160 acres instead of 704. And at that point in time, the mineral lessors start looking around and going, hey, I think you formed that unit in bad faith. So it doesn't matter that the unit was valid because it was formed in conformity with the lease terms, which is not what is the case with the 1982 void paper from its inception. That one was valid. However, the question was, did they put acreage in it that was non-productive? Did they pool in bad faith? Even though they had the contractual right to do it that way, there's still the requirement that you can't put in unproductive acreage. And when you get all the way around to 1995, when the lawsuit is filed, the issue of limitations comes up. And what the Corpus Christi Court of Appeals, they didn't say that even in this situation where the unit was valid in the first place, that fraudulent concealment and discovery rule just categorically didn't apply. What the court said was that they didn't file their proof right. They didn't bring the right evidence into the record to put it on. And that basically one could have looked at the commission records and seen that the unit was out there at the 704. It was perfectly in conformity with the lease terms, no question about that. And they could have seen where the production was coming from at the Railroad Commission. There were no lies or fraudulent reporting to the commission in that one. And that they could have, at that point in time, done their own investigation to see whether, well, is this really draining or not? I mean, they've said it is. And that basically it was a battle of the experts as to whether a breach there had occurred or not. And even under that situation where there's been no line to the commission, where there'd been an actual, where there had been an actual validly formed pooled unit in the first place, the court said, we're not saying categorically discovery rule and fraudulent concealment don't apply. All we're saying is that here you're poured out for the reason that you screwed up your summary judgment presentation and didn't get the evidence and the pleadings in the right form. So with respect to the plaintiff's ask here, and again, that's their White Horse case. This motion that they had, this no evidence motion, is so procedurally out of order. I don't have a magic 8-ball where I know what the court's pretrial rulings are or how limines are handled or how pre-trial hearings go. And so he pled limitations. We don't know what he's saying. There's no cause of action whatsoever. Now, I would ask Mr. Kilday, is there a cause of action asserted against you that you've got a limitations plea against? There's not. He can't point to one. He can't show you a pleading of one. But if you continue through, but he's pled limitations. And so in response to that, I say, well, I think the fact that Carbon committed felonies between 1992 and 2014 and lied to the commission. And as we went through the entire relevant commission file here, no one in the universe could have told. I feel like that's pretty compelling and conclusive evidence of fraudulent concealment. And again, there's no, and you know, just do what you want with the procedure on the hypothetical claims and all that. They don't even have standing to plead a defense for Carbon of limitations, even if we did have a hypothetical claim. And again, there's no guillotine that comes down after 4 years. Even in his hypothetical world, Carbon would have to make the choice to assert that, and you would have to ignore the Sampson case saying it's not our burden to, it's the burden of operator to show that it's been ratified. It's not our burden to show that we haven't ratified or show it's void or anything else. So Your Honor, we'd ask the motion be denied. I don't think it's going to be material one way or the other to anything that is going on appeal or otherwise, but there's no basis for the thing being granted, period.
Anyone else on the defense?
Not from EOG, Your Honor.
All right, and briefly from the plaintiffs?
Yes, Your Honor, I'll be brief. I was glad that Mr. Waymeyer returned at the end of his presentation to the Hay versus Shell Oil Company case. It felt like we wandered around into arguments about the merits on traditional motions there for a good long while, issues about Greg Robertson's declaration where he identifies his view of the location of the Austin Chalk Formation. And on all that, I'll just say that, you know, we stand on the arguments we made the other day that the 1982 pooled unit designation specifies what is being pooled. And what is being pooled is 3 tracts for a formation. And the formation is specified in the designation as the Austin Chalk Formation. And it's our position that that's the specific, and the first thing that's said is that it's pooled for that formation. and that the description thereafter is nothing more than an estimate. And it certainly is Mr. Robertson's view that the estimate was off by a couple hundred feet. He puts the floor of the Austin Chalk a little bit higher in the hole, a little bit closer to the surface. But that doesn't change the effect or the enforceability of the pooled unit designation. It specifies that it's pooling for the Austin Chalk formation. And it's clear that for many years after 1992, oil was produced from that well, from the Austin Chalk formation. Now, why does any of this come up in the lawsuit? There's a discussion about this being a mess procedurally. Our lawsuit simply seeks to say that the term royalties were perpetuated by production, which is what the records show. The records show that there was production continuously through June of 2014 from the Schnitz-Riedel unit. And that's a unit that the plaintiffs participated in until they were cut off. The cutoff was, well after the 1997 release of the Frells lease. We talked about that. Well after 1992, well after 1972, the plaintiffs continued to participate in that production. The defendants continued to participate in that production. And the key issue under the term royalty deeds is, was there production in paying quantities? The records show that there was production. And we got a battle of the experts on whether that production was commercial or paying quantities or not. They've got an expert. We've got a very qualified, experienced operator who's given an expert opinion about what a reasonable and prudent operator would do and his own analysis of this well. And so that's really the trial stuff, and really isn't the subject of the motion. But because Mr. Waymeyer went into that, I wanted to respond. But I am glad he came back to the Hay versus Shell Oil case, because that really is more on point with what this motion deals with. And I'll go back to the share screen here. So here's where we are, coming back to what the motion's actually about, which is these two defenses that have been raised by the defendants, fraudulent concealment and the discovery rule. We didn't hear much about those two defenses until the very end, but I'm glad we got to it. But fraudulent concealment, the discovery rule, that's what we're saying, that the defendants have no admissible evidence to bring to the court, and that should be adjudicated as a matter of law. And the Hay case is a case for improper pooling. Now, Mr. Waymeyer described the facts of that case. There was a properly formed pooled unit. Just like in this case, there was a properly formed pooled unit in the 1960s for the Schnitz tract, the Riedel tract, and the 1.85 acre portion of the Frells tract. Properly formed unit in both cases. And then the operator took action to improperly pool other lands. And in our case, the operator took action that the defendants maintain was improper for pooling at a different formation. Why was it improper? Well, the defendants argue it was improper because it breached the Frells lease. And what the Hay case says is that the limitations defense about improper pooling, which is the defendant's argument here, was barred by limitations because it was not filed within 4 years of the triggering event. And the triggering event in the Hay case, the act causing the legal injury, was when the new unit was formed, when the larger unit in that case was formed. Here, if you believe the defendant's allegation, it's when the new unit was formed at a different formation, the Austin Chalk formation. But in Hay, what we learn is you got 4 years to bring that claim. If you don't bring that claim, you're barred from doing so. And it doesn't matter whether there is or is not production pursuant to that newly formed unit. The injury is the formation of the unit. And here, what we are saying is that the 1982 pooled unit allowed for production out of the Austin Chalk formation. And while it's true that for many years that production was reported as coming from the Edwards, ultimately, legally, it didn't matter because there was a pooled unit formed in 1982 that no one timely objected to that allowed for production where this production came from, which was the Austin Chalk. And it doesn't matter whether Mr. Brandt did or didn't know about that. It doesn't matter whether the defendants did or didn't know about. The reality is that there was a pooled unit formed in 1982. It was recorded of record, and the defendants took no action to contest the formation of that pooled unit. And so I want to take a look at a couple of cases that we've already talked about in connection with the traditional motions for summary judgment about the discovery rule, and the same principles would apply to fraudulent concealment. The discovery rule doesn't apply to a claim for improper pooling. And we talked about the Hecky case, which was a case about breach of a lease and injury to a common reservoir. And the court held that the claim was time barred. And the reason it's time barred was because the discovery rule didn't apply. Why did the discovery rule not apply? Because the underlying facts that would put someone on notice of that claim were not inherently undiscoverable. Why were they not inherently undiscoverable?
Because they were receiving payments under the pool?
Well, it's because the filings and materials were of record in the Railroad Commission. That's what the court looked to in Hecky. And similarly, we've got the Wagner Brown versus Horwood case, not Wagner and Brown versus Shepard, but similarly a breach of lease claim for underpayment of past royalties. Here, we didn't even have Railroad Commission documents. There was simply a right to obtain the records from the operator that was available to the lessors. And because they did not take advantage of that right that they had under their lease, these claims were time barred in the Horwood case because the facts were not inherently undiscoverable. And the same applies here. Third case is the Marshall case in 2011, BP versus Marshall, suit for breach of a lease, claim that there were not good faith efforts to develop the lease. And the court held that that claim was time barred. And again, the underlying facts were not inherently undiscoverable. And the basis of that ruling was that the information was available from Railroad Commission documents. So here, clearly the defendants could have learned about the formation of this pooled unit and brought a claim. They did not do so. And because of that, it's our contention that they cannot now go back and retroactively rewrite history and pretend that the production that generated royalties was not for the benefit of the unit. It was for the benefit of the unit. That's how it was reported and treated and paid. And that's how dollars were put in people's pockets for all those years. So those three cases teach us that a claim for breach of lease is time barred when it's filed more than 4 years after the triggering event. And the triggering event is based upon what documents are obtainable. And you can only use the discovery rule where you can show that the underlying facts were not inherently undiscoverable. And here, documents were available in the public records, including the Railroad Commission documents, including in the real property records of Karnes County. So that's just not inherently undiscoverable. The defendants missed the mark in how they argue this. Our claim and contention is, our claim is that what they are asserting in this lawsuit is time barred and waived and barred by quasi-estoppel, because what they're claiming is that you shouldn't count that 1982 designation. You should write it away because it breached the Frells lease. That's what they're contending in this case. And they've said so in their pleadings. And they're asking the court to disregard all production after 1992 because they allege that the chalk pooled unit designation in 1982 violates the Frells lease. And what we're saying is that you waived your right to make that contention. You're barred by quasi-estoppel in making that contention. And for purposes of this motion, you're also barred by the statute of limitations. All that information to support any such claim was available in 1982. Mr. Waymar asks, what lawsuit would have been filed in 1982? Well, it would have been a claim for breach of the Frells lease. It would have been a claim for improper pooling. If they wanted to complain about that pooled unit designation, they had a mechanism to do that, and they simply waived it, and they simply allowed it to become barred by limitations. And the Hay case makes that clear, that the act causing the legal injury is when the pooled unit was formed. They didn't file that claim, and it's our position that this partial summary judgment on no evidence grounds should be granted as to fraudulent concealment and as to the discovery rule. And I thank the court for your attention.
All right, I think I have a good understanding of everyone's positions on this. We're going to take a break until 2:45. We'll come back at that time and start the next point.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, I'll be back in just a moment.
Hey, Corey or Bob, I forgot what time the judge said he needed to leave today.
5 o'clock.
Yeah, 5. Was it 5 or I thought it was 4 something? Okay.
All right, there's Ms. Cavazos. All right, all right, so what's the next?
Your Honor, the next motion is the defendant's motion for no evidence judgment.
All right, and Mr. Wimar, I had muted my speakers actually. So we're looking at what?
The next one up is all of the defendant's no evidence motion for summary judgment.
Okay. Is that number 8? Is it one of the numbered ones? Is it one of Sierra's?
Your Honor, it's number 6.
Number 6, okay.
Number 6 by DDR Gaddy and Bressler, and also there's some pages in the Sierra Bank motion that also assert no evidence, Your Honor.
Okay, all right. Go ahead, sir.
And a lot of this will dovetail with some of the evidentiary objections that we have, but I'm going to go through it, and I might highlight some places that we're going to have to talk about what they cite as evidence. But I'll just start with saying that credibility is key and is the only thing that I have when I walk into your courtroom, and candor is required. I've mentioned throughout the course of these hearings that there are freight train sized holes in the requisite proof plaintiffs bear that they have no hope whatsoever in me. This motion has been waiting for 2.5 years to be heard. And today's proof day, today's evidence day. The plaintiffs don't have evidence, and to the extent that they reference any, it's hand waving over inadmissible pieces to which unfair extrapolations have been made. And one of the freight train size holes in their case is that we've discussed the production and paying quantities being the single thread that their case would have hung on, requires expert testimony. And Mr. Kilday said that on the record yesterday, that all of the production and paying quantities discussion is technical and expert. The record will bear that out. And when we pointed out in our no evidence motion for summary judgment that they left a gaping hole in their case and that they didn't even attempt to prove the expert or technical aspects of production paying quantities between 2014 and the present. This is what Mr. Kilday put on the screen and showed you. And I objected at the time and I fussed. He said, look, here's our evidence. Defendant EOG began drilling Eagleford wells in the Frales Tract area in 2013. In March 2014, the Lynch unit, a new unit which included portions of the Frales Tract, began producing in paying quantities. EOG subsequently drilled additional wells that include portions of the Frales Tract and form pooled units. The pooled units include the Lynch unit, Colleen unit, Kilimanjaro unit, Walter unit, Elbrus unit, Josie unit, Blanc unit, and Cosbeck unit. These units include several wells per unit. He said, we have an expert to talk about this. Look, right here, she says there's production paying quantities. It's Idalia Romanos. What he didn't tell you is that she's an accountant. She just gets numbers and she calculates what she alleges would be due royalty payments. She is not the production and paying quantities analysis expert in the case, and they have none for the year 2014 to the present, which is years and years that if this was put to a jury would be a complete waste of time. We would have to wait and make a directed verdict. We would have to object if they try to do anything during that gap, and then we'd have to make a directed verdict, and everybody's time would be wasted. Well, here, and I fussed at the time, here's the truth. Let's take a look at where Mr. Kilday pulled that out of to show you his evidence from his expert. The background section from Ms. Romanos' report. And what she starts with is saying is the following background is based on information provided in the plaintiff's Fourth Amendment petition. This is not her opinion. And the paragraph that Mr. Kilday showed you came from the second full paragraph that was just her repeating what came out of the plaintiff's pleadings. And pleadings, as the court knows well, under Rule 166 AC aren't evidence. She said, goes on, the plaintiffs maintain that the unit was producing and paying quantities. The plaintiffs maintain that because the MPRI was in effect when it began producing, they're entitled to a term royalty interest. The plaintiffs maintain that their term interest was still in effect when EOG began drilling wells. She formed no such opinion, and that was absolutely misleading to suggest to the court otherwise. And the court can look at her deposition testimony because she swore it. I wanted to avoid exactly this kind of a situation that we're here. I asked her, this is the plaintiffs maintain, I'm quoting from it. And I asked her, we might be able to cut off some of this fuss here. With respect to all of the section 2 in the background, are any of those your opinions, or are you just regurgitating what was written down by the plaintiff's lawyers? I'm just repeating what was in the petition. All you're doing is repeating what the plaintiffs have said. These are not matters that you personally investigated or that you personally have any opinions or thoughts about that. That is correct. That's the evidence they showed you. That, if you could have seen the whole page back when I was fussing at the time, she said she was just regurgitating what Mr. Kilday wrote down on a piece of paper. And here's the sworn evidence that that's what was all she was doing, was regurgitating what was said, and that was not her opinion. The Romanos designation, this is from the plaintiff's live and current designation of experts. There's nothing in the world about Ms. Romanos, a number cruncher that looks at royalties, royalty payments to crunch royalty payments, has any technical expertise in the world. My guess would be she's never set foot on a well site in her entire life. But she's certainly not designated as having any opinions or knowledge or technical expertise about how costs are calculated. You know, what does soap to put down the well cost? What does electricity cost? What's a pumper cost? What type of burdens need to be attributed against revenue from a tax perspective, marketing perspective? She's not an expert on any of that. She's certainly not an expert on reasonably prudent operator standard. And I want to set the tone on that here briefly. The court knows well, there's many Texas Supreme Court cases that, from Clifton versus Coons to the recent LADEX, that enunciate how experts prove production paying quantities. And that's the technical analysis of recurring expense against profit, against revenue to arrive at profit, and where it's unprofitable over a quote reasonable period of time. Would a reasonably prudent operator continue to operate the well in that condition with an expectation of profit as opposed to mere speculation? That's the test. That's the relevant test. All of it expert. And in this case, the plaintiffs have zero of that after the year 2014, zero. And for that reason alone, it's appropriate to grant the no evidence motion for summary judgment disposing of the plaintiff's entire case. The declaration of Greg Robertson, I showed that earlier. Again, in terms of where production comes from, Mr. Kilday told you in unequivocal terms that the base of the Austin Chalk was at 10,800 feet. But his expert and in his summary judgment evidence tells you exactly contrary. And now he tells you, well, maybe his expert, the man who claims to be the father of the Eagleford, was off by a couple hundred feet. The Eagleford Formation is about 200 feet in depth. So what Mr. Kilday just told you in his most recent remarks is that he's right. The father of the Eagleford expert is wrong, and that his expert's off by approximately the entire depth of the Eagleford. I would be curious to know where Mr. Kilday got the evidence in the record to tell you unequivocally earlier this week that the base of the Austin Chalk is 10,800 feet, other than he needs it because the 1982 Schnitzel oil unit, which is the bad word in this case, is his lifesaver and doesn't help him. Let's talk about the way that they've handled their response. The court's going to see this. As you look at their response, there's not citations to evidence, any particular evidence in whole, part, and parcel. There are places where certain things are cited. The court needs to actually look at it because as you peel it back, that evidence doesn't stand for the proposition urged. But I just want to make sure the court recalls the standards on summary judgment. The bottom quote, that's a San Antonio Court of Appeals case from 2006. It says, when a summary judgment respondent fails to direct the reviewing court to specific summary judgment evidence, a fact issue cannot be raised sufficient to defeat summary judgment. Holding neither appellate court nor trial court is required to wade through a voluminous record to locate summary judgment respondent's proof, and that attaching entire documents and depositions to a motion for summary judgment or to a response and referencing them only generally does not relieve the party of pointing out to the trial court where in the documents the issues set forth in the motion response are raised. So again, the plaintiffs have attached approximately 4,000 pieces of paper. As you look at the paltry response that's 23, 24 pages, something like that long, I would just ask that the court keep in mind what the standard is in terms of how you meet with proof the summary judgment burden you've been put to by the no evidence challenge. The first cause of action, let's talk about this. They asked the court to declare that they are the owners of their proportional shares of term royalties granted in the Frills Tract and that the interests have been held by production and remain in effect. That they are entitled to recover the proportionate shares of all royalties in units. Unitization, so now what they're asking for is they want to be treated on a unit basis under the 2010 oil and gas lease and the leases that came later in time. And even under their view of the world, under Montgomery versus Rittersbacher, if the term MPR, if you ignore that they have zero evidence in the summary judgment record of the technical showing required of production paying quantities between 2014 and the present, which has been properly challenged, absolutely. Ignore that. What they tell you is they want to be treated as though they ratified EOG units and EOG leases that came in 2010 and later. But what's clear from the Montgomery case, and I mean, this is just piles of black letter law, is that a ratification is only effective on a going forward basis. You cannot make your ratification retroactive. And in response to this no evidence challenge, they say, well, we ratified by filing our petition in July of 18. The problem is their title expert, Mr. Starr, that I mentioned earlier, who does not have a law license, but who accepted compensation in the state of Texas for rendering a title opinion. All of his decimals are unitized as though these plaintiffs had ratified according to them back in the year 2010 or 2014. And so now the plaintiffs say, well, we would be ratified from July of 2018 forward and get to participate from July of 18 forward. But that's not the proof that they've developed for the court. Let's look at the proof. We challenged their ability to prove any chain of title. And the closest they can get to that is a conclusory, self-serving declaration out of the landman that practiced law, Starr. And if you look at their Exhibit 12, what he says is that he's built a run sheet complete through September 13th, 2018 at 7 a.m. So as a basic matter of proof, these plaintiffs wouldn't need to prove their title as of September 13th, 2018. They would need to prove their title as of the date of trial. And under, check me on my rule reference, I think it's Rule 63. the summary judgment hearing date is treated as the time of trial. They've got no proof whatsoever, even if you accepted an unlicensed person's title opinion for the relevant time frame, leaving a huge multi-year gap. According to their proof, that would also be in the appellate record. That would be part of the issues challenged here. Again,
Okay, but Mr. Wiemeyer, isn't that just an ongoing issue in oil and gas litigation, that if you have to have proof through the date of trial for what your losses would be for lost revenue, there's always a gap between when you have your numbers and the date of trial? You would never be able to go to trial because every month there'd be another month's worth of production.
In my experience, Your Honor, with respect to calculation of royalties, that would be an ongoing thing, and there would eventually have to, you'd either, depending on the type of cause of action, you might be able to calculate them on a going forward basis and present them all at once and get them all at once, or otherwise. But with respect to title, what you're required to do on title is have a proper abstract. And I mean, Mr. Trust and I've had cases, we've got abstracts as high as the ceiling piled around the room. And what's in the summary judgment proof is that these folks didn't start Sovereign and they didn't work forward from Sovereign. They didn't prepare an abstract. And the expert, the landman, said that he omitted documents that are in the chain of title, and that he used in forming his title opinion documents that are not recorded in the Karnes County records. And even then, with respect to cutting off in 2018, again, that doesn't, that's 2+ years gap that remain unclosed.
All right.
Here, the plaintiffs, this again just exposes that they have zero production and paying quantities, expert testimony, competent evidence to fill the gap after Carbon stops operating and after EOG starts operating. They say, well, EOG's produced a bunch of royalty. That has nothing to do with the production and paying quantities analysis. PPQ requires an analysis of revenue against expense. It doesn't matter how many royalties are generated. The relevant inquiry that they've never done is what's it costing to operate the wells. There's zero evidence whatsoever after Carbon stops in 2014 to close that gap to the present day. That's why they keep desperately trying to point, one of the reasons they keep desperately trying to point to that 2013 agreement between Carbon and EOG. And here they phrase it: the key issue and dispute in this lawsuit is whether the actual demonstrable production from the Farrell's tracts and lands pooled with the Farrell's tract during the period of 1962 through 2014 operated to perpetuate the term royalty interest that the Farrells sold to plaintiffs' predecessors in the early 1960s. That's not, they don't claim a fee perpetual MPRI. It's term defeasible, and they have left a 7-year gap in their proof. They designated no expert on this. Experts are closed. Robinson motions are filed. If this motion is not granted for their lack of proof between 2014 and the present, it just puts everybody to the waste of time of going through the case in chief and awaiting a directed verdict. And again, with respect to limitations, they have no case anyway, but that's a different point here. Again, continuous production is required. They told the court, they've waved their hands and said royalties were always paid, production was continuous, and that is verifiably false. This little thin strand of production that they want to, like I said, we've talked about every complete barrier to their recovery as a legal matter, but even if you ignored all those, let's look at the actual evidence. This comes from Plaintiff's Exhibit 2G, and there wasn't continuous production. I told the court about goose eggs. Here are the goose eggs. In October of 2010, 0 oil or gas production, 0 disposition. November 2010, 0 production, 0 disposition. December 2010, 0 production, 0 disposition. January 2011, 0 production, 0 disposition. And just the way that production shoulders, looking at this report, that means it was a minimum of 120 days of 0 production. And so what they want to say is that, well, there were continuous operations that were conducted with reasonable diligence. And so operations, not production, held the alleged MPRI interest for this period of time between October 2010 and January of 2011. Here's their problem on that. They did not designate an expert, and there is zero expert testimony in the record as to an operator's reasonable diligence during this period of goose eggs to conduct operations and restore production. Again, what is reasonable diligence is absolutely a technical matter. It would be categorically inappropriate for me under Rule 702 or the Robinson standards to get up and say, well, my name is Mr. Waymeyer, and I practice oil and gas law, and I'm around the industry a lot. And it's my opinion that because these things were done around the well, this was reasonable diligence. I don't have any technical expertise. I haven't been qualified as a technical expert to have that opinion or designated as one. And the closest they can get to is 2 paragraphs of conclusory testimony out of Bob Brandt, where in leading fashion they say, well, were you exercising diligence? And he goes, oh, yeah, I was exercising diligence. We've got our written objections to that. But even if you accepted it, even if the judge says, Mr. Waymeyer, you're crazy, that's not a good objection. They didn't designate him as an expert in the case. They have an attempt to qualify him as an expert. There is no showing of qualification. Even if you just take the paragraph that they have, there's no showing of a qualification for him to have that opinion. And we obviously would have filed a Robinson motion. If they had tried to designate Mr. Brandt, who had some kind of early onset something and some mental issues, we would have had, and based the utter lack of knowledge on anything, we would have absolutely had a Robinson motion on that. But they didn't designate him, so we didn't go through all that procedures. They can't, to close this gap of goose eggs, they can't use Mr. Brandt now, and they don't have any other evidence in the record that even comes close to that. But again, Mr. Kilday has continued to wave his hand over this case and say, there's always been production, there's always been payment of royalty. Not true. Not a shred of any evidence of actual payment of royalty to a defendant. And I can show you right here in their own evidence that there's at least 120 days of complete cessation, goose eggs, and they have no expert testimony on the reasonable diligence to restore it. There's more goose eggs. I don't need 120 days of goose eggs. 1 day of goose eggs is good enough. In June of 2013 and July of 2013, this comes straight out of their Exhibit 2G. Their summary judgment evidence, this is the production history associated with the Schnitz-Rydell well. And again, with the way the production is reported in Shoulders, there was at least 60 days of complete and utter cessation of production, which independently, setting everything else aside, would have caused termination of the term defeasible MPRI had it survived after 1997. They've got no technical qualified expert to say that during that period of goose eggs, an operator's reasonable diligence was being carried out and conducted to restore production. And to the extent that they're trying to rely on Mr. Brandt for anything to say that to the time frame of 2014, there was PPQ. I took Mr. Brandt on voir dire, and it was asked, when you say reasonable period of time, are we talking a stopwatch, a calendar for a reasonable period of time? I don't know. Well, let's just assume we're talking about a calendar. When he wants to talk about, quote, reasonable period of time, how many days on this calendar are you talking about when you answer his question? I don't know. Is it 1 day, 100 days, 365 days, 1,000? I would assume it to be a matter of months. How many? Just depends on the circumstances. Less than 6 months? Probably around 6 months. More or less. Depends on the well. Okay, let's talk concretely on the Schnitz-Rydell. You never analyzed profitability as to that particular well over any period of time, have you? He says, and obviously we have received checks for the production, and that's probably as far as we went, as long as we were receiving monies. So when Mr. Kilday has used evidence over the last 3 days and said, well, Mr. Brandt says it was always producing and paying quantities. This was the intellectual and technical rigor that went into the conclusory, self-serving compound testimony out of Mr. Brandt that's been objected to, is that, well, as long as we're receiving monies, that that would be what it is in no opinion on reasonable period of time. Let's look at the next slide. He was asked, and that's what I'm saying, is that in terms of totaling up every single cost, be it to soak down the well or treating for this H2S and the pipes on it, the depreciation of the equipment, the gun barrel sitting out there, the tank battery, you've never analyzed all of those costs as it concerns that particular well, have you? No. And so in terms of analyzing revenue against all of these different lease operating costs, that's not an exercise you've ever undertaken for this well for any period of time, have you? No. Do you agree? Yes. And if we want to talk about a quote reasonable period of time, if you sat down to undertake this exercise that you've never done, over what period of time would you call a quote reasonable period of time? I don't know. So you can't tell this judge or jury, as Mr. Kilday talks about, quote, reasonable period of time, whether that's 3 months, 6 months, 5 years, can you? No. You agree? Yes. When they want to wave their hand over and say Carbon says this thing was producing and paying quantities, that's the foundation of what they're pointing to. Again, Rule 702, if you're going to talk about reasonable operations or what a reasonably prudent operator would do, you need to be qualified and designated as an expert. They didn't do that as to Mr. Brandt. They don't have a qualified designated expert on these gaping holes in their case. I'm sorry, can I have the slide prior? So this is the testimony that Mr. Kilday puts into his summary judgment record. This is the stuff that's objected to. After you just saw the basis of that witness's knowledge, this is what he comes and tells you as evidence. When he leads and says, regardless of when Carbon stopped paying the term royalties, isn't it true Carbon continued to produce oil and gas out of the Schnitz-Rydell well continuously from 97 until June of 2014? Yes. Well, I just showed you out of his own production records months and months of goose eggs. That was categorically false. This testimony is unqualified and false. Isn't it true Carbon's production during that time was in paying quantities? Again, leading him, and the witness has no foundation for it. Oh yeah, of course it's producing paying quantities. And that production out of that well was sufficient to cover Carbon's operating and marketing costs. Yes. This is what the plaintiffs have brought you and told you as evidence, after we've just seen that the witness utterly lacked any qualification or knowledge about it, period. If you want to rely on Greg Robertson, that's the other PPQ testimony they tried to give you. This is what he says. He relies on Mr. Brandt, which is absurd for all of the reasons we've discussed and you just saw. And in direct violation of Rule 166 AC, he just says, I conclude that based on this evidence and my experience and knowledge in operating marginal wells, it is my opinion that there was production and paying quantities from one or both of the two wells during all time periods from the time Carbon took over the wells up until the time operations ceased on the Schnitz-Rydell number 1. This is not summary judgment evidence. It's not summary judgment proof. Under 166 AC, the court disregards conclusory, contradictory, unqualified remarks like this. And again, this it's compound. And he stops the designation that they have. It stops as of 2014. They said that he's only going to have opinions as of 2014, not times after that. That's the written designation. And in terms of any opinion, if you want to call this an opinion, it stops as of 2014. Does not purport to cover in any way, shape, or form an analysis of PPQ after the time that EOG takes over operatorship. Why else are we entitled to a no evidence on the declaratory judgment? Well, not only do they need production paying quantities that they can't show, and I've already shown the court goose eggs that, I mean, that's a complete cessation. They're done. It's dead, it's done, and they don't have testimony to overcome it. They've got to show the court, because only the 64 designation of unit is valid, or was valid, that the production was out of the upper Edwards Limestone Formation. And we know that that stopped as of 1992, if you could even call it commercial by that point in time. And if we go to the next, again, Bob Brandt confirmed that there was no production out of the Edwards after 92. There was no production to save the plaintiffs, even if you play the production and paying quantities game. The ratification, again, they have asked in their declaratory judgment that they be declared unitized. But now in response, now they say that they ratified by filing the petition. So even under their view of the world, we would be entitled to our no evidence motion for summary judgment being granted as to their claim about unitization for all time periods up until the lawsuit being filed. And they didn't conduct an allocation well analysis or anything like that. They didn't calculate any damages on an allocation formula. All of it's on the unitized basis. They start those damages as of 2014, but they say they weren't unitized until July of 18, according to them. So with respect to that declaratory judgment on the unit, again, we already win because they're barred by limitations, and we've proved that conclusively. But even if you ignore that. And this is the section where they say that they only purported to ratify, i.e. now we're unitized as of July 24, 2018. This comes straight out of their response to the no evidence motion at page 19. They sue for breach of obligation to pay royalty. And so the no evidence challenge said, one, you don't have evidence of a contract. And two, you don't have evidence of damages under a contract. And when they sued us, this is what they said in their breach of contract action. They said other defendants are jointly and severally liable to plaintiffs for such royalties. Plaintiffs therefore seek recovery of any such royalties from the other defendants. And so since they sued all of the defendants, not just EOG, as jointly and severally liable, all of the defendants moved for no evidence motion for summary judgment. Well, now they say, let's see what the response is. Plaintiffs have no breach of contract claim against DDR Gaddy and the other non-operator defendants. So we challenged the element of no contract. They sued us and identified us in the breach of contract section. And now they concede that there's no evidence. And so they've conceded that the non-operator defendants are entitled to judgment at this point in response to that. Let's see what they say as to EOG. And on the joint and several liability, although lawyers filed the pleading, in footnote 11 of their response, they now help us and tell us that their reference to joint and several liability was not intended to be understood as a term of art. Plaintiffs are not seeking damages against the non-operator defendants under the Texas Natural Resources Code or breach of obligation to pay royalties. So even though they sued us for joint and several liability, and us as lawyers know what that is, now they clarify in response to the no evidence challenge and hundreds of thousands of dollars being spent that they didn't really mean it. It wasn't a term of art. We're not being sued for that. The non-operator defendants are entitled to the no evidence motion for summary judgment being granted as to the Texas Natural Resources Code and breach of obligation to pay royalties. Let's talk about EOG. Well, okay, here's the contract. EOG also said, you have no evidence of a contract with us. And here's what they say. Well, here's the contract. It's the term defeasible royalty deeds, exhibits D, E, and F, the 1960 and 1962 instruments. That's the contract they pointed to. Well, at the hearing that we had on January 26th, they told you there wasn't a contract. Mr. Kilday said there's a debt claim. It's not styled as a breach of contract claim, but it's in the way of a debt for unpaid royalties. Because of our term royalty deeds that we are successors to, there's a debt claim against EOG for its legal obligation to pay royalties under those term royalty deeds. Okay, so I don't know if I've never heard of an action on debt. When they sue under Chapter 38 for attorney's fees, under subsection 8, that speaks to an oral or written contract. It doesn't speak to a debt. I don't know how a debt is different than a contract, but they're saying this is a debt claim, not a contract claim. So to the extent we can get our head around that, let's just look at the instruments to see if they've met their element of a contract. Well, here's the Frels deed to the first one to Dan Auld. EOG is not a party to this instrument. EOG didn't sign it. EOG is not a successor to it. This is no proof of a contract as to EOG. At Exhibit 1E, EOG didn't sign this Mortimer instrument. EOG is not a party to it. EOG didn't succeed to it. EOG is not a party to this contract. Exhibit 1F, they point to the Huddle deed. EOG didn't sign this instrument. EOG didn't succeed to an interest under it. There's zero evidence of a contract between any plaintiff on the one hand and and EOG on the other hand, and they've already judicially admitted in response to the no evidence challenge that they don't claim any kind of contract claim or debt claim as against the remainder of the defendants. So we're entitled to judgment as a matter of law in response to the no evidence challenge on that. Again, they sued everyone under Texas Natural Resources Code. This is a head scratcher. They say, said other defendants are jointly and severally liable to plaintiffs for such royalties. This is directly taken out of their petition against us. Plaintiffs therefore seek recovery of any such royalties from the other defendants pursuant to sections 91.402 and 91.404 of the Texas Natural Resources Code. I think under Texas's fair notice pleading standards, when they say that they seek recovery of royalties from the other defendants pursuant to sections 91.402 and 91.404 of the Texas Natural Resources Code, I think we would interpret that as there's been a lawsuit filed. Well, now let's see what they say now that you've caused hundreds of thousands of dollars in expenditure of money suing 13 defendants over something 20 years late. And you've pled this, that we're liable under 91.402 and 91.404. We know evidence it. Again, we've waited 2.5 years to have this day. What do they say in response? DDR's next ground for no evidence summary judgment is again premised on a claim that has not been asserted against DDR Gaddy or any of the other non-operated defendants. Plaintiffs have asserted a claim under Texas Natural Resources Code, Chapter 91.401, only against EOG. Can I have the previous slide? So when they say that the defendants are all jointly and severally liable, and they seek recovery of royalties against the defendants under 91.402 and 404, well, of course, in response to no evidence challenge, we just misread that, and they haven't actually sued us for that. No defendant in this case is a payor. No defendant in this case is jointly and severally liable. There's no basis for that whatsoever. All of the defendants are entitled to judgment as a matter of law in response to the no evidence challenge as to TNRC because we're not payors, and they've conceded that we're not payors. Let's talk about EOG just for a moment. Under 91.404, if they thought they had a prompt pay claim under the statute, here's what they have to do. They have to give the payor, in this case, they've confirmed it definitely isn't the defendants now that we've been put to the burden of this litigation. They say that's only EOG. Well, the payee must give the payor written notice by mail of that failure as a prerequisite to beginning judicial action against the payor for non-payment. That's straight out of the statute. We can all read that. It doesn't, the Texas legislature didn't say an oral notice or a email. What is required is a written notice in the mail. And let's just go back to that for a minute. So we filed a no evidence challenge and said, you haven't even presented the claim. You didn't put anything in writing. You didn't put anything in the mail. And EOG is not, you are not a payee under the Texas Natural Resources Code, period. But even if you were a payee and you're not, you haven't presented your claim the way the statute says you have to. And what did they do in response? The only evidence that they put in the summary judgment papers by way of response is some email correspondence between Mr. McFarland and EOG and Mr. Truss's office, emails. So this is Exhibit 14, subsections A through F. No written presentment, nothing in the mail. It's emails. It doesn't say what plaintiff, even if you want it, let's just say Mr. McFarland printed the emails and put them in the mail to EOG. It doesn't say what particular plaintiff he is purporting to make any presentation on. They solicited through the mails, completely solicited dozens of parties to sign up on a contingency fee basis to sue here. Mr. McFarland told you about that in his earlier remarks. And the majority of folks said, no, this is not a good idea. This is silly. We're not going to do it. He doesn't have the majority of the folks he solicited by mail here. But with respect to if you look at his emails and you pretend that he printed what's behind Exhibit 14 and you put it in the mail to EOG, it is no presentment of claim. It's no presentment of claim as to any particular plaintiff. It does not help him under 91.404. And for all the reasons we've been discussing for the last 3 days, they cannot show themselves to be payees. That's even if they've done it right and made a correct presentment, They have to be a payee, and they're not legally entitled to anything. And the limitations judgment that they take nothing on their declaratory judgment action in this case confirm that. Let's talk about the money had and received action. According to them, they've pled the defendants hold money in the form of royalty payments that in equity and good conscience belong to plaintiffs. Said other defendants are jointly and severally liable to plaintiffs for such royalties. Plaintiffs therefore seek recovery of any such royalty. So again, we know evidenced all of the joint and several liability, and in response to that, they've all agreed, the plaintiffs have agreed now, there's no joint and several liability in the state of Texas in the nature of what they fuss over being, undivided divisible interest. So they've conceded all the joint and several liability needs a take nothing judgment rendered on that. But the idea that the defendants hold money in the form of royalty payments that in equity and good conscience belongs to plaintiffs. Well, with respect to defendant Bressler, he is entirely omitted from Ms. Romanos's expert report. She was asked about that in deposition. You prepared no analysis whatsoever as to defendant Bressler, and she agreed with that. After experts were closed, after reports were long closed, after her deposition, and after defendant Bressler made the decision to designate no expert in this case on royalties because there was no opinion expressed against him on them, they come with a late report trying to make up royalty. They don't even base it off of actual EOG records. But with respect, so defendant Bressler is entitled to judgment for that reason. He's not even mentioned in the report whatsoever. And at the deposition, I asked, you've got no opinion as to defendant Bressler, right? That's right. Okay. So what they try to use is Ms. Romanos's report. And again, hers is entirely premised on unitized decimals, and unitized decimals are absolutely inappropriate to use. And the plaintiffs, according to them, say you should start using those as of July of 18. But so she uses unitized decimals, which are wrong. They're all premised on the non-lawyer Jimmy Starr's title opinion, which is wrong. But they're all lumped together. And so basically, if you look at the report, what it has is that according to the plaintiffs, here's what each of the 26 plaintiffs is entitled to in royalty. And then it says, as to each defendant, this is what, according to the plaintiffs, each defendant is liable for. There is zero analysis as to whether any defendant is entitled to the royalties in its possession. And in the uncontroverted record is that the defendant's title across Frel's tract is not uniform. And it's also uncontroverted that there's ownership of defendants from tracts that have nothing whatsoever to do with Frel's tract that have been placed into EOG units. And so what they try to extrapolate is that we are owed X based on our view of title, and then completely arbitrarily make a pro rata burden of that against defendants. And so what Ms. Romanos was asked was, look, every single defendant here has a due process right. We do not live in communist Russia. We have a due process right to be told, what are we being sued for? And how have you calculated the damages against me? And so it was illustrated in the testimony of, I want to choose a particular defendant in this case. Again, nobody in the case alleging the defendant's title is uniform across Frel's tract. No one disputing that at least some defendants own interests outside of Frel's tract included in EOG units. I'll just ask, tell me, when we talk about money had and received, that there has been a royalty dollar paid to a particular defendant that in equity and good conscience belongs to a particular plaintiff. Tell me about that. They have no evidence of that. The jury charge in this case, if one ever got there and we don't get there, isn't going to say, what do all defendants owe all plaintiffs? That's absurd. Each plaintiff would have to show an entitlement, would have to show that each defendant, I don't know what defendants they claim or allege what, but just take any one of the plaintiffs. You could start with Ben Apperson and say, as to Mr. Apperson, what dollar did defendant DDR Gaddy receive from EOG that you claim is your dollar? That's the relevant inquiry. You can't lump all of the defendants together and just go, well, all of the plaintiffs are owed something by all defendants. It doesn't work that way. That's not how title works. That's not how the proof works. That's not how money had and received works. They literally cannot trace one single royalty dollar as being received by a single defendant that would be owed to one single plaintiff. they have no evidence that would be competent evidence to meet the actual charge to the jury that would eventually issue in the case. And so with respect to if you want to say that a particular dollar that a defendant received is a plaintiff's dollar, step one of that is identifying what do defendants own. You can ask Mr. Kilday, he's going to completely agree that it is not their contention that as to each defendant in this case that they own nothing and that they were entitled to be paid nothing. That's not they absolutely agree that defendants own and defendants are entitled to be paid even under their view of the world. And so then you have to say amongst that defendant group, who owns what percentage and who's entitled to what before you can start tracing dollars and saying that a dollar received by, for example, DDR Gaddy as a defendant would be somehow owed to one particular plaintiff or others. And the problems just continue to compound, as you ignore all of these hurdles they have to come over with the fact that Mortimer and Huddle deeds don't convey road tract just as a pure matter of law from the starting block. And so when they try to lump all defendants together and say all of the defendants owe the plaintiffs X, that just doesn't work. And it especially doesn't work just by pure illustration where two of the three instruments don't even describe road tract. And so in terms of, real competent evidence that a defendant has received a dollar that's owned by a particular plaintiff, they've got none of that. And that's no fault of the defendants. The plaintiffs bear the burden both at the trial level and on appeal, and they just haven't put the proof together because they can't. I want to talk about the attorney's fees. We also know evidence the attorney's fees because this is how they pled attorney's fees. And so with respect to the collective defendant group, they just say everybody's liable for attorney's fees. And so each of the defendants challenged the elements of an attorney's fees claim under Chapter 38, 37, and 91406. And in the response, they say, no, you've got it all wrong. Even though we pled this way, we assert no 38 attorney's fees against the non-EOG defendants. And we assert no attorney's fees under 91406 against the non-EOG defendants. So they've conceded that judgment is ripe and appropriate on no evidence grounds as to the non-EOG defendants under those. As to Chapter 37, the declaratory judgment statute, we know evidenced two aspects of that. One, reasonable and necessary fees, and two, a showing that an award of fees, that they have evidence of the element of equitable and just. And in an attempt to meet the challenge, they provide a declaration from Mr. Kilday. And you can look through the declaration of Mr. Kilday, not once is there any lip service, mention, any evidence in the universe about how on these facts, it is their opinion that an award of fees would meet the element of equitable and just under Chapter 37. And so Mr. Kilday would get an opportunity to come up and respond. I would be very curious to know, where is the summary judgment evidence where they've even tried to meet the element of equitable and just? They don't even mention it, period. And so for that reason, all defendants are entitled to no evidence summary judgment as to fees under Chapter 37 for the reason that after specific challenge, no evidence exists on the equitable and just. With respect to the 91-404, it was challenged that as a precondition to maintain an action and getting your fees, you've got to make a written presentment. And in response to that challenge, EOG is entitled to judgment as a matter of law under 91-402 for the reason that they have provided no evidence of a written presentment. And with respect to Chapter 38, Chapter 38 also mandates that as a precondition to receiving attorney's fees, you must make a presentment of claim. A lawsuit is not a presentment of claim. And the only evidence of an alleged presentment of claim that they make as to EOG under Chapter 38 is, again, the McFarland declaration with the McFarland emails. Chapter 38 is different in that it doesn't require a mailed presentment, but it still requires a presentment. And as you read Mr. McFarland's declaration at Exhibit 14 and his sub-exhibits A through F, there is nothing whatsoever in there that would rise to the level of a presentment of claim against EOG on behalf of any plaintiff. In terms of any ask, that to the extent you could construe anything in there, I think the ask would just be to suspend, not that EOG pay anything. I think if you actually look at the emails and accepted the emails, it would not be to pay them, it would just be to put in suspense. And so with respect to the challenged element of attorney's fees under Chapter 38, presentment was challenged by defendant EOG. And if you read Mr. McFarland's exhibit A through F, make them show them to you, there's no such presentment there. And I got a little ahead of myself. Again, this is the declaratory judgment. As are equitable and just, there's a specific challenge made. You can read the response. You can read Mr. Kilday's affidavit. They don't even wave their hand over it. For that reason, the entirety of the defendant's no evidence motion for summary judgment should be granted. These are freight train sized holes in the plaintiff's cases. They've developed it with their experts. Again, that's not our burden. It's their burden. They didn't do it. They have to suffer the consequences of it. The purpose of the no evidence motion for summary judgment procedure is to avoid waste of court resources, jury time, attorney money, party money. And that's exactly what would be achieved here, because they just can't meet their burden. They've certainly had sufficient time. On the sufficient time, we alleged in the motion that they had enough time for discovery. In responding to that, they do not deny that there was enough time to discover. There's no challenge to that whatsoever. It's 100% ripe. The elements are unsatisfied. This judgment would dovetail with the judgment that's already been issued in the case as to the take nothing based on limitations ground, and would provide additional support to the judgment on the appellate review. Thank you, Your Honor.
All right, who else from the defense wants to speak? Mr. Truss?
No, Your Honor.
Oh, Your Honor,
I'm
Mr. Waymire has covered the arguments that would apply to EOG in the no evidence motion.
Your Honor,
Yes, sir.
Gary Allison, just briefly, we sit at the tail end of this, and I don't want to bring too much in at this point new, but we wanted to at least point out that as GUM's defendants joined in the various motions and in the responses against the plaintiff's motions, we pointed out on the correction warranty deed that the GUMs acquired their interest on in 2009, 12 years after the release, that there was a specific identification of exceptions, reservations, right-of-ways that impacted the 365 acres that the GUMs bought. There is a list on Exhibit B. Not one of the items on that list include the terminated and released oil and gas lease, the units that they were claiming by the plaintiffs, any of the 3 term royalty deeds asserted here, or the term mineral reservation from 1940s from Hancock in the deed to Farrell's. And we point that out for the purpose of showing that this is real world. These property transactions that occurred years after this release do not pick up the release or those expired interests, and that the GUMs were bona fide purchasers when they bought this land without notice of claim and without any identification of there being any party making a claim. And they further in the matter, when in the deeds, they acquired the deed, they took 100% of the mineral interest on the main portion of the Farrell's tract, together with some other lands. It's described in the supplements. And in that aspect, the grantor had reserved a royalty interest of 50% of the royalty, as clarified by the correction deed, which took place in 2013. It went through title, it went through closing, it had mortgages, all these items in the real world handled by real lawyers dealing with the problems. None of them considered any of this, there to be any encumbrance that the plaintiffs are asserting. But I want to point out that under the Dewey rule, that if there were any royalties that were owed related to the mineral interests that the Gums had acquired, that because of the warranty that warranted that we got it all, and there was a reservation of 50%, that only the interest, if there were any part of the 50%, it would be attributed to the reservation, not to the grantee under Dewey. It has not been challenged by the by the plaintiffs at any point, is unresponded to in their responses. We just pointed out to let the court know we're not waiving that claim at all, and we do assert it. We do agree that Gaddy, when they acquired it, were bona fide purchasers, and the multiple real estate transactions of the properties constitute bona fide purchasers to all of them. In any event, just want the court to know it's there, it's briefed, we don't waive it.
Okay, but you're not asking for relief on that right now.
No, the relief that we're asking on is, now all of our claims are they get nothing. We're lockstep with Gaddy, they get nothing. If there was some portion of it left, it would only be coming out of the reserved royalty, not the conveyed royalty.
And I agree with you, that's the law, but do you have a cross claim against Gaddy for that, or?
We have.
No,
we don't have it as a cross claim against Gaddy. It's simply that we're not obligated to pay the plaintiffs any portion. If the plaintiffs were to receive anything and they claim less than 50%, it would come out of the Gaddy interest in the reservation.
All right, who else in the defense?
And Your Honor, just with 15 seconds, I think what he's drawing the distinction on is the difference between fixed NPRIs and floating NPRIs. And so there's no way to pro rata, under the plaintiff's view of the world, say every defendant pro rata bears X, because there would be combinations of fixed royalties and floating royalties. And so this pro rata idea, I think that's just what he's illustrating. And I would just say the reply papers that we filed very comprehensively and in detail that address the absence of evidence and exactly why.
Anyone else on the defense? Who's going to argue for the plaintiffs?
Yes, Your Honor. If it pleases the court, I can proceed.
Go ahead.
Thank you. Let me share screen here. There we go. Okay, first I would like to just thank the court. I know that you've been given a lot of argument, a lot of issues over the last 3 days, as well as a couple of weeks ago, and we appreciate the court's attentiveness to all of this and your thoughtful consideration of these motions. We are responding to 2 no evidence motions for summary judgment at this time, and that would be the DDR Gaddy 6th motion for summary judgment based on no evidence, and the portions of the Cyrus Minerals Sierra Bank Mustang Minerals motion for summary judgment that addresses the no evidence point. And it's important that we focus on what the standard is. First of all, that we're not required to produce a mountain of evidence at this time. We're not required to produce persuasive evidence or decisive evidence. All we are required to do at this time is to produce more than a scintilla of probative evidence to raise a fact issue. So the burden is very low. If we can produce a scintilla of evidence and then just one more, then we are there on each of these elements of each of these claims. So that's our burden, and we've been put to that burden and we're prepared to meet it. Secondly, under the standard for this kind of motion, it's not appropriate for the court to be considering or undertaking, or for the parties to be advocating questions of law. Those are for traditional motions, and we've certainly had an abundance of traditional motions for summary judgment, but that's not what we're doing here on the no evidence point. A lot of the argument was based on various points of law and legal argument that really are for a traditional motion. Some of those arguments were indeed raised in the form of traditional motions, but I just want to be sure that we're aware that in the no evidence motions, which is what we're arguing right now, all we need to do is produce more than a scintilla of evidence, and then we're there. We don't need to prove questions of law or respond to arguments that deal with questions of law. Our burden is simply to produce the probative evidence that would get us across that very low bar of more than a scintilla of evidence. And then at trial, it will certainly be our burden of proof to carry where that burden of proof is ours. But today we're not trying to persuade or win an evidentiary battle. We're simply trying to show that there is at least a scintilla of evidence in order to support a jury finding. And finally, we're not required to marshal our proof. We don't have to put it in order. We don't have to line it up. We don't have to organize it. All we have to do is show that there is somewhere in the record more than a scintilla of evidence. So we've all seen this map. I don't want to go through it in detail at all. These are the tracks and the units and the wells that we've been talking about this week, and we'll be talking about at trial. And we go through their motion. There are two motions, and we go through what points have they said we have no evidence of, and that's what our response focuses on, and that's what my presentation today will focus on. And we stand on our briefing, Your Honor. Our briefing goes through all this in detail and points out the various evidence points that have been challenged by the defendant's no evidence motions. But we'll start with the no evidence point that was raised in both motions, that the plaintiffs have no evidence that they're the owners of proportionate shares of term royalty interests, and that those interests have been held and perpetuated by production. And again, we're not here today to decide who's right, who's wrong on these issues. The question is just, do we have any evidence of that? And we have much more than a scintilla. We have considerable evidence on both points, and we'll go through that real briefly. First, on the ownership. And again, this is usually something that would be uncontested. And I think in substance, it is not being contested. There's no evidence that's been put forward by any expert on the defense side or any other witness on the defense side that says, oh, you know what, Leland Apperson and his estate don't actually own anything, or, you know, any of the other plaintiffs. Nobody's saying that we don't own what we own. They're just saying, show me the proof. And so the proof starts with the term royalty deeds. Those are in the record. We talked about them this week at exhibits 1D, 1E, and 1F. Those are the term royalty deeds that give the plaintiff's predecessors a non-possessory interest, a term royalty interest in the production from the Farrell's tract. And as we've discussed this week, those term royalties are for a term of years, 15 years, which gets you into the mid 70s. And then after that, we continue to own those term royalties for as long thereafter as there's production in paying or commercial quantities. So that's the origin of the plaintiff's claim of a right of ownership. Now, what happened after 1960 and 1962, and how did that go from Dan Auld, Glenn Mortimer, and T.C. Huddle to the current plaintiffs? We've produced substantial evidence on that. First, if you look at Exhibit 5, there are royalty payment records from several of the plaintiffs that have put into evidence division orders and revenue statements and royalty checks showing how this was paid and treated over time. Next, we have the declaration of Jimmy Starr at Exhibit 3. And behind Exhibit 3 are Exhibits 3A and 3B, which are his reports. And Jimmy Starr is a certified professional landman. We'll talk a little bit more about his qualification in a couple of moments. Jimmy Starr has produced that, and it's in the summary judgment record as Exhibits 3, 3A, and 3B. And then, because the defendants challenged whether Jimmy Starr could just, you know, say his opinion as a landman about title and how it has flowed, and with his run sheets and charts showing exactly how the title has changed hands over the years, by volume and page number, with numerous voluminous documents from the real property records. Since there was a challenge that that's not sufficient, Your Honor, we went ahead and put into evidence Exhibit 9. That's not attached to our report because it is truly a voluminous exhibit, and we pre-filed it before our response to the summary judgment motions was filed. Just to get that out of the way, I think the Friday before our response to summary judgment motions was due on February 1. So on January 29th, we filed Exhibit 9, which is a very short declaration from Jimmy Starr authenticating the documents that are described in indexes that he prepared from the real property records of Karnes County. And the indexes identify each document by number. There's a plaintiff set that chases the title down. I want to say 100 some odd documents, maybe a little bit more than that, that chase the title down into the hands of the various plaintiffs who are here bringing this claim. And his index right behind declaration attached at Exhibit 9 gives numbers applicable to each of those documents. And then we included the documents. So they're in the court's record and the court can look at those to the extent the court wants to do that. Jimmy has summarized those voluminous documents in his run sheets and report, which are at Exhibit 3, but the underlying documents are there as well. And then he also has a separate set that he's numbered separately based on the defendant's title. And I want to say that was maybe 293 some odd documents, again, chasing title down to show the various defendants who should be here and who are here and why they're here. So those exhibits 5, 3, and 9 are in the summary judgment record. And then we have at Exhibit 12, a declaration of Jimmy Starr, where he tries to summarize the substance of what's attached at Exhibits 3A and 3B in his reports in the form of a declaration that he signed. And so that's in the court's record as well. I think all this is belts and suspenders, Your Honor. I think any one of these would suffice. But since there's been a lot of nitpicking about the various formats of exhibits, we want to be sure we had that right and in the court's record. And it's there each of those times. Exhibits 12A, 12B, and 12C are the run sheet and flow charts illustrating the derivation of plaintiff's title. Exhibits 12D and 12E are the run sheets and flow charts showing the mineral title and the title history of the defendant side. And then Exhibit 12F is a plat showing the tracks that are identified in the flow charts. All that's in the summary judgment record. It's certainly way more than a scintilla of evidence. It probably meets the higher bar of conclusive evidence, but it's certainly much more than a scintilla. All that's in the court's record. There's a challenge that I'm sure we'll take up and discuss when we get to objections, that somehow Jimmy Starr is not qualified. He's not able to give testimony about the title history, which is what he does for a living and has done for a living for nearly 50 years. Jimmy Starr is a certified professional landman, and he has been so since 1992. To become a certified professional landman, you've got to have at least 10 years of experience. So this is work that he's been doing since at least the early 1980s, and I believe longer. But anyway, he's been a certified professional landman for almost 40 years, almost 30 years, pardon my misspeaking. He's been a certified professional landman since 1992. That's stated in Exhibit 9 in his declaration. He's certified by the American Association of Professional Landmen. Jimmy Starr has an associate degree in applied engineering, petroleum technology. And what he says in his declaration, this is a cut and paste of what he says in Exhibit 9, that he's experienced in all phases of field work, including title examination, lease acquisition, title curative work, preparation of run sheets, calculating working interests, overriding royalty interest and royalty interest, preparation of division orders, seismic permitting, settling surface damages, purchasing right-of-way, and working closely with geologists and seismologists in coordinating oil and gas prospects. So he's got experience in all that. It's what he does for a living and has done for a living for the last several decades. And he's worked as an independent landman on a contract basis and for land services companies and exploration companies. What he has done for the court and for the parties and for ultimately the jury in this case is what Jimmy Starr does for a living and has done and done well for many, many years. Now, there's been a challenge that somehow what Jimmy Starr has done in this case is somehow a felony, that he can't do what he's done, that he's engaging in the unauthorized practice of law. So I want to briefly address this since Mr. Waymeyer's already discussed it in his presentation on the no evidence motions. All of his opinions going back to the 1945 conveyance from the Hancock Company to the Frells is opinions that he's giving that relate to the lease, purchase, sale, transfer of mineral or mining interests in real property over these many years. Each time that title has passed hands from one party to another, there's been a purchase, sale, or transfer of interest. Each time there's been a new lease or an activity affecting a lease, that is opinions he's giving relating to the lease, purchase, sale, or transfer of mineral or mining interests in real property. And that's what specifically is allowed under Texas law. There certainly is a statute on unauthorized practice of law, but it specifically excludes the type of work that Mr. Starr is doing in this case and does on a daily basis and has for many decades. Under section 954.001 of the Texas Occupations Code, it specifically makes clear that when a landman is giving opinions about title that relate to, and it uses those words, relating to the lease, purchase, sale, or transfer of mineral or mining interest in real property. It doesn't say it has to be for a specific purpose of a specific sale or a specific transfer or a specific lease. It says if he's doing this title work relating to lease, purchase, sale, or transfer. And all of his opinions in this case relate to the lease, purchase, sale, or transfer of these interests over the decades. So there's just nothing to this argument that somehow Jimmy Starr is a felon. He'll be relieved to hear that. He was accused of that for some lengthy period of time at his deposition, that he's not engaging in any unauthorized practice of law. He's not a felon. He's not breaking a criminal code in Texas. He's doing what landmen do and what they're authorized to do by the Texas statutes. He's giving the same information in this case to the court that he routinely provides to title attorneys who are providing title opinions. Mr. Waymeyer described Mr. Starr's work as a title opinion, and he made clear in his deposition that's not an accurate characterization. He's giving his opinion. He is summarizing what it appears to him that the deed records say, but the way that he does his work when he's providing title work for someone to prepare a title opinion is he does all the same things he did in this case, gathers those documents, does his run sheets, does his flow charts, gives his analysis, and turns it over to a title lawyer who then gives a title opinion. And here, Your Honor, the expert on title, the law expert, will be Your Honor. It would be presumptuous of us to put a lawyer on the stand to instruct the jury about the law. And we're not purporting to do that. What we're doing is we're providing the court with the information that it needs, the same as a title opinion lawyer would ask Mr. Starr to do in giving a title opinion, which is gathering up these documents, summarizing them, showing the flow charts of how title has changed hands over the years, and showing his read on things about who owns what, so that the court can then properly instruct the jury. And if the defendants believe he's done it wrong, they haven't said so. They haven't designated their own expert. They haven't put forward any testimony saying that the decimal interests he's calculated are wrong. They're simply saying he's the wrong kind of person to give that kind of an analysis. But the court can look at what he's done and instruct the jury that he's done it wrong if the court believes that's the case. Again, no contention of that type is being made. I just want to make clear, Jimmy Starr is perfectly qualified and perfectly authorized by Texas statutory law to do what he's done in this case in providing his opinions. So we have substantial evidence also on that second prong from the earlier slide to show that there's been production to perpetuate the interest, production in paying or commercial quantities. And let's take a look at what that evidence looks like. Well, we start with the production history from the Railroad Commission on these wells, and that shows up in the summary judgment record at Plaintiff's Exhibits 2G and 2L. Those are in the record. It shows the production of MCF for gas and barrels for oil for each month going back decades in time from both the Frells well and from the Schnitz-Rydell well. So that production history is part of the record and certainly is more than a scintilla of evidence about production. Shows the Frells well produced through 1997. It shows that the Schnitz-Rydell well produced through June of 2014. We also have provided.
And is that continuous?
Your Honor, there are certainly a couple of gaps here and there, and there's case law that we've briefed and discussed about a temporary cessation of production. The only period of time that is of any significant length at all is that period of 2010 to 2011, which we also discuss in our brief, and I'm prepared to talk about later in this presentation. But certainly when we looked at the production records at the beginning of this, you could see that standing out about, what happened in 2010, 2011? Is that a gap in production? We need to learn more about what happened there. And what we did learn, and what we have in documents that are in the summary judgment record, is that there were continuous efforts to do a rework on the well during that time that involved a frac. The frac resulted in a leak in the casing, and there was a lot of work that had to be done to repair the well to bring it back online. But throughout that time period where there was no production in 2010 and 2011, Carbon was working on it. And we have his deposition testimony on that, as well as a dozen or so exhibits, maybe fewer than a dozen. I didn't count them, but we'll go through those quickly later in the presentation. So Exhibit 5 shows some payment records at various.
And I'm sorry, I need
Please,
to
Your Honor, go
take
ahead.
this real quick. Okay, one of those days.
Thank you, Your Honor. May I proceed?
Yes, sir. Go ahead.
Okay, thank you. So we've produced some additional evidence in Exhibit 5 showing royalty payment records, division orders, revenue statements, royalty checks at various points in time. It shows that plaintiffs were participating in royalties at various times. And then Exhibits 4 and 10 is exhaustive testimony from Bob Brandt. And I know that Mr. Waymeyer and the defendants like to pick at Mr. Brandt and say he's not qualified, but we're not putting him up as an expert witness in this case. He hasn't been designated as an expert. I don't think he's serving in an expert role. Rule 701 makes clear that lay witnesses can give opinion testimony to the extent that it's within their knowledge and helpful to the trier of fact. And here he was the president of this company that was operating this well. And as he said, certainly was being attentive to whether or not the well was profitable or unprofitable, and has given opinions about that, which are within his purview under Rule 701. Mr. Brandt's testimony at exhibits 4 and 10 confirms that there was production in paying quantities, that there was production that was profitable, that there was production that was sufficient to cover marketing and operating costs at all times on both of these wells, the Farrell's well until 1997, the Schnitz-Rydell well until 2014, until production ceased on both those wells. And for the Farrell's well, that was 97. For the Schnitz-Rydell well, that was June of 2014. We also have
Farrell's well.
Yes, Your Honor.
Is it his testimony that it was still producing in paying quantities, but he just released the lease because he didn't want to bother with the Getty's lawsuit? Or was the cessation of production in commercial quantities something that occurred in 97 and they were sued in 97 and released all in 97?
Good question, Your Honor, and it's the former. Mr. Brandt was very clear in his testimony that he believed it was still operating profitably. He did concede it was marginal, that it wasn't much of a boomer well anymore. It wasn't making a lot of money, but it was making enough to cover operating and marketing costs and return a small profit to Carbon, and that they would have kept it going and it would have continued to earn a profit. But what he said was, once there's a lawsuit, he's going to have to spend tens of thousands of dollars on a lawyer. And he didn't want to do that. And furthermore, he got a significant benefit in the settlement, whereby Mr. Carl Gaddy undertook a duty that Carbon owed to plug and abandon the well. And that would have been about a $40,000 expense Carbon would have needed to incur at some future date and time that he was successful in shifting to Mr. Gaddy by way of settlement. So he avoided tens of thousands of dollars of legal fees. He avoided tens of thousands of dollars in plugging and abandoning costs, and that was worth it to him in order to release the lease. And he said at no time did the Schnitz-Rydell well come up, and so after that it continued to produce and he continued to pay on.
Go ahead, sir.
So Exhibit 10, the next exhibit that I would point to for production to perpetuate the interest, this is the acknowledgement by EOG and Carbon, Deposition Exhibit 28. Attached to Bob Brandt's testimony. This is the document the court has seen in 2013, whereby both Carbon and EOG acknowledged in writing that the Schnitz-Rydell well was still producing and perpetuating the interest in the leases covered, one of which was the Rydell lease. And the Rydell lease is also in the summary judgment record, and the court can look at it. But the Rydell lease was perpetuated by production from the Schnitz-Rydell well. And the Rydell lease required either operations or production in paying quantities throughout this time. So EOG and Carbon have acknowledged the production in paying quantities throughout those years in writing in Deposition Exhibit 28, which is attached behind Plaintiff's Exhibit 10. And then we also have the declaration of Greg Robertson. Mr. Robertson is a very experienced operator. We'll talk a little bit more about him, but Mr. Robertson has analyzed the well history for both the Farrell's well and the Schnitz-Rydell well, and has confirmed his opinion that they were earning a profit at all reasonable periods of time, and that a reasonable operator would continue to operate those wells for purpose of making a profit. And he says that with deep credibility because he's an operator who has operated many, many of these wells similar to these two wells in Karnes County and the surrounding counties. So he can testify much better than a geologist and software programmer can about what a reasonable operator would do, because he is an operator who actually operates these wells. He drills wells like this. He owns wells like this. He operates wells like this.
And I'm familiar with Mr. Robertson. I know everybody has to have their information in the record, but did he do any particular research into what it was costing Carbon to operate these wells? Or did he just look at the production and say, well, you could have made money on that?
Your Honor, the opportunity to do a detailed review on the exact expenses is something that no one is able to do because the documents are not there. There are scant documents in the record about what Carbon's actual expenses were at various periods of time. Mr. Brandt's testimony was that a substantial amount of Carbon's historical records after they stopped operating were destroyed in a flooding event in the Houston area with one of the hurricanes. And so we simply don't have month by month records over many, many years that will show specifically what the expenses were. So the defendants group has taken the approach of using the few documents we have and assuming that those are the expenses for all time. Mr. Robertson instead has taken the approach of using his experience and knowing how these wells changed over the years from being produced at different formations where they were gas during a period of time, they were oil at a period of time in the Edwards, they were oil at a period of time in the Austin Chalk, and he's looked at the records that were produced, but he has done his own analysis of what a reasonable operator would incur for expenses and looked at the production history to come to his opinion that Carbon, just like Mr. Brandt has testified, was indeed making a small profit, at least a small profit at all times on these wells. And, you know, someone can criticize that methodology. That's really going to the weight of his testimony, not to the admissibility of his testimony. Mr. Robertson did what any reasonable prudent operator would do with not only incomplete record history, but scant record history showing what the expenses were at various times to try to determine what would a reasonable operator do. And Mr. Brandt was very clear multiple times in his testimony that it was always covering operating and marketing expenses and returning a small profit. And Mr. Robertson certainly relied on that testimony as well. So I want to discuss some testimony from Mr. Brandt because this has been challenged that we somehow have no evidence. And I'm not going to read to you the entirety of his deposition, but there's several excerpts I want to focus on. The first comes from Exhibit 10. There's Exhibit 10 and Exhibit 4, both contain different excerpts of Mr. Brandt's testimony. Exhibit 10 at pages 52, 53, here's a question and answering. And again, some of these questions have drawn objections. I know the court wants to address those separately. I don't want to mislead the court by removing the objections. I'm just trying to get these on as few slides as possible. I'm not trying to pretend that there weren't objections to some of these questions. And I know the court will take those up separately, but here's just the question and answer portion. Mr. Brandt, as far as you're aware, was the Schnitzriedel well producing and paying quantities in 1983 when Great Western became the operator? He said yes. Was the Schnitzriedel well producing and paying quantities in 1983 at the time when Carbon became the operator? He said yes. So there was a period of just a few months where there was an operator between Shell and Carbon, an entity that Mr. Brandt and his other co-owners in Carbon had an interest in this Great Western company. But so during those two periods, it was, to his knowledge, producing and paying quantities. I asked him, how long did the Schnitzriedel well continue to produce and paying quantities? And he said, until we sold it to EOG. And the records are clear when that occurred. And I said, and that was in 2013 or 2014? He said, correct. This is a separate excerpt in Exhibit 10. This is Brandt's deposition at page 55. I asked him, during the time when Carbon operated those two wells, were they generating sufficient revenue to cover operating and marketing expenses? He answered yes. Were they earning a profit for Carbon? He answered yes. Separate excerpt, Exhibit 10, Brandt deposition at pages 56 to 58. How long did Carbon continue to operate the Frells well, the CW Frells well, on the larger tract? And he said, until we got sued and decided that the production that was coming out of it didn't substantiate going to the expense of a lawsuit. And this is directly in response to the court's question a moment ago. I said, okay, and that was in 1996. He said, I believe that's correct. Question, did the Frells well earn a profit for Carbon during the years when Carbon was the operator until that lawsuit was filed? I think that's a typo, but if I said were, that's on me. Mr. Brandt said yes. And I said, and then how long did Carbon continue to operate the Schnitzriedel well? His answer, until we sold it to EOG. Continuing pages 56 to 58, do you remember when the Schnitzriedel well was plugged and abandoned? He said, I believe it was just last year. This deposition, Your Honor, was taken in August of 2019, and he's correct. 2018 is when that was plugged and abandoned. I asked him, 2018? He said, I believe that's right. Question, and did the Schnitzriedel well continue to operate through late spring of 2014? Answer, I believe that's correct. Did the Schnitz-Riedel well earn a profit for Carbon during the years when Carbon was the operator until May or June of 2014? Answer, yes. Regardless of when Carbon stopped paying the term royalties, isn't it true that Carbon continued to produce oil and gas out of the Schnitz-Riedel well continuously from 1997 until June of 2014? Answer, yes. And isn't it true that Carbon's production during that time was in paying quantities? Answer, yes. And that production out of that well was sufficient to cover Carbon's operating and marketing costs? Answer, yes. And production from the Schnitz-Riedel unit during that time period was sufficient to pay Carbon a profit after covering its operating and marketing costs? Answer, yes. So let's move on to another excerpt. This is again from Exhibit 10, Mr. Brandt's deposition, excerpts at pages 90 to 92. I asked him, was that true during the entire time Carbon operated the Schnitz-Riedel well from 1983 until June of 2014? He answered, yes. Did any of the owners of the Schnitz tract ever complain to Carbon about the fact that they were being paid royalties out of the Schnitz-Riedel well? No. Did any of the owners of the Schnitz tract ever complain to Carbon about the fact that royalties were being paid to others out of the Schnitz-Riedel well? Answer, no. Continuing within pages 90 to 92, my question was, from 1983 until June of 2014, did Carbon always treat the production out of the Schnitz-Riedel well as production for the benefit of the owners of the Schnitz-Riedel unit or the participants in the Schnitz-Riedel unit? He answered, I believe so. And is that how Carbon always reported that production to the Texas Railroad Commission? I believe so. Did anyone ever contact Carbon to disagree with that characterization of the production as being production for the benefit of all the unit participants? Answer, no. And did any of the participants in the Schnitz-Riedel unit ever express disagreement to Carbon about the payments of royalties out of that production from the Schnitz-Riedel well to the Riedels or to the Frels or to the term royalty interest owners? Answer, no. No one ever complained. The next excerpt, we're moving along now. This is page 331. This is still at Exhibit 10, Your Honor. I asked him, was profit important to Carbon in determining whether or not to continue operating a well? He said, yes. Question, did you make it your practice to be aware whether a well over a reasonable period of time was earning a profit or making a loss for Carbon? He said, yes, unsurprisingly. And I said, and was the Schnitz-Riedel well ever making a loss over a reasonable period of time? He answered, no. And before I move on to the next one, Your Honor, Mr. Waymeyer pointed out that, he didn't specify a specific time period for what he thought a reasonable period of time was, but he said that he assumed it would be a period of months and that it would depend on the well and the circumstances, which I think is exactly right, but that was his view. And that's the view that he gave. And he gave those answers that it was never making a loss. It was always making a profit over any reasonable time for those two wells. So this is Exhibit 4, Your Honor, different plaintiff's exhibit in the summary judgment record, but same deposition. Plaintiff's exhibit number 4 at Brandt deposition, pages 361 to 362. I asked him, let's take a look back at Exhibit 61, the pooled unit for the Chalk formation. Are you aware of any challenge that was ever made to the validity of that designation of pooled unit? He said, no. After 1992, was there production from the Austin Chalk formation out of the Schnitz-Riedel well? Answer, yes. And I'll pause there, Your Honor. This is very important. That Exhibit 61, I think it's Exhibit 1F in the court's record, 1H, I'm sorry, in the court's record. The Austin Chalk pooled unit designation, what it designates is a pooled unit for the Austin Chalk formation. And it's been alleged that since it says 10,800 feet, that it didn't count as chalk production. But what it says is it's pooled for the Austin Chalk formation. And Mr. Brandt's deposition testimony.
Mr. Kelly, I'm sorry, I've got an officer here to see me on a warrant. Judge Elston's not available, so I have to look at it.
Go right ahead. Thank you, Your Honor.
Okay, I'm back.
Okay, thank you, Your Honor. So the issue of the Austin Chalk pooled unit designation came up again in Mr. Waymeyer's argument about the no evidence motion, that somehow it's limited to only the depth of 10,800 feet and not a millimeter more or a millimeter less, which we maintain is simply not a reasonable interpretation. It is pooled for a formation. And what I said was not that our expert believes 10,800 is the floor. What I said is that Mr. Robertson believes the floor is somewhere different, and you've seen where he puts the formation, but it was whoever wrote the pooled unit designation in 1982 was giving an estimate of approximate range of where that formation is located or the floor of it. And obviously they didn't get it exactly right, but it's pooled for the Austin Chalk formation. And the reason I'm bringing that up now is because Mr. Brandt has confirmed in his testimony that after 1992, the production was from the Austin Chalk formation, at least the production out of the Schnitz-Rydell well. And so I'll return now to Exhibit 4, Deposition Exhibit 4, Brandt's deposition testimony at pages 361, 362. So again, the question after 1992, was there production out of the Austin Chalk formation, out of the Schnitz-Rydell well? Answer, yes. And royalties were paid on that production? Answer, yes. Did anyone ever complain about receiving those royalties? Answer, no. I asked him, did anyone ever complain about the production that generated those royalties? His answer was no. Did anyone ever complain about the formation of a designation of pooled unit for the Austin Chalk? And his answer was no. Then I said, changing gears, talking back about production and paying quantities, if Carbon had been losing money on this Schnitz-Rydell well over a reasonable period of time, is that something that you would have expected to know about? He answered, yes. Is that something that you would have remembered? He answered, yes. Do you remember that ever happening over a reasonable period of time? And he answered, no. The next piece of evidence I'll point to, Your Honor, is Exhibit 13, which is the declaration of Greg Robertson. His declaration shows he's been a consultant or owner of overriding royalty or working interests in over 600 wells from the late 1970s to the early 1980s. Since 1984, he's been an operator on approximately 200 wells, including in Karnes County. He currently operates 18 leases and 29 active wells, including in Karnes County. And he's won a number of awards that are recited in his declaration. I won't read that to you, but it's in his declaration. He's a very accomplished and highly respected operator in this state. Mr. Waymeyer acknowledged that he was the person who drilled the discovery well for the Eagleford Shale, which won him a number of awards and a lot of acclaim. A very experienced operator.
Mr. Waymeyer is objecting, and I think, I mean, he was one of the first guys to do the horizontal.
I've never admitted or agreed that I said he calls himself the father of the Eagleford. If they actually dug into the evidence, I think what they'd learned was that the place he picked was the wrong place, and they recompleted the STS #1 discovery well over there, the Petrohawk well by the LaSalle-McMullen County line, in a different place than what he picked it at. If we get an opportunity to examine him over it.
Well, that sounds like great fodder for cross-examination at trial, but I'll move on, Your Honor. He's reviewed the records and the production history, the deposition testimony. He's reviewed the Railroad Commission files. He's reviewed the Carbon well file. All the records that were produced by Carbon were looked at by Mr. Robertson, and he gave it the weight that he thought was appropriate based upon his expertise and knowledge. And he's given his opinion, which is probative, admissible evidence that both these wells produced in paying quantities. That is, both wells were profitable. Both wells were generating sufficient revenue to cover marketing and operating costs and produce a profit back to the operator. And also separately, his opinion that a prudent operator would continue to operate both of those wells for profit at the time periods when Carbon was operating them. That's in the record as Exhibit 13, Plaintiff's Exhibit 13. We also have the agreement between Carbon and EOG. This is Deposition Exhibit 28. It's attached to Plaintiff's Exhibit 10, which is excerpts of Mr. Brandt's testimony. We've talked about this document before this week. Deposition Exhibit 28. This is the 2013 agreement between Carbon and EOG, where they both acknowledge that the continued operations on or production from the wellbore, which is the Schnitz-Rydell well, have been perpetuating and will continue to perpetuate the leases beyond the expiration of the primary term provided therein. And EOG then required Carbon to continue operating that well and producing from that well until such time as EOG achieved production from its new wells, and that's what happened. And then Carbon was directed to plug that well, the Schnitz-Riedel well, after and stop operating from it after EOG gave a notice, which is why Carbon stopped operating the well sometime in June. And you'll see in the production history, there's a drop off to just a couple barrels of oil in June. They didn't have the whole month. They just had a portion of that month before they were directed to stop, and they did stop. So EOG and Carbon have both acknowledged that the production from the various leases and from the wellbore, the Schnitz-Riedel well, perpetuated those leases, including the Riedel well, which required operations or production in paying quantities in order to perpetuate the Riedel lease, which is also in the record. So Mr. Waymeyer talked this morning about, or this afternoon, Mr. Waymeyer talked about this time period of 2010 to 2011, and the court inquired about that at the beginning of my presentation. I want to go through that. The records on that are at Exhibit 6 in plaintiff's summary judgment evidence. And looking at Exhibit 6A, this is part of Carbon's files. It's a document indicating that on July 15th of 2010, there was some work beginning on the Schnitz-Riedel unit well, removing the horse head from the pumping unit. That was in July of 2010. You'll see that there's this period of no production from the second half of 2010 through part of the first half of 2011. Exhibit 6B, Your Honor, is an email dated August 25th of 2010, indicating that Carbon was setting up to frack the well on September 7th. Exhibit 6C is another email dated November 11th, where it turned out there was water coming out of the well, more water than was being pumped into the well for the frack. And they didn't know what was going on, but there was a worry in November of 2010 that there could be a casing leak. Exhibit 6D, Your Honor, then is late November, November 29th, 2010. They're still trying to identify the source of the water and isolate it. They still don't know what exactly is going on. So Exhibit 6E is the next one. Exhibit 6E is January 4th, 2011. At this time, it had become clear there was a hole in the casing. This is from an email, internal email from Carbon. Exhibit 6F is a document dated January 29th, 2011, where there were efforts being undertaken to repair the leak, this casing leak that was generating water coming out of the well. Exhibit 6G is dated March 26, 2011, which is a workover report where now they're going to try to plan to pump test the well. Maybe they've got it fixed. Maybe they've got the water leak fixed. Then Exhibit 6H is a handwritten note from Carbon's records from April of 2011, showing that now they're repairing a motor for the pumping unit. That was on April 1, 2011. Exhibit, I think I forgot to put the number on this one. This one's got to be 6I, Your Honor. 6I, it says that they're back to commercial production in August of 2011. So those records show conclusively what was going on in 2010, 2011. That was, as a matter of law, a temporary cessation of production that would not terminate the plaintiff's rights and would not stop the production in paying quantities. It was a temporary cessation while work was being done. And we don't need an expert to prove a temporary cessation. We need facts, and we have those facts, and we can argue to the jury that those facts show a temporary cessation if it's contested at trial. So additional evidence of production beyond 2014. This has been discussed yesterday and today, that Ms. Romanos's reports, not only her declaration, but her reports show that production beyond 2014. It goes through, and she describes this in her declaration, that she goes through exhaustive detail, showing exactly what was produced month by month, defendant by defendant, well by well, exactly what everybody get paid, based upon documents from EOG. And that's the next item I want to talk about, which is Exhibit 11A. These are the production reports from EOG, and they're attached to the summary judgment record. At least the summary sheet is attached to the summary judgment record, showing how much has been suspended, how much has been paid out to each of the various defendants. There is a gap in EOG's records, Your Honor. And this has been pointed out to EOG. EOG has a duty to supplement before trial. I've been in discussions with Mr. Truss since last October about his need to supplement, and he's told me he will before trial to show the
Your Honor,
various production records.
I've got a hearsay objection. This is outside the record. Discovery's closed. They haven't asked for continuance of the hearing. There's zero evidence in the record about Mr. Truss says we're going to do this sometime in the future.
As Your Honor pointed out, there's continuous production from these wells, and of course, there's a duty to supplement. That's in the Texas Rules of Civil Procedure. So Mr. Truss has that duty, whether I say he's acknowledged it or not. That's in the Texas Rules of Civil Procedure. And so there will be, we expect, supplementation showing production since last summer. The last report we have is from maybe September of 2020. So we expect there'll be supplementation, and we pointed out that there are a handful of wells that are missing from what's been provided, as well as Mr. Bressler. But we don't need to guess, we don't need to speculate. Ms. Romanos has gone and independently calculated that. And as part of our supplementation of our discovery responses, on the deadline for supplementing discovery responses, we did provide supplemental data from Ms. Romanos, where she has estimated it based on her calculation of the 8/8 royalty and extrapolating what portion is attributable to Mr. Bressler. And that's in the summary judgment record as well as Exhibit 7C. I just wanted to explain that for the court, why there's a gap, because there's a gap from EOG's records. But Ms. Romanos.
All right, I'll overrule the objection. Go ahead.
Thank you, Your Honor. And then we also rely on, Your Honor, Exhibits 8A, 8B, 8C, 8D, 8E, 8F, which are various discovery responses from the defendants where they were specifically asked what the production was and what they'd been paid. And rather than answering, they point to the EOG record that got produced. They say, we don't need to give that to you because EOG did, and we rely on that. So those discovery responses are in the record, which point to what we filed and attached as Exhibit 11A from EOG. So we provided a substantial mountain of evidence, Your Honor, much more than a scintilla on the next items, which are the defendants hold money and that in equity and good conscience, that money belongs to the plaintiffs. And we would point to the same evidence that we've discussed above and in this presentation, the same evidence about the fact that we own the interest and the fact that there's been production in paying quantities, as well as Ms. Romanos's calculations and EOG's discovery responses about what got paid to whom. All of that would support the two elements on the money had and received claim, that the individual non-operator defendants do indeed hold money because they've been paid money that in good conscience and fairness belongs to the plaintiffs. And we rely on the same evidence that I've already talked about for that.
All right, but do her numbers say exactly how much any particular defendant owes to any particular plaintiff?
Yes, Your Honor. And if you look at Exhibit 7B and 7C, you'll see what was produced, what was paid to the defendants. And she's gone through that calculation and she's got spreadsheets doing that, and her declaration describes that. I expect, Your Honor, what's going to happen at trial of this case, if and when it goes to trial, is we'll be looking for the 4-year look back against EOG, and it will be up to EOG to recover what they are obligated to pay. And the reason for that is that there's a 4-year statute on EOG and a 2-year statute on the non-operator defendants. So I think that'll be an issue to be decided and litigated between EOG and their payees, their other payees in this case, if we're successful in this claim. But Ms. Romanos has given opinions and reports, and those are in the summary judgment record at 7A, 7B, and 7C. Your Honor, next I would just discuss Exhibit 11A, the spreadsheet showing royalties paid to the defendants and suspended out of production from the Frells Tract. We would next point to Exhibit 8, which is the discovery responses from the various defendants, and Exhibit 7, same items I discussed in connection with the other issue, would also apply to the money had and received unjust enrichment claim. And then those two reports from Ms. Romanos are in the record for the court to review. So we've provided considerable evidence, and certainly much more than a scintilla, that EOG had an obligation to pay royalties to the plaintiffs, and that the plaintiffs are entitled to their proportionate share of royalties for production from the Frells Tract, and that EOG owed a duty to pay royalties to the plaintiffs. Those are elements that have been challenged by the defendants that somehow we don't have any evidence to show those elements of our claim. And also that EOG breached that duty causing damages. We've got a mountain of evidence on that discussed already in this presentation, also in our briefing, an obligation, entitlement to be paid, and a duty that was breached. The term royalty deeds, the evidence of plaintiff's ownership shares, we've already talked about that. The 3 royalty deeds to the plaintiff's predecessors, and then Mr. Starr's calculation along with the underlying documentation from the real property records of Karnes County that are in the summary judgment records. The production history, we talked about that already, that perpetuated those interests. And then the leases in the pooled units that are also in the record that have been ratified by filing suit. All that's in the record and is certainly more than a scintilla of evidence. And the recent leases are in the record too under Exhibit 9, and Mr. Starr has enumerated those in his declaration. So evidence of breach and damages, EOG's failure to pay plaintiffs and payment to defendants instead is shown in Exhibits 11A, which is EOG's calculation showing the royalties that have already been paid out and suspended certainly have not been paid to the plaintiffs. Exhibit 8, and then Exhibit 7A, 7B, and 7C from Ms. Romanos. We certainly have a mountain of evidence on breach of that duty and damages to the plaintiffs. Next, Your Honor, we've provided considerable evidence and substantially more than a scintilla of evidence that EOG is a payor under the Texas Natural Resources Code, and that plaintiffs are payees who are persons legally entitled to be paid from the proceeds derived from the sale of oil and gas. Those are definitions from the code. And we've got substantial evidence on that. Same evidence we talked about, that plaintiffs own these term royalty interests, that there's been production and paying quantities to perpetuate them, and then EOG's records showing exactly what the payment history on the royalties has been to the various defendants, and then held in suspense, but not paid at this time to the plaintiffs. And Ms. Romanos's reports as well. So we've got these term royalty deeds, the evidence showing the plaintiff's ownership shares, the production history, the leases in the pooled units, all those have been ratified by filing suit, and all that's in the record. Your Honor, next we provided considerable evidence and substantially more than a scintilla that plaintiffs are entitled to participate in royalties from a unit that includes a portion of the Frells Tract. That's been challenged. Our entitlement to participate in royalties from a pooled unit, this is really a point of law that we've already litigated ad nauseum this week that we believe is not proper for a no evidence motion for summary judgment. That comes from the Frank versus Rhodes case, 310 Southwest 3rd, 615 out of Corpus Christi, that points of law about whether or not a pooling in the Austin Chalk would perpetuate interest. That's not a no evidence point. That's a traditional motion, and it's a traditional motion that's been made here. I'm not saying it hasn't been made. I'm just saying that's not something that warrants a response on a no evidence point, but we've given a response and we've shown our position on that and the evidence supporting our position on that.
Let me ask you, I pulled up your exhibits 7A, B, and C, and could you find those?
Yes, Your Honor. You want me to take this screen share off and find those?
You can put them up, pull them up or not. I just want to ask you if you can show me where in there's a number from her that says a particular plaintiff is owed a particular amount from any particular defendant.
Well, she shows the particular amounts that are owed by each defendant and the particular amounts that are owed to each plaintiff. And that's what I was saying, Your Honor. And that's in, if you look at Exhibit 7C, it describes that and it shows that in some detail. And it's also incorporated into our declaration, but I would look at Exhibit 7C. And I can try to find that. It might take me just a moment. Trying to find the document, Your Honor.
It's page 379 of 700 on my copy of your response.
Right. Yes, Your Honor, I've got it. If you look at page 7 of Exhibit 7C, And if you'd like, I can share screen, but it sounds like you're looking at it right now.
Okay.
Do you want me to share screen? I tried to.
No,
I've got
you
okay.
can. I've got it.
Okay. Here we go. I think this is it. There we go. So at page 7, we've got the total amounts that are owed to each plaintiff by plaintiff, as of the production date for the records that have been produced to date by EOG. And then if you look at page 8, there's the amount that is attributable to each defendant, the amount that was paid to each defendant that should have been paid to the plaintiffs. So all that's calculated, all that's shown, all that's totaled in Ms. Romanos's report.
All right. And where does it show how she determined what percentage of any well that your clients were entitled to?
Your Honor, it's attached to the native Excel spreadsheets, which are included with a report that have been provided to the defendants. We didn't burden the summary judgment record with the details, but we showed this summary form with all of her opinions and declarations that are included in the summary judgment record. But the Excel spreadsheets are very voluminous, and so she describes them in summary form as the rules allow.
Okay. Go ahead, sir.
Okay, thank you.
Your Honor, here's one objection that's not in my written objections. I did not understand him to be saying that this report was a Rule 1009 summary that compliant with Texas Rule of Evidence 1009. So I guess I would ask that in light of this new claim that we be allowed leave to add a Rule 1009 objection that this doesn't satisfy the predicate for a summary of voluminous material.
All right. I'll let you bring that up in your discussion on objections, because I don't believe we're going to get to those today. I said I need to leave at 5.
And Your Honor, I'm almost finished. I think I've got 4 more slides and then I'll be done. I'm just going through point by point the items actually raised in the no evidence motion. I'm not endeavoring to address new issues that I believe are points of law discussed in Mr. Waymeyer's presentation today. This is just responding to the no evidence motion. And so we believe that the evidence we've produced and put into the record shows entitlement to participate in royalties from pooled units. This is a point of law and the Franks versus Rhodes case that we cite, but all of these issues are fully addressed in the traditional motions, plaintiff's second motion for summary judgment, and in our response to the defendant's second motion for summary judgment. But just to be sure that we don't miss the opportunity to talk about it, production from a pooled unit will keep a term royalty or term mineral interest alive, regardless of whether the well in the pooled unit is located on the land subject to the term royalty. Mr. McFarland has addressed this in our discussion of those motions, traditional motions, Bradley versus Finley, and Pena versus Coates, and Williamson versus Federal Land Bank of Houston. These are all in our briefing on the traditional motions for summary judgment. The plaintiffs have provided considerable evidence and substantially more than a scintilla on the issue of attorney's fees, which I heard Mr. Waymeyer talk about, and segregated by claim and by defendant group. If you look at Exhibit 16, Plaintiff's Exhibit 16, which is it's actually declaration. This says affidavit, but it's a declaration. And I've estimated 50% or more of the work on this time after my review of the records was on prosecution of these claims for the money, looking back 4 years versus EOG for unpaid royalties. That's where the majority, or at least half of our time, has been devoted to that claim, and about 30% on the claims for declaratory judgment to establish plaintiff's royalty ownership. And then 20% or less of our time on this case has been devoted to the money had and received unjust enrichment claim, for the very reason I articulated. It's just not as substantial a claim because it's only a 2-year look back. Our focus has been on the money side with EOG and the declaratory judgment claim for the future interest. Mr. Waymeyer says there's no expert testimony on what's equitable and just. Well, the statute makes clear, Your Honor, that's something for the court to decide. This comes up only in connection with the declaratory judgment claims. And in section 37.009, the statute makes clear that it's as the court deems equitable and just. It's not what I think. It's not what Mr. Waymeyer thinks. We can argue that, and I'm sure we will. We'll both make arguments about it, but that's all it is argument. the equities and the justness of an award of an attorney's fees that are related to the declaratory judgment claim, that'll be a judgment that the court will need to make. And we'll preserve our arguments on that for the appropriate time. But that's not a subject of expert testimony. That's a subject of argument and a subject that's in the purview of the court as made clear by the statute. Not a subject of expert testimony at all. And then there's been an argument made about presentment. Exhibit 14 is John McFarland's affidavit showing presentment of these claims to EOG as required. The claims have also been presented in pleadings in this case, dating back to August or July of 2018. And the remedy, if any defendant wanted to insist upon presentment, is to seek an abatement of this case for that presentment to occur. And that's been waived. And the court's familiar with the cases on that in many, many different contexts. And so just in conclusion, Your Honor, we have produced substantial evidence of all of our claims, much more than a scintilla of evidence on all of our claims. And the defendant's no evidence motion must be and should be denied. And that goes to defendant DDR Gaddy's 6th motion, as well as Sierra Banks' motion at pages 18 through 20. Thank you, Your Honor.
Your Honor, may I be heard in brief reply?
Yes, sir.
With respect to the allegation that Ms. Romanos has ever made a determination of what any particular defendant owes to a particular plaintiff, if there's any suggestion that she has done that, and that it's just in a paper, not before the court, that is categorically false, and Mr. Kilday knows it's false. Because the sworn deposition testimony that supports the motion to strike Ms. Romanos, that exact question and answer sequence went on for 2 pages, and she's confirmed unequivocally she never performed that analysis. So I don't want the court to be misled that Mr. Kilday, in response to this court's direct question about that, he says, well, look at 7C. And the court looks at 7C, and it doesn't say that at all. And if there's a suggestion here that there's some paper that he just hasn't brought you that does that, that is categorically false. And the sworn testimony for Ms. Romanos says that's false. With respect to he told you that the base of the Austin Chalk was 10,800 feet. He told you that. And now he tells you it's not there, that it's 200 feet somewhere else. Other than Mr. Kilday wanting it to be there and just telling you it is there, there's, again, where did he get that to inform the court earlier this week that at 10-8 you find the base of the Austin Chalk? It's just made up because it suits his case. With respect to the title opinion aspect, in Mr. Starr's deposition, he was asked, what is the difference between your title opinion here and a title opinion such that one of the members of my law firm would issue? He swore the only difference between the title opinion that the lawyers at my law firm charge for and the title opinion that he charged for was that a lawyer prepares him over here who has a law license and that has goes to CLE and has satisfied the ethical standards of the State Bar of Texas. And he's not a lawyer. That is the only difference between what he did and what a lawyer at my firm does that he charged. We went through and tracked every single element of the unauthorized practice of law, and he provided testimony that clearly satisfied every element of the unauthorized practice of law. We tracked every single element of the landman exception, and he agreed factually that he did not meet any element of the landman exemption to the practice of law. This is all on the sworn record, and Mr. Kilday's protestations now to the contrary are absolutely false, and this is already in the can in terms of sworn to and can't be weaseled out of. With respect to the production history in the records, Mr. Kilday cannot show you one single MCF of gas produced after 2015, in 2015 or after. Ask him to put it up from his summary judgment evidence, one single MCF of gas, one single barrel of oil that has moved off of Frell's track or a land pooled with Frell's track. He can't show it to you because it's not in the record. With respect to Mr. Brandt's testimony, he tells you now it's not expert. Yesterday, he is on the record clearly as saying that production and paying quantities analysis is an expert issue. He says, well, Mr. Brandt's just testifying as a lay witness. What Rule 701 subsection C says, if you look at 701 subsection C being the lay witness rule of evidence, it says that there is no opinion permitted of a lay witness that is scientific or technical, which again, so the idea that Mr. Brandt's testimony is just a testimony under 701, apparently Mr. Kilday doesn't look or want the court to look at 701C, which says that that does not permit technical testimony. Additionally, with respect to the idea of the operations, I've shown the court 4 entire months of goose eggs. Under the law, it would be his obligation to come in and explain not just that some operations were performed, but that the operations were conducted reasonably and diligently. That is an expert issue. I can't look at an invoice that says took the horse head off of the pump and qualify as an expert to tell you that those operations were reasonable or diligent. There's been never a case in the entire published history of Texas jurisprudence that said that a lay witness could come in and supply reasonably prudent operator, reasonable diligence of operation standards. The case I always like to tell clients about when you build a plaintiff's case is the one, there's the published case where they come up to the well site and all the cows are laying dead. There's a whole field of cows laying dead around this oil sheen water. And they get through the case in chief, and the Court of Appeals takes it away because they didn't do an analysis of the actual cow material to draw the link, the expert link between oil sheen water and a whole field of dead cows around it, and saying that the oil water is what caused it. So that, I mean, that's just an illustration of the 702 technical expertise and how what he's trying to do now, waving his hand over 701C, doesn't work with Mr. Brandt's testimony. I would also point out that in addition to him having no testimony in this evidentiary record to close the 120-day gap, he didn't even mention the 2013 utter gap in production that I pointed to. And so he can't even bring you an invoice as to that. And certainly no expert testimony. And I don't have to show 120 days. I don't have to show 60 days. If there's 1 day of goose egg, an oil and gas lease is dead. That is a cessation of production, an utter termination of production. And it becomes incumbent then on to show the reason for the cessation and that there were reasonably prudent operations conducted with reasonable diligence to come in and restore production. He doesn't even point to invoices, let alone expert testimony, to close that gap in 2013. And again, I've been speaking at the gaping hole of a lack of production and paying quantities analysis or opinion from 2014 forward, and lo and behold, there is none of that. He tries to play the sleight of hand by pointing the court to, well, there's production records. There's not even any production records. Again, I would like Mr. Kilday to show the court where there's a record in this summary judgment closed proceeding of 1 MCF of gas produced or 1 barrel of oil produced and sold after the year 2014. I've combed through every single page of this thing and it's not there. And he certainly doesn't have any kind of qualified expert testimony to say that during that period of time, revenue exceeded expenses. The court asked him a direct question about whether Mr. Robertson analyzed costs. And the truth there is that Mr. Robertson provided no opinion about costs. What he just said was, I know how to operate cheap wells. I looked at the revenue. This is profitable. The only deduction he made out of that was for severance taxes and for the royalty burden. By that analysis, every single well in the history of time would be profitable because all you're taking is a revenue number and knocking it down by a percentage of severance tax and a percentage of royalty burden. And so in response to that, you also asked Mr. Kilday about the cost, and he told you, well, there's no evidence of cost. I'd like to screen share and show the piles of costs that were available, but that Mr. Robertson just didn't know was there and didn't look at. Again, the court asked directly on cost. Like, if we zoom in, we can see, for example, every single month, here we go. Let's see if we can rotate this. There we go. So back in 97, a pumper every single month would cost $100. Let's scroll down to the more recent time frame. There's electricity, there's telephone, there's the pumper eventually goes to $500 a month. There's all sorts of expenses, treating, we can go on and on here. Labor pumper, here's the pumper alone is $500 a month. A gauger, going on. There's lubrication for the horsehead pump jack. You can take that down. What came about in the deposition of Mr. Robertson was that the expert didn't even analyze the correct well. What he said is you would have no cost for this well because it would just be a flowing gas well and that he's operated a bunch of Edwards gas wells. Well, as has been beat to death, the Edwards gas production, this stopped being an Edwards gas well in 1992. It became a horsehead pump jack, saltwater making oil well after 92. So when Mr. Robertson just declares, well, you don't have any cost because this is just a flowing gas well, there's no methodology, there's no analysis, but to the extent this happens in his head, it's ditchy, and it was for the wrong kind of well. At his deposition, he learned for the first time that there was a very expensive saltwater disposal well. He learned for the first time there was an expensive pumper. He learned for the first time that there was an expensive pump jack. He learned for the first time that expensive pump jack took electricity. And so when Your Honor asked, did he analyze costs? The answer is he didn't analyze cost. The only cost that came about in his initial report was knocking down a small percentage for the landowner royalty and for ad valorem taxes, no expenses cost whatsoever. He learned about those in his deposition and he was the expert. And then just the last point on the.
All right, and Mr. Weimer, I'm sorry, but it's been.
Thank you, Your Honor.
Well over 4 hours since we got started. We did not get to the objections. Do you all want to try and set that tomorrow? When do you want to try and set those?
Tomorrow pleases us, Your Honor. And I think based on the initial hearing, we had blocked off tomorrow for that.
Okay, what time?
Anytime pleases. Your Honor didn't set a specific time. It was just a whole, a time announcement. I think an hour and a half.
Okay, let's do that at 10 a.m. No, tomorrow's Thursday?
Yes, Your Honor.
Yes.
Okay, I'm thinking backwards here. Okay. Friday is the day I have to be at the house. Well, I have regular dockets tomorrow, so do you want to just check in at 9 and see what the announcements are? And I'm going to set it for 1:30 and hope we're done, or?
I think 1:30 is, at least, I don't want to speak for everybody else, at least for my office. This is the most important thing we have going, and 1:30 is fine.
I think we have the Peeler case.
Do we have Peeler tomorrow?
Yes.
All right.
Your Honor, I had a conflicting setting for tomorrow, but I've moved it because I got the court docket announcements on Friday where we got invitations to all 4 days. I've moved my conflicting hearing, so I'm available tomorrow. Happy to check in at 9 and be heard when it pleases the court. I do want to point out Exhibit 15 shows production from the Lynch unit, and we've got that in the summary judgment record as well. But I'm happy to meet and have our hearing tomorrow at whatever time pleases the court.
That is only 2014.
All right.
Judge,
Yes.
Bart Bear put a proposed order in chat. I'm not sure if you were able to pull it up. I tried to open it
And I
and save
sent it
it.
back to him about 2 minutes later.
Okay, good deal. And then one other thing, you do have a setting on the Friday. You just said something about,
Well, that's why I was going to say 10 so that we could get that finished.
okay, gotcha. Okay.
All right, so I'll see you all in the morning. And I think I set the stuff for this week, so that's on me, but just, Ms. Riley, remind me if we ever have a big oil and gas case, let's not double set it with the peelers.
Certainly.
Okay, we've been doing this not quite as much every week, but for a long time with the peeler case. Okay, I just posted to everyone a few moments ago something that says side-by-side causes and answers. That was just something when I was working on a jury charge a couple of years ago. What I'm asking is, whenever we get this wrapped up, I just, a little thing, I did this on, I don't know if I did it in Excel, I think I did it in Microsoft Word. Just says the points where each side is moving for summary judgment and the just a nutshell response. You see, I'm not asking you to rebrief anything, just a point, we're moving on summary judgment, no evidence on discovery rule. The plaintiffs say, just to make sure that I remember all the points we're looking at and make sure that I have some sort of ruling on all the points.
Your Honor, it's not an argument, just a bullet point of what's an issue.
Just a bullet point of what's at issue. Okay. And that was just a working document that I prepared for myself when I was working on the charge. All right, then I've got to pick my son up. I will see you all in the morning.
Thank you, Your Honor.
All right. And has someone downloaded that side-by-side causes of action?
I've downloaded it, Your Honor.
Okay. All right, if you'll make that available, I'm going to take off. I'll see y'all soon.
Does someone on the defense side have that as well?
We do. Thank you, Doug.
Okay, thank you. I'll see y'all tomorrow. Take care.
Bye, Lachey. See you tomorrow.